Morning, people. How's everybody doing? Morning, morning, morning. Y'all know I woke up this morning and as I started thinking about what happened yesterday, one thing really sticks out to me. I mean, there's a lot that sticks out to me. But one thing that sticks out to me is I feel bad for Hylton, y'all. I really do. I feel bad for Hylton. Now, don't get me wrong. I know there are defendants on trial. I know there's families of the victims. I know that they're living victims. So I am not minimizing those people. I'm just not focusing on them right now. Okay. So don't come at me because people they come at you when you don't say what they want you to say. I'm talking about Hylton right now. Because Hylton yesterday, she really tried, y'all. Hylton started off slow. She didn't start off with a lot of emotion, in my opinion. And by the end, she was very emotional. She was giving it all she had. I know y'all don't have any sympathy for Hylton. I get it. But let me express myself. Let me express my thoughts. Because the no sympathy for Hylton, that thought, that opinion, that point of view is well expressed. And this is not, I'm not saying sympathy. I don't want to use the word sympathy. I don't want to use the word sympathy because Hylton is a voluntary, willing participant in all of this. This is a job for her. And the victims, the defendants, you could make the argument that they're not voluntarily involved. So I'm not saying I feel sympathy for her it's certainly nothing compared to the involuntary participants in this. So I'm not really saying sympathy. When I say feel bad for her, I mean, you see somebody trying and really trying to do something and it just doesn't seem to be working. The lady was really trying, y'all. She was really trying yesterday. And I know what she's trying to do is put people in prison. So that's the part where y'all probably don't feel sympathy for her or don't feel bad for her. I get that. But that's not really but if we can just parse it out and focus for a second on I think history will judge Hylton and Love differently. I really do. I think history will judge Hylton and Love differently. Hylton will probably go on to have a somewhat, maybe I'm not even going to say somewhat. She'll probably go on to have a good reputation. And Love will probably not. Sadie says she had no compassion, was mostly words. But that's not, her job is not to have compassion for the defendants, y'all. Her job is to try to get a conviction. Okay? So that's her job. So we shouldn't expect her to say, I feel bad for these guys who are accused. We shouldn't expect her to say that unless she thinks that's going to help her get a conviction. But the reason I say I feel bad for her is because she was up there really emotional. You could tell she was trying. And I think I was somewhat swayed. I was swayed as well by a post that I read afterwards that she embraced the families of the victims and she was crying. I think that also affected me. But as I'm watching her, I'm like, man, this lady, she's really giving it all she has. But it wasn't clicking. It wasn't clicking. Yeah, Kelly, exactly. So she was emotional, and I don't say that in a bad way. I do think you want to bring the emotion, but she couldn't get it in from. So we're watching from home too. So maybe the jury felt something different from what we felt. But she couldn't, for us anyway. And again, the jury's there, so maybe they got it. Maybe she connected with them. So that's also a possibility. But she just couldn't seem to make it. She, when I did a video, I just edited a video, and when you watch the video, like, because I'm scrolling and whatnot, and she was all over the place. She was moving, she was very animated, and it was just like, man, this lady is, and you know what? It kind of goes back to what Max said. It did look foolish, Kari, particularly when you are editing it and you can see all the movements. But that's kind of why I feel bad for her, because it kind of goes back to what Max said, y'all. Max said trying to put a round peg in a square hole. And it's so interesting because Max set the tone with that comment, and that is exactly what it looked like Hylton was trying to do. It looks like she was just trying to force that round peg into the square hole. And it's almost like watching somebody and you just want to say, stop. Y'all ever seen that Michael Jordan, Just Stop? Let me see if I can find that. Y'all ever seen the Michael Jordan, Just Stop? There's like a Michael Jordan, Just Stop. Have y'all ever seen this? Get some help.
I'm Michael Jordan. McDonald's restaurants have given me this time to talk to you about something we both really care about. Kids. Kids are the reason McDonald's sponsors.
Nah, let me just play that.
Stop it. Get some help.
Yeah, that's kind of the feeling I had yesterday. It was like, stop it. It's like, stop it. The way you're doing it, I get what you're trying to do. And you are trying to do the thing you're supposed to be trying to do. But I felt bad for her. I feel bad for her because I feel like the biggest thing is she came across as ghetto, ratchet, unprofessional, uneducated, not uneducated, but her presentation had hints of like, people make fun of the way she talks. They say acts, and you heard her saying, like they instead of there or whatever, I don't know if that's the exact, but it's just, As a Black woman, it won't age well. Dirtiest case in history, and it was Black on Black mental violence. Yeah, y'all. So, she turned into a whole different person. But let's put it like this. Wouldn't you have liked to see Hylton do a very good job? Wouldn't that have been better? That's really the point. Wouldn't it have been better for everybody if Hylton, I guess if you want people to go home, you want the defendants to go home, you're like, well, I'll take it, because she didn't do a good job. You know what I'm saying? She was slipping in and out. Yeah, she wasn't just slipping. She was tripping, y'all. She was tripping. Y'all want to know what's really tripping me out is that at some point the video went off, right? Y'all remember yesterday, like we were like, is that it? And when the video came back, Hylton was like in full-on trip mode. She was like on full-on trip mode. I'm gonna play a little bit of it real quick, y'all, since we have some time. Like, the video went out for about 5 minutes, I don't know, 10 minutes, whatever it was, maybe 5 to 10. And when she came back in, she was cursing and just literally on a full-out crash out. And people called it a crash out. It was kind of like a crash out, honestly. I'm about to play this for y'all. So you can see. That was 11 hours yesterday. That's crazy. All right, check this out. All right, so I'm going to show y'all Where did the video go off? The video went out. Okay. So here, before the video goes out, who is this? Let me see something. So the video goes out somewhere around here. So here's where the video was off, right? We had all of this. And then when she comes back, she's playing. So when she comes back, she's playing this audio that she can't get to work, or that you can't really hear maybe. And then we're going to hear how she tells you what it says.
And I know this is kind of faint, but I'm going to tell you what he says in this call. Let me give you a little background about this call. This is November 19, 2015. This is after his preliminary hearing. Y'all heard about the preliminary.
This is where she starts tripping.
And you heard them talk about the fact that a couple things, that they didn't talk about witnesses by name. They said about witness number 1 and witness number 2. This is what he says.
Okay. So she's about to start. Like, this is where, for me,
fuck them niggas, bro.
Where the full-on trip out starts. This is where she, like, the full-on, like, crash out starts at this point, in my opinion. Morning Air Hall. Yeah, do hit the like, y'all. I don't like beg enough on these streams. I like beg on my videos a lot. But on the streams, my like begging game is not very good. So anyway, y'all, let me go ahead and play this crash. So I feel like this is where the true crash out part starts.
All that fake friend shit. Fuck nigga. He know what's going on. Pussy ass nigga. That's what he said. Fuck niggas are rats. He ain't say he lied on me. He said he a rat. I just went to court and they let everything out. That fuck nigga a rat. Him, Woody, and the other little D. Bitch, you in love with a rat hoe. That's anger. Why? Because you just heard that your friends, because you didn't really know it was them, but it said witness 1 and witness 2, you were able to infer that your friends told the police about what you did the night of Donovan Thomas's murder.
Morning, thank you.
These are his words.
Hit the like, y'all.
He didn't say, yo, them dudes, I went to my prelim and they lied on me. He didn't say, oh man, they I don't know where they got this information from. He said they are rat. Because what do rats do? They tell. And he was angry that his voice would tell what he did. Let's talk about they songs.
Well, okay, so that is what I was talking about earlier when somebody said code switching. Y'all know it's let's talk about their songs, right? The word is THEIR, right? It's not THERE, by the way, people. It's THEIR. And she was saying they. Now, obviously she knows the difference. These are little things. So this is nitpicky. This is, maybe unfair. Maybe she doesn't deserve me to be, criticizing this. So I'm, nitpick alert. I'm going to give an alert for the nitpickiness. But when you say they instead of their a lot, is it a purposeful decision, or did she just fully flip out and just literally now she's in like a whole nother mode? Let's talk about they songs, not their songs, they songs. I'm gonna play that little bit again.
1 and witness 2, you were able to infer that your friends told the police about what you did the night of Donovan Thomas's murder. These are his words. didn't say, yo, them dudes, I went to my prelim and they lied on me. He didn't say, oh man, they I don't know where they got this information from. He said they are rats.
Listen to her talk about the song.
Because what do rats do? They tell. And he was angry that his voice would tell what he did. Let's talk about they songs.
Let's talk about they songs. Joe Rivens, thanks for the super. Max and Doug handled their case in a pile of shredded posts, and unbothered personality failed to bail her out. So yeah, Max and Doug, that's been a situation this whole case though. If Brian Steele had gone up there, he would have done a great job. If we didn't get to see Bruce Harvey's closing, imagine if all of those lawyers were still on the case. First of all, we wouldn't be in closing yet. We would have had another 2 months for sure, 2 to 3. The closing arguments would have lasted what, 2-3 days? Because you would have had to give Harvey his say, you would have had to give Brian Steele his say, and you would have had to have given Matthews his say. All of them would have gotten 2 hours. If they took their 2 hours, then that would have been another 6 hours. That's practically a whole day. Brian Steele would have definitely taken his 2. So, yeah, if some people said, oh, you know, Thug didn't know that this trial was only going to last 3 more weeks. It wasn't going to last 3 more weeks only if Thug was still in the trial. This trial would not be ending right now if Thug were still in the trial. This trial would still be going. It wouldn't be wrapping up. So, you know. Do I think Max and Doug, how do I think they did compared to the state? I just said it. So I think Max brought the emotion that she was trying to bring, Max brought. Doug is always good to bring a little bit of levity, a little bit of humor, a little bit of lightheartedness in his own unique way. I think they both did an excellent job. But again, I'm not there. So we're watching from home, y'all. We are watching from home. And it's difficult to really know how the jury feels, you know? All right, y'all, I got to skip these songs. I'm sorry.
And then I could send the whole gang to the heavenly house? You good with killing folk. That's why you didn't kill Donovan, you didn't kill Shamel.
I can't play these songs.
I ain't gonna play the song. Let's just talk about the words.
Okay.
Dodging all your shots, and I'm watching my eyes. Let that bitch rain out the top of the drop. Here we go again. Lizard walk your block, let that glizzy rock. Oh, glizzy, ain't got a Glock? Hey, one Shamel killed with a Glock? One there, Glock on that table? Well, what investigator Viverito said it looked like a Glock. And I found it interesting because we're gonna get to Shamel soon. We about to get to Shamel.
One juror already spoke out. Who? You mean juror 50?
He said that Shannon wasn't linked to the Ford, but he linked to having guns thrown away. That's what he did in 2015. He's linked to the gun that was probably in the house an hour.
So she started off black, pretty black girl 79. She started off more subdued, and she at some point the switch flipped and she just started going. You know what I'm saying?
Before he killed Shamel, sitting on a table in front of him. We ain't gonna play this one either, but let's talk about what he's saying.
Chris, so her minimizing drinks and Donovan Thomas, whatever type of gang or whatever they did wrong in their life, you know. I get it. I think it's a legitimate strategy. You know, they were not killed in a shootout or something where they, you know, this is not a self-defense thing. You know what I'm saying? In other words, they weren't shooting at the people who shot them, whoever those people were. So I think it's legit. I think, you know, she's trying to get a conviction, y'all. I mean, we got to give her some kind of leeway on, spinning the facts into the light most favorable for her. Her job is to get a conviction. So, she's not going to get up there and say, that these guys were terrible people and deserve to go. And I'm not saying that that's the case, but even if it were the case, she's not going to say that. She's going to give them a good light, and their families were there. That's another thing. So, it's respectful to speak of them in respectful terms when their moms are there, when their dads are there, when their aunts or whomever the families are that showed up. So, we got to understand that her job is to get a conviction. And also the families are there, right? So I'm not upset about that, the downplaying of whatever type of gang ties these guys had, because frankly, again, if it had been a shootout, if those guys had been robbing somebody and they got killed, if it had been self-defense or something, that would be one thing. But it wasn't self-defense. Both of these guys were killed. However, whoever did the killing, both of these guys were killed unsuspecting to themselves, and they were not in that moment engaged in any kind of criminal activity that we know of. So this is what I was saying, Ron. I wasn't saying this exactly, but this is why I said I felt bad for her, because she was trying to put that round peg into that square hole, and it just wasn't going in. What do I think about the R. Kelly lyrics used? I wish I had DNA. I didn't get that. I heard it, I think, but I didn't get the reference. What song is that from? I wish I had. That's an R. Kelly lyric? I guess I didn't get that one. Yeah, so Drinks at the moment was not, that we know of anyway, he wasn't shooting at whoever shot him, as far as we can tell. He was just out getting some, I think they say he's getting some food or whatever, some gas, some food, going back to his girl house. So yeah, she's gonna paint this guy as just, if not an innocent victim, he's a victim in a situation where he was not actively targeting somebody else,
In this, I see ops fall. Shell, know my call. That's Shell Kell, y'all. Every slum play nasty. That's what he says in the song. They wonder how we lasted. Bout my gang, it will never end. Again, beat the hum. What do you think, y'all? No evidence.
So she entered the criminal underground, to use a cartoonish phrase. She entered the criminal underground with her language, with some of her mannerisms, with her enunciation. She entered into that world. And I get it. It's a calculated risk. I get it. I don't think it landed. That's why I say I felt bad for her, because she seemed like she took that risk of, all right, I'm gonna be more on the street level with this at some point, because I don't think she started off like that, but I have to watch it back. She seems to have made a decision, or even just slipped into this, where she like beat the hum, and I think there's definitely a place for some of that. So I'm not saying I think she should have been totally buttoned up the whole presentation, because I do think there's a place for some of that, but I felt like she kind of slipped into that as her default mode of communication at some point. That was just how she was communicating from that perspective. And, I don't know that was effective, but again, I'm not there. She was cooking at start, but then she overcooked and crashed out. All right, let's keep going.
He don't realize that what his two co-conspirators said is evidence. Those interviews are evidence. His confession over a beat is evidence. This is evidence, ladies and gentlemen. And this is evidence you can take to the bank, deliberate, and find him guilty. The surveillance video is evidence. No, we don't have his phone records, but you got his two friends telling y'all what he did. And they don't got no reason to lie on him. For what?
They don't got no reason to lie. So if my daughters were to say to me, they don't got no reason to lie, automatically, they don't have any reason to lie. Automatically. I do it every day. My mom did it to me. My mom did it to me. She wouldn't let me say they don't got no reason to lie. She just wouldn't let me say it. She would make me say they don't have any reason to lie. Like, that's just what I would have to say. So they don't got no reason to lie. She's in street talk at that point. She's in street talk at that point. I mean, if somebody came to a job interview with me and they said, and I told my friend they don't got no reason to lie, I immediately would be thinking, ooh, I don't know if I can hire this person.
You ought to get killed from me and YSL if you snitch. See, that video is not just, a nice artistic video. That has symbolism in it. So now they guilty of all those. That's what we're talking about. Shamel. Young man, probably started associating with people from YFN. But on the day that he was about to get killed, he's about to go back to his girlfriend's house and go eat some spaghetti. That's what he's doing at the light. Get ready to go back. You see him go inside the gas station. He's not worried about a thing. He doesn't know that seconds later he's going to lose his life. So the timeline here, this is, and I'll tell you here, this is a direct result of retaliation from the stabbing of Lucci. So what do we have? February 9th,
Morning,
Sean Bennett gets stabbed in the Fulton County Jail by Jada Myrick. February 22nd.
Y'all notice this? This surprised me. This second little piece here to the puzzle. February 22nd, 2022. Christian Eppinger called to determine if he could get paid. Now, it was Hylton herself who interpreted that call as he was calling for permission. Y'all remember that? Hylton herself told the jury that call was for permission. But now on the slideshow, that was a call to get paid. Now, when we heard it, what did Eppinger say? I'm trying to see what I could get for that. At no point did he say, I'm trying to see if I could do that. Would y'all approve that? Can I do this? Can I roll with this? Y'all want me to rock out on this? He said, I'm trying to see what I can get for that. So he never asked for permission in that call, and it was clear that he didn't. But she was trying to prove that this is some kind of hierarchy. And so she interpreted, I'm trying to see what I can get for that as requesting permission. It was clear he wasn't asking for permission. Now, when they put it on a timeline, they actually put what it really was. He was trying to get paid, which is clear. You see? So when she talked about it in court, she did not mention the payment. She mentioned permission. Now somebody made this timeline. I'm pretty sure it wasn't her. I seriously doubt it was her. And that person actually put what it really was. Now, she could have easily said it was payment. I mean, that would certainly have helped her conspiracy argument. But she misinterpreted it, I think on purpose, because it was quite clear it was a payment question.
Antonio Sumlin to see if he could get paid for finishing what Myrick didn't do. Then you heard about that emergency bond paperwork that was filled out on March 3rd. Then sometime around early March, the media hears about the YFN Lucci stabbing. It gets picked up on media. On March 11th at 3 a.m., two YSL associates, Christian McMillan and Darius Ford, are murdered on I-75 and I-85. That same night, there's a shooting at 12 Atlanta where a YFN associate gets shot in the head. On March 12th, there's a shootout on Cleveland Avenue with Demekion Garlington and the ops. On March 12th, there's a 911 call shooting at 2830 Waters Road. March 14th, Shannon Stillwell rents the Audi A5 and puts dark tints on all the windows. March 14th, 10 o'clock is the murder of Shamel Drinks. On March 16th, the shooting at Waters Road, where the investigator RICO comes out. March 17th, there's a search of Waters Road where everything is taken out except for a few guns that they left behind. And then Stillwell and Nichols are arrested.
Y'all know another thing that's worth noting? She said in this presentation, did she show this yet? No. In this presentation, she said that Shannon and Quay and the whole group, they just happened to see Shamel Drinks at the gas station. They just happened to see him at the gas station. That it was just a bad coincidence for Shamel, basically. But she also says Shannon went and got the car's windows tinted. So basically, her story is he got the windows tinted so that he could go op hunting in a rental car with his name on it. Okay. Doesn't make a lot of sense, but fine. That's her theory. That's her hypothesis, I should say. Her hypothesis is Shannon went and rented a car in his own name with the reservation on video camera surveillance, which he probably would have known. And he tinted the windows so that he could go op hunting. Okay. That's her hypothesis. But then when he finally caught up with an op, it actually was not on a, well, maybe we don't know if he was on a hunt or not, but it wasn't due to the hunt. You know, it would have been a terrible coincidence for Shamel Drinks that Shannon and them were just at the drive-through. Excuse me, I said drive-through because somebody just said that. Y'all see how you put thoughts in my mind? Shannon and them were just at the gas station, and Shamel Drinks just showed up at the gas station. Didn't even know they were there. Like, probably never knew. So, though that's not a contradiction, because both of those could be true. It could be true that Shannon got a rented car in his name on video and tinted it to go op hunting. And it could also be true that he just coincidentally ran into an op the same day, was it? The same day at a gas station. But I tend to buy the explanation more that things were hot. I mean, look at this timeline. Things were really hot. So I tend to buy more the self-preservation explanation for the tints. I tend to buy more the self-preservation explanation for the tints. That you know, that's kind of neither here nor there with the Shamel Drinks. Another thing she keeps bringing up is how fast Shannon went. He went from 14 miles an hour to 90 miles an hour. I'm like, so? The only reason people go 90 miles an hour is because they're running from a murder that they just committed? Like, has she not seen drivers? I'm not convinced by that at all. I'm not convinced that the only explanation or even the best explanation for him going 90 miles per hour is that he's running from a murder he just committed. People just speed. I mean, 90 is quite fast, but you would have to tell me where was he going? Was he on the highway? If he was going 90 miles an hour down a residential road, I would find that very, very, very unusual. Yeah, so Miss Flynn's, it all depends. If he was going down a residential road at 90, I would say that is very unusual. But if he was on the highway or a road where you can do 40 or 50, even 40, that would be very fast in a 40 mile per hour zone. I would have to see where was he. Matter of fact, let me see. BP Windsor, Atlanta. We can actually find this out. Because didn't he go straight through the light? I actually want to know. I want to know, where was he going 90 at? Let's take a look. Let's take a look. This is interesting because she made a big deal out of the fact that he was doing 90. And I want to know where he was doing, where was he riding at? So this is the BP here. This is the King Liquor. We've looked at this map a bunch of times. This is the stoplight. This is the FedEx over here. Let me take Miss Flynn's off. This is the FedEx here. Okay. This is the stoplight right here. And Shannon went through this light and he was doing 90, but we really don't know. Can you get onto this highway? We don't know where he went. So I'm not sure. I mean, he goes through this light. I think he goes straight. Whoops. So if he just goes straight up here, 90 would be really fast to be going in this. I mean, if this is where he's at, just going up this road, that would be really freaking fast. If he gets onto the highway, which is literally right past the light, if he gets on the highway, then 90 is kind of normal for young people. If he got on the highway, then I'm not tripping off the 90. You get on the, I know you get on the highway under the bridge. I get that. So if he gets on the highway and he starts doing 90, then it's like he drives at 90 miles an hour. That doesn't surprise me. If they were to say he just went straight up this road and he was doing 90, I'd be like, yeah, that's definitely unusual. So, but if he gets on this stuff, all of this spaghetti that we're looking at here, then I'm going to say people drive 90. So I think for me, the 90 mile per hour evidence is only strong evidence if you tell me he's going straight into any of this stuff. You definitely don't want to be driving 90 in all of this. But if you're getting on this spaghetti, then yeah, 90 is normal. Any thoughts on Hylton saying doctor's testimony was that Shamel could move after being shot? No, Anon. What I said initially, and I maintain this is, and thank you for the super chat. The doctor said he could not have had any voluntary movement. So I agree with Hylton with what she said. He could not have had voluntary movement, but he could have had involuntary movement, meaning even after you are totally dead, your body retains energy. So his muscles could have still contracted and made certain movements even if he was dead. It's just possible for your muscles to still move even after you're dead for some period of time. I would say at least several seconds. You know, in some weird cases, you might be able to make movements for even over a minute, but definitely several seconds. Now, most of us don't ever see that, but you've seen it. I've certainly seen it in animals who have been killed or whatever. Some of them just go out and some of them, their body will kick, you know, and whatnot for several seconds or whatever until it just stops. So Hylton wasn't saying once he got shot, he could have tried to do something. She wasn't saying he could have tried, because at that point, his ability to try was extinguished. His ability to make a purposeful movement was extinguished, but his body did not just suddenly lose the ability to move. It's just he couldn't make it move. There was no he left. He wasn't there, but his body was still there, and his body still had energy, and his energy in his body could still coordinate certain involuntary movements, like maybe kicking the gas or the brake. You know, that's her theory. as to why the car moved. Now it's going to be up to the jury as to whether or not they want to think that that's likely, if that introduces reasonable doubt or not. But I think we should all be honest enough to say, after you're dead for a few seconds, your body can still make involuntary movements. Now, as a jury, you would say, do I believe that that's what happened here? It's not, can it happen? Of course it can happen. But do I think that's what happened here? So the question is not a can or can't. Yes, it can. Now we want to say, do I believe that's what happened here? Is that a good explanation? But yes, it can continue, but involuntarily, not voluntarily. Okay. So Slim, yes, unconscious movement. So you would expect if he's dead, or if he's alive, but only seconds left of life, and his conscious ability to do something, to do anything, has been removed, you would think maybe his foot could maybe pump or not pump the brake. But what we saw looks kind of purposeful, because you're kind of deep down inside, you kind of think, I mean, no matter which way you slice it, he stayed. You would imagine he was stopped at the stoplight. The car was probably not in park, but the car never moved. So somehow, strangely, did he put the car in park at the stoplight just coincidentally? I don't know. It's very strange that you see that pump happen, and that it's however it happened, the car didn't just kind of roll off. That's just weird. Do I think it was unfair the amount of time the state got? No, man. Tayo, I don't know. Man, woman, sorry. But I don't think it's unfair. No. The state was going to get to start, then defense went in the middle. Y'all, Max Sharp took 3 hours. Max Sharp took a full 3 hours. And I don't think Hylton took 3 hours. But if she did, she took the same amount of time as Sharp, maybe. It's just she went later in the day. So I think it was about even. And frankly, this has been a year-long trial. I think you just let them say what they got to say. No, they didn't check for GSR on his clothing. He went from 18th to 90th through a red light after the fourth car pull up. Yeah, I think it was 14 miles an hour. It could be the last car was shooting. He thought they were after him. Could be. You can twitch after death. That's exactly what I'm saying. The expert didn't suggest that he hit the brakes after the headshot, though. She wouldn't know. She wouldn't know what he did after the neck shot. Nerves still working. Yeah, for a little while. Your body can do all sorts. Yeah, for a little while, you can do all sorts of things. It's the car manufacturer issues. They make the cars go. Yeah, so I mean, again, I'm just simply saying, for me, if I'm a juror and I'm thinking he's doing 90 right here up this road, I would see it as unusual. If I'm a juror and I see that he got on this highway and he's doing 90, I wouldn't see it as unusual. So I'm simply saying, if I have to weigh all the evidence, doing 90 up this road would seem very dangerous. You don't usually see somebody doing 90 on this kind of road. I mean, I know there's people thinking, well, I seen it. It's not, has it ever happened? Is it normal? It is definitely not normal to do 90 on this kind of road. That is abnormal. If you're on a motorcycle, maybe you're doing tricks or something, but just driving around, you're not doing 90 on this road. If you're getting on the highway, there's a lot of people doing 90. So it just all depends. Yeah, snakes can still bite after death. That's exactly right. Hylton never asked a question of the ME, nor did anyone else. Actually, somebody did ask that question, Daily. Somebody did ask that question. If he can continue to make involuntary movement. Abate asked that question. He definitely did ask that question. If you can make involuntary movement after that neck shot. Abate asked that question. All right, let's go back to Hylton, y'all.
Again, we talk about the state does not have to prove motive, but here, ladies and gentlemen, this is motive. Again, that's that same video with Quindara.
Let me say this real quick. Quick Bite says, theoretically possible, highly unlikely. The concept was never elicited as testimonial evidence. That's not correct, Daily Quick Bites. Abate did 100% ask the medical examiner about post-death involuntary movement. Abate absolutely did ask her about that. And the problem with Abate is she replied, she focused, and I don't know if it was that Abate focused her on this or if she just replied with this, but she focused on like a hand clenching where we're talking about the brakes pumping. I will look it up for you. You know, I will absolutely. In fact, let me show you. I'm going to show you this because it's the internet and this is the type of stuff we do. I'm going to show you. Abate absolutely did ask her that question and she answered, but she just, for whatever reason, sometimes these lawyers, like, they're getting at something, but they don't actually get the full question out, or they don't get like really dig into it. And you like, why did you leave it at that? Like, this is a big question. I'm about to show you. I'm about to show you. I think it might be on this one. I have to pull up these videos. Hold up 1 second. Is the medical examiner on this video? Here she is. Okay, let me show you. Hopefully I brought it to this video.
This is the right side of the neck.
This would be the side that's, I guess, closest to, if you're sitting in the driver's seat of a vehicle, to the passenger, I guess, compartment.
Hopefully I left it on here.
Correct. Yes.
Now, can you tell the jurors, if there is no exit wound, can you explain to the jurors, were you able to determine during the external and internal portions of the autopsy that you performed?
A massive injury to the skull and also to the brain. It caused bleeding on the surface and within the brain. And whenever there is massive trauma such as this to the brain, consciousness is lost immediately. However, I could not determine whether this shot was instantly fatal or if Mr. Drink still had some cardiac and respiratory activity for some undetermined period of time.
Okay, so first she just says, I don't know if he was still breathing or if he just stopped breathing all of a sudden. That's the first thing she says. And Abate is going to try to focus her more on, could he make some movements? But for some reason, he doesn't actually get into the foot movement part, which I don't get, because that's what he was getting at, and he just left it there.
Sometimes with these catastrophic injuries to the brain can send out a signal to the heart, which causes the heart to either stop beating immediately or to go into a lethal rhythm. So consciousness would have been lost immediately, but whether death was instantaneous or there was some cardiac activity or breathing activity for some period of time, I couldn't determine.
And can you explain to the jury, based on the circumstances you kind of just described, what does, I know you described what the brain, the message that is sent to the heart. Can you explain to the jurors, are there other things that the body does under these circumstances? And I mean, are there any involuntary actions that the body can produce as it relates to someone who was shot in this?
Okay, listen to the question. Is there any involuntary activity that the body can produce? He literally just asked the question. Can the body produce involuntary activity? He just asked that question that people are saying did not come up in the trial. In case you didn't hear him, I'm going to bring it back because some people forgot this part. He just asked her the question. Now, I already said he did a poor job because they have a state's hypothesis. He did a poor job of eliciting the answer that he needed her to elicit. But he certainly did ask the question.
Are there any involuntary actions that the body can produce as it relates to someone who was shot in this manner?
Well, if there was still cardiac and respiratory activity, then there could have been obviously breathing. As people are dying, they can exhibit abnormal patterns of breathing. So I'm not sure if that's
so she's like, I don't know if that's what you're asking me. And Abate, I don't know, he just had a brain seizure, not seizure, but his brain just didn't, it's like, you're right there, foo. You're right there. You literally are right there. You know what you're trying to get her to say. And he just drops the ball here.
Referring to?
And I guess I'll give you an example. In an instance where someone is shot like this, and can someone's hands clench and it remain clenched because of the immediate traumatic injury that they received to their brain?
It's possible, yes.
Doctor, Mr. Body
That's
just
it.
asked.
That's it. That was it. Can their hand clench and it remained clenched? Like, Abate, are you familiar with the evidence? Don't you know that you need to get her the example of your foot moving? He didn't even ask. Y'all can go back. I did clip that part, but it's because he didn't go any further than that. So we all know that your body can involuntarily move, y'all. Come on. Okay. We all know your body can involuntarily move. Now, again, I've already said, I never said to me, I think that that's what happened. What I said is that's what the jury is going to have to decide. That is their job. They have the evidence. Now they have to try to make that determination. So that's my whole point. The jury will have the evidence, which is the testimony, which is the video, and they'll have to make that determination. It's a huge determination as to deciding whether they think Shannon did it or not. So, but the idea that it didn't come up as evidence, I just showed you, it did come up. The specific question about can your body do this thing didn't come up, but can it make involuntary movements did come up as a question. I think he didn't ask about the foot because I don't know if breaking is an I think he should have rolled the dice. But I see what you're saying. Maybe she would have just said no, right? Maybe she just would have said no. Maybe it just should have said no. Daily Quick Bites, I see what you're saying, but I disagree with you. The concept of involuntary movement came up, okay? He doesn't have to ask, can you turn your head? Can you open your eyes? Can you smile? Can you whatever? All right? He doesn't have to ask about every different function that you could possibly make. Can you make involuntary movements? The answer was yes. Plus, we know this. I mean, do we live in the world, y'all? Do we live in reality? I mean, are we going to sit here and say, once your consciousness goes out at that very second, all movement must stop? I mean, are we going to do that? I don't think we're going to do that because we all know that that's not the case. We can say usually, it seems like usually when consciousness stops, all movement stops. We can certainly say that. That's why the jury is going to have to make a determination. In their opinion, is this an unusual case? Right? That's the jury's job. She would say no to the foot. Maybe that's why he didn't ask. Maybe she would have said no. You might be right about that. But anyway, let's just play what Max asks as well, just to get the full context.
After being shot in the neck in the way that Mr. Drinks was, unfortunately, whether it's possible that one's foot could remain on a break if it was already there. And you said that's possible.
Yes, sir.
Okay. What is not possible? You would agree it's not possible after suffering that wound that someone would be actively moving their feet up and down off the break. That would not be possible.
That's correct.
Okay, thank you.
Okay, so Max said someone would be actively moving their foot on and off the break. But she understood that to mean, let me get this gun off the screen. YouTube is really, they don't like guns. I do believe she understood that to be voluntarily, though. No disrespect. I think you're wrong here. No clear evidence who killed Drinks. Okay. Are you talking to me? Because I certainly didn't say there's clear evidence who killed Drinks. So maybe you're talking to somebody else. Sometimes y'all just say something and I don't know if you're talking to me or not. Foot movement, all movement is both voluntary and involuntary and can be involuntary, y'all. Y'all, what? Sometimes it's like, why do we have to act like we don't live in the world? Okay, I know people are not convinced Shannon did it. I literally never said I think Shannon did anything. In fact, I've said multiple times I think there's reasonable doubt. Okay, so my take is there's reasonable doubt. I've been saying this. I've said it 100 million times. Okay, but to act like you can't have body spasms, involuntary spasms. People in a coma can move. It's not voluntary. They're not conscious. Okay, there's no consciousness there, but they can move. So you gotta, all I'm saying is this is not true. It doesn't matter what anyone said or what anyone. I'm gonna tell you how you know that this is totally untrue, because people are on the jury and they're gonna talk it through. And there's quite possibly gonna be somebody in there who's gonna say, well, we all know that your body can move after you're dead, right? I mean, now somebody else might say, hey, I don't know that. And then you're gonna have a deliberation. That's what jury deliberations are. But the idea that the only thing that's going to come into deliberations is what was said in court is ridiculous. That's ridiculous. In fact, Hylton even said, hey, y'all going to bring your common sense to this trial, right? Nobody had to instruct the jury on how to use common sense. So the idea that if it wasn't said, it won't be a factor, that's just crazy. Of course, there's going to be a lot that is unsaid explicitly that are going to be a factor in this. There's going to be a lot that are unsaid, that is unsaid, that's going to be a factor. Dude, this is my stream. I'll talk about whatever I want. If you don't like, you could just bounce. Okay? You could bounce. You don't like what I'm talking about? And no, I'm not a paralegal. I'm not a paralegal. So when they get in there and they start to deliberate, there's going to be so much that comes into play that wasn't explicitly said. Is there court today? Yeah, court is going to be starting in about 5 minutes. I'm not trolling. I'm not trolling. I'm not trolling. I'm not trolling. Y'all have to think that people are going to go into the jury deliberation room and they're going to talk these things through. They're going to talk these things through. Right? So this is what it looks like when people talk stuff through. All right? So, you have to allow that people are going to have their opinion. You have to allow the people going to have their opinion. You know what I'm saying? And it's just factually speaking that there could be some involuntary movement. But I did say, I've said many times about the drinks footage that I believe there's reasonable doubt. I've been said that. I said it today as well. Thank you for the super mismelanated. If the bullet went through the brainstem, he was immediately paralyzed and brain dead. The brainstem controls involuntary movement. I know this from working in ERs. You know what? It's funny. Somebody else who said the same thing, I've been a nurse for 20 years, came on here on this stream and said, yeah, once you're dead, you can have involuntary movements. So you are a person who says you can't have involuntary movements. And somebody else said, yeah, I know for sure that you can have involuntary movements. So thank you for the super. But this is just, you cannot have voluntary movement. And the medical examiner just testified that you can have an involuntary. She literally just said it. She said your hand could potentially clench. It's possible. So, Ms. Melnade, I definitely thank you for the super, but you're going against not only, I mean, you can see, I brought up a video of a frog that literally had no head. It was skinned. It was about to be eaten by somebody. And when they touched it to the sauce or whatever, the muscles jumped. And people were like, oh, is that frog still alive? No, it's not still alive. Muscles can move involuntarily. Involuntarily. That means that there is no conscious or purposeful control of it. She even said that he could have continued breathing. Breathing is movement. So she said it depends. He might have been able to keep breathing for a while. So back to you, Miss Melanated. Explain to me, how could he have kept breathing, according to the medical examiner, if he can't move? How can you breathe without moving? How can you breathe? How can you breathe without moving? That would be a neat trick that you could breathe, but not your body not move. You can have involuntary movement after death, however, not enough strength to hold anything or hold your foot on a gas pedal. Well, y'all, what y'all got to remember is this. Drinks was at a stoplight. Drinks was at a stoplight. When he got shot, his car didn't just ride off into the sunset. So somehow his foot was still on the brake. That's a fact. A chicken with his head chopped off continues to run. Thank you, Sandy. That's the point. That's the point. All right, Get Back Black Women says it's a moot issue since they can be convicted for just being there and or being part of the planning. That's what we need to see today with the jury instructions. That is what we need to see with the jury instructions. That is what we need to see with the jury instructions, people. Because I don't remember them discussing that at all. I don't remember them discussing that at all. I can't believe there's people really here who think that the moment you die, your body can't move anymore. Like, it's impossible. She literally just said that you could keep breathing. Breathing is movement, people, in case you haven't noticed. She said your heart could keep beating for a while. Heartbeats are movement, people. Breathing is movement, people, in case you didn't notice. Anyway, we kind of got caught up in that. We kind of got breathing isn't foot movement. Okay, so Tiffany Rivera seems to think that your foot can't move. All right. I've seen headless men have involuntary movement. Well, so this is what's going to happen in the jury room, y'all. Everything that's happening with us right now is what we have to expect will happen in the jury room. Remember, they weren't supposed to have discussed this. They were not supposed to have discussed this at all for a year. So now, for people who think, oh yeah, they're gonna get it, they're gonna get out of there by tomorrow night because they want to have Thanksgiving and they want to be home for their, well, they're gonna be home either way, but they want to be just done with this. Maybe they will. Maybe they'll be done by tomorrow night, but maybe they won't. Maybe it's gonna be a guy like me in there. Again, I've already said I think there's reasonable doubt. So this is kind of just arguing a bit of a point that doesn't matter to my conclusion of the whole thing. I think there's reasonable doubt. I think there's reasonable doubt that the third, or you could say the fourth car, that the third car that arrived did it. I think there's reasonable doubt. I was convinced. So I would have to vote not guilty. But if we were to be in a jury room and find ourselves in an unfortunate debate about this, we would be there for a while, because I wouldn't be backing down on this point. Even though, you know, at the end of the day, I would be for not guilty due to reasonable doubt. See, do y'all see how this is a kind of a back and forth in here? No, this was not the point this morning. This wasn't like the idea was not to, but we have talked about this many times. So it's not surprising that this came up again. It's not surprising that this came up again. But imagine that the jurors get into this kind of conversation. I think they'll be done by Wednesday. The state has no proof as for unaliving those. I don't know. You start getting into these little nuanced conversations and stuff is going to get crazy. They're
We
going.
need to make sure we have taken care of all of our last minute housekeeping on the indictment, the verdict forms, the charges. Ms. Persfield shared an email yesterday evening that has what we think are the last things we need to take a look at. So if we want to just walk through those, I guess maybe the verdict forms are the easiest thing to look at first. And y'all just let me know if those look okay. Yes, final docs, charges, etc. from about 6 yesterday evening. And it attaches each verdict form, the redacted indictment, which
Y'all hit the like, please.
Need to still address some things on, and then the jury charges may change based on what we do with the indictment. So let's just look at the verdict forms first.
D, I would say it seems very
Actually
unlikely.
in final form.
That's why I have reasonable doubt. Not impossible, but unlikely. So I, as a
This is
juror,
minor, Your Honor, but do we need an entire page for the
Well,
overt acts, or is that just a
here's
good way
the
to break
thing
it?
is I thought about doing some lines, but then I didn't want y'all saying, well, if you put 10 lines, that implies that they should find lots of acts.
I
So
thought about
if
doing
we
some
have a blank
lines, y'all.
page, it is literally a blank slate, and they can put nothing, 173, it'll be up to them. So that was my thinking.
Well, I certainly prefer that to the lines. So,
Okay.
but it's
All
very
right.
difficult to please us.
All right, then that's why it's there.
Well, Your Honor, as you know, the state would prefer the lines, but given that you made it clear, you sort of made your mind up on this issue.
These instructions are going to take at least half a day, I believe.
Most appropriate to go around.
They're going to come in at 11, Latrice. I'd be surprised if the instructions aren't done. They're going to take at least 2 to 3 hours, I would say.
Okay. All right. So any other items? All right.
And I don't know if this is the same thing Mr. Sharp stated on Mr. Stillwell's verdict form.
Yep.
For count 49 and count 52, just for consistency, I would put the not guilty first and then the guilty.
I agree. Don't know how that one happened. Ms. Persfield, can you switch those around? Thank you for that catch. Yes. Why? I mean, if you're going to object, you need to give me a reason.
Because, I mean, I think it's clear what the two counts are. If we put a date on it, I wouldn't necessarily have a problem with it. I mean, I think it's clear that my client struck two murders. I don't think it's necessary to put the victims' names next to each count.
How much y'all think
All right,
the
well, I
jurors can
appreciate
make
that
on a book
objection.
or on an interview? If I'm going to make an offer to a
Anything
juror,
else
how
on
much should it be?
Mr. Stillwell's verdict form? All right, hearing nothing, we will move on to Mr. Kendrick's verdict form. And
3
it's
million. Come
possible
on.
that, I don't know if we have a guilty, not guilty reversal on that one, but if
No,
we do, we'll
it's
fix
correct on that one.
Okay.
Or consistent. Let's use
consistent.
that word,
Okay.
consistent, Your Honor.
$5,000. Y'all tripping. Depends on the verdict. Explain, Ms. Flynn's. I've never even tried to get a.
All right, anybody have any issues then on that verdict form? I guess maybe you could on the, I don't know why it's not showing up on mine. I don't have lines under this blank day of blank, but it looks like you do on yours, Ms. Persfield.
Tree
so
fitting.
As long as they're there.
That's funny.
Okay, all right, so looks like at least the verdict forms are in their final form.
Y'all have to remember there's
Redacted
what,
indictment.
16 people?
And
So
as y'all can see, and from the email, I determined that Overt Act number 175 shouldn't be in there because it seems to not assert one of the necessary elements to have made that a crime.
Yes, Your Honor. I understand the thinking behind it, but I don't think that's consistent with Georgia law. I think we've already established and the court has recognized an overt act doesn't have to be a crime, and therefore we would not have to have all the elements present.
You are asserting the crime of, did commit the felony offense of whatever, OCGA section whatever, so.
That was the first part. Second,
Okay.
second part is this. Under Georgia law, and federal law is consistent as well, the state does not have to allege all of the elements of an overt act that does happen to be a crime because it is not separately charged. The pleading rules are not the same. You can't generally demur to an overt act. And so it's, while it might not be adequate as a freestanding charge, an overt act telling the jury what we are saying was done, that would still be sufficient. They don't have to decide it's a crime. They just have to decide it's an act in furtherance of the conspiracy because they're not separately convicted.
I don't agree. If you have law that is on point, show it to me. But if you are asserting he committed the felony offense of possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm, and you cite 1611-133, one of the essential elements of that is that he's possessing it while he's committing a crime. And y'all don't assert that.
I understand, Your Honor. As far as it not needing to be a crime, Yates versus United States, 354 U.S. 298.
That says if you assert it as a crime inside a statute, it still doesn't have to be a crime? I know an overt act doesn't have to be a crime. Are you saying that Yates is going to tell me that if you assert he committed X crime, you don't have to actually be asserting a crime, even though you're saying pursuant to XYZ statute?
So I was citing Yates for the initial principle.
That I understand.
Okay. I'm not representing to the court that Yates says all of the additional things you said. I don't have a cite off the top of my head, so I'll simply have to represent this to the court. But I will tell you that it is well-established federal case law, for example, that if a defendant is charged, let's say count one is conspiracy, and there is an alleged overt act, that overt act is also alleged as count two, independently.
Right.
The defendant can be acquitted of count two because the jury finds an element of that separate charge was not found, but it still functions as an overt act in furtherance of the conspiracy, especially when, like the ones we're talking about here, there's more than one actor involved.
There's not here for 175. There's only Mr. Nichols.
Okay, I I still don't,
All right, again, if you find some law that is on point, you let me know.
all right.
By that reasoning,
I'm, if you find some law, we'll deal with it further. Otherwise, let's move
I
on.
agree, I'm with the court,
Okay.
but I'm wondering if that should also not apply to 174, 189, and 190.
So on those, I would like to know, let's see. Good question. All right, 174 and which others?
189, oh, sorry, go ahead.
189 and 190.
Mrs. Flynn's, that's one of the problems. You can be found guilty of crimes, but you could still be included in the RICO. That's one of the big problems with the RICO, is that you can still be included.
I think those present the same situation.
I do think there's a lot of reasonable doubt. I agree with that.
Yeah, I think you're correct.
Particularly with the two murders and with the RICO. Yeah, Nutt was supposedly, according to Detective Dennis, he was the 4th or 5th highest ranking blood in the entire state at that time. That's what Detective Dennis said at that time. Is this still going on, y'all? Does YSL still exist? Is anybody in Atlanta? Do you know if there's still YSL? Does IF still exist? I mean, as a force. I don't mean like technically. I mean, you know, are they still moving? IF is all locked up. So, y'all, do you think Thug's gonna have to basically start a whole new thing at this point? I kind of feel like he had to start from scratch with a whole new thing. I kind of feel like YSL is too hot, and anything that has the word YSL on it that is involved in violence, if Thug is still involved, he can be hauled right back into court.
So looking at, like, for instance, on Mr. Stillwell's March 17th possession of a firearm allegation, it's also a substantive count 64, and it's saying that he did that on March 17th. And we know from the evidence that what everybody is talking about is the gun that was, I don't know if it was thrown out of the car, but the gun that was discarded during the chase.
Hey, Nicole, I went to law school in St. Paul. First time I ever landed on a totally snowed out runway. Like here in my area, the airport would have been closed, but I'm talking about totally snow-packed runway.
You know, I mean, I think we were looking at sort of the somewhat odd language of 1611-133.
So I guess my stance, Your Honor, is that ultimately, when it comes down to it, the state did not indict this correctly, and the state did not put it in the overt acts correctly, and they specifically alleged a specific crime in the overt acts. So we moved for a directed verdict on the
on the substantive charges, and Mr. Abate and the state provided case law that saved that and opened up the possibility for a lesser included, and I get that. But I don't see that same mechanism of saving the charge for overt acts.
Right.
And so that's kind of where we're at. Essentially, I'm suggesting that there should be a directed verdict on the overt acts.
Oh, DeMoyo 360 says he's YSL for life, that they're still out there. Thanks for the $4.99, sir. Oh, but just kidding. I'm not kidding about the thanks for the $4.99. I appreciate that. I definitely appreciate that. Okay, yeah. I went to law school at Mitchell Hamlin University. Totally snowed out runway, y'all. We landed a plane on a snow-packed runway. It's crazy.
I think those overt acts need to be removed. 174, 175.
Yes, I went to law school.
And 190.
I graduated from law school. That is correct.
Your Honor, may the state briefly address that issue?
Sure.
The state does believe that for the reasons that Mr. Floyd was just articulating about the case law for a substantive count of 133, as the court, as we have addressed, you can have the possession of a firearm by a convicted felon because it's a lesser included. Legally speaking, the argument for an overt act language, which does not have to have as much specificity as a count that the jury is deliberating on. The first language in 190, for example, is possession of firearm by a convicted felon. It obviously has the superfluous language because it's not completed of the underlying felony, but that same logic for a count, which has to be more perfected than overt acts do.
This is live.
Because overt acts do not have to be crimes.
I understand they don't have to be crimes,
Yes,
but they've
Your
been alleged to be crimes with specific statute numbers. And yet y'all haven't included what would be essential to make them a crime. So are you arguing that the overt acts should be lesser included also, or what are you saying? What's your argument?
Your Honor, my argument is that if the jury is tasked to decide if on March 17, 2022, when Shannon Stillwell possessed the firearm by a convicted felon in
Previously convicted of a felony involving use or possession of a firearm.
Yes, Your Honor. In the state's mind, the lesser included argument on a substantive count is a harder standard to meet than an overt act. There's no such thing as like a directed verdict on an overt act as there is with substantive counts. And so the state believes that same legal principle of why a lesser included of possession of firearm by a convicted felon can be included on a substantive count is even stronger on an overt act.
So are you, so I'm
Yes, Your
clear,
Honor.
are you asking that these be converted into just possession of a firearm by a convicted felon in the overt acts? As
Essentially,
kind of a lesser included crime?
Yes, Your Honor. And if the state, if you, like, for example, if the state, from my understanding, were just to, redact, or essentially, yes, Your Honor.
All right.
And I'll let Mr. Floyd.
I mean, I think that there is evidence presented for that. It's, and I hope y'all understand what my thinking is on because 133 requires that it be asserted that they did this while they were attempting or committing a series of crimes listed or types of crimes listed in the statute. And that is in nowhere listed in your overt act. That seems to be problematic. But simple, if you will, possession of a firearm by a convicted felon. You don't have to be possessing it while committing a crime. You just have to be possessing it. And that has been asserted in each of these overt acts.
Well, and Your Honor, just to supplement what my colleague, Mr. Adkins, was saying, I'm holding this up because I've been informed they can't hear me behind otherwise. The point that this does different work as an overt act than it would as a separate substantive charge. Frankly, only just the fact that he had the gun during the course of the conspiracy is enough for it to be an overt act. And just he is in possession of a weapon.
I know
The
y'all
rest of the
didn't allege it that way.
Well, that may be so, but it still does the work under it. I mean, it wouldn't.
They cannot return. I find overt act 190. He committed this crime when you have not asserted that every element of that crime. They can't possibly find that when it hasn't been correctly asserted. Y'all have left out an element. So unless you've got case law, you're not going to convince me on that one. We have moved on to whether it should be redacted, modified to essentially assert a Section 131 crime of simple possession of a firearm by a convicted felon. And I think that has been sufficiently asserted in each of these overt acts.
Excuse me, and the
Yes.
state may be able to find a case, but I haven't, I mean, and you may be aware of a case, Your Honor. And in my limited time, I haven't found one, but I don't believe that there's a case that permits the court to go back
I do
and
not
fix.
have any idea whether there is.
Yeah, I do not believe that you can go back now and fix the error that they have made or whatever, fix what they have done at this point in time by modifying the allegation
Yeah.
of this overt act. At this point, I just don't.
How
think
would
you
they
can
do that? I mean, the whole
I don't
trial
The
has
option
happened
is
at
to
this
redact
point.
it, Your Honor, and it would be, I think it would be error to go ahead and change that.
I don't know. So
Because that's what we have been,
I'm sure we'll have some time between now and when we actually send it out for somebody to do some research on that. So
What?
we'll put a pin in overt
They
acts
did the whole
174,
trial. How are you going to go
175,
back and modify
189,
stuff?
and 190. They're absolutely not going to be included as a 133 offense. Y'all can let me know if there is case law out there that answers our question on the floor right now of whether they could be converted into a 131 offense, since it at least asserts that, but I don't know whether we can.
Thank you,
change it
Audra.
like that. So
Thank you
we'll
for
come back to that.
the super chat. And wow, 24 to 36 hours. That's a lot more than I would have thought.
Yeah, because we need it specific to, can an overt act, in the midst of a trial after the evidence has been closed, be modified to assert what would be a lesser included crime that is fully alleged in that overt act. All right. So our next issue
Oh my gosh.
let me jot myself a note down. All right, the overt acts that include Mr. Kendrick and others that I granted a directed verdict as to Mr. Kendrick that basically with regard to the possession of cocaine and possession of codeine. And that's easy enough to redact out of the substantive count of the indictment itself, although we need to actually look at, if y'all can open up the, what count is that, Ms. Persfield? Okay.
you mean
I'm sorry, the count. We'll do the substantive count first. I think it's highlighted. Okay. If y'all will look at count 57, the issue, I would just strike possession of codeine with intent to distribute and possession of cocaine out of the indictment. I know that it doesn't really matter with regard to Arnold and Williams. I mean, they're on this indictment, but they're not deliberating about them. So it really doesn't matter, I don't think, whether something that those people could be charged with is included or not, because all that the jury is deciding is Mr. Kendrick. So is everybody okay with us just redacting out possession of codeine with intent to distribute and possession of cocaine on the substantive count?
I'm okay with that, Your Honor.
Okay, all right. Now, the somewhat more complicated issue is when we go back to the overt acts, because that same thing is essentially included as an overt act as well, and those start around overt act 183.
And on that, if I may just briefly speak to that, Your Honor. I mean, we have a similar situation, I guess, that we're fighting with those others, and that the question is, do you redact the entire count, right?
And I think not, because with an overt act, it doesn't have to be that Mr. Kendrick was the one that the jury determines whether or not committed. The other people, they could think, well, Mr. Williams possessed that codeine, so.
But here's the problem with that. Let's say they come back in the jury verdict form and they list 183 as one of the overt acts that they find, right? We don't know if they found that because they found that Mr. Kendrick.
Agreed. So here's a possibility.
All right.
So I'm going to throw this out here and y'all can let me know what you think. If we have a 183 that alleges that the three people that are included, Arnold, Kendrick, and Williams, possessed marijuana with intent to distribute and a firearm during the commission of a felony, because those are still live with regard to Mr. Kendrick. And then maybe a 183A that says, or posits that Arnold and Williams possessed the codeine and the cocaine. And then we know, okay, it's 183. They think they all, or somebody at least, possess those two things. Or we think maybe Mr. Williams or maybe Mr. Arnold possessed the codeine or the cocaine, but we know it can't have been Mr. Kendrick because I've already determined that.
So just want to make sure I understand the court's suggestion. There'd be essentially I'm going to do a slightly different numbering system. There'd be a 183A, which has all three individuals listed, but you would remove the codeine and the cocaine. And then there would be a 183B, which would just be Arnold and Williams with the
codeine and the cocaine. Yes, that's what I'm proposing.
My only question with that is, are we facing the same situation, or with a question of, can we then go and modify? I guess we can modify these overt acts. I don't know if we can modify.
Like that's an easier question because it's based on me having directed a verdict that Mr. Kendrick can't have done those two things, so it inures to his benefit.
I'm willing to go with your suggestion as long as it's not taken by the court or anyone else, that I'm conceding that the ability to modify this overt act for A and B due to a directed verdict is a concession that you can modify those other overt acts that we referred to earlier.
Understood. And if we find out that you in no way can modify, then I guess our solution would be to just strike those two things entirely. But I don't think that is actually fair to the state when it could be that, they asserted that all three of them did that, and it could be that the jury thinks one of them did that.
And I'm not, while I probably should, I'm not disagreeing with the court on what you're saying with respect to that. The real key is going to be if we can find any law and what that law says. Sure. That'll be determinative of some of those issues.
You say I probably should, but you shouldn't if you, I appreciate that you take your duty of candor seriously. I really do. Thank you. Yes, sir.
Your Honor, with regard to count or Act 183,
Yeah.
if the jury unanimously finds that this overt act was in furtherance of the conspiracy,
Yeah.
I believe with the instructions the court will be giving when you have multiple parties, and could mean, and can be or in pleadings. And so if the jury finds that this, which includes Mr. Arnold, Mr. Williams, and Mr. Kendrick, if they find it's an act in furtherance of the conspiracy, it would be attributable against Kendrick and Stillwell. So I believe the state's current belief is that the way it is worded is safe with the instructions the court will be given about possession, constructive, actual, how you read and in indictments or pleadings, so that the jury, who's presumed to follow the court's instructions, will use those legal principles. And if they do find this overt act is in furtherance, it will be following that law.
Here's the
Yes, Your Honor.
challenge with that, and just kind of think through this hypothetical with me. We have got overt act 183 that says Arnold, Kendrick, and Williams. Let's assume that the only overt act the jury comes back with is 183. And all we know is they found 183. But how do we know then that they didn't say, you know what, I think Mr. Kendrick possessed codeine with intent to distribute. That is all I think, and that is why I'm finding this count. When I have already directed a verdict against the state and on the side of Mr. Kendrick with regard to that, that seems problematic. And then the whole case gets reversed, assuming that that's what happens.
Understood.
And
John.
I doubt if that's going to come to fruition, but legally speaking, that's my worry with leaving it the way it is.
Understood, Your Honor. I'm thinking through it with the court right now.
Okay.
So if we could come back to this.
All right.
Thank you, Your Honor.
I guess what doesn't make sense is we didn't have to charge the separate offenses. We could have just put those offenses like we did in the overt act, and your directed verdict on those obviously would have had no.
That's true.
There's no directed verdict.
That's true, but I'm worried about an inconsistent verdict, which is not allowed.
Well, inconsistent verdicts in Georgia are allowed. Georgia doesn't have inconsistent verdicts in what they don't go.
Well, what is it that we phrase it? It's not inconsistent. What is it called? Repugnant. And I don't know, this would qualify as that, but it's factually, I don't know the answer.
Your Honor,
I just know the question.
I think we'll have time to return to this.
Okay.
I'd like to bring you, bring you some authority. But
Okay.
I can tell you that my understanding under analogous federal law is that there is not such a thing as an inconsistent verdict as between a substantive count on a charge and that being an overt act. The jury could find it to be the overt act, even though the substantive count they rejected explicitly.
Okay, but that's not them. All right. If you can, I think that would be an inconsistent verdict, which wouldn't be problematic. Our situation is not that. Let's assume that nobody else is charged, that it's just Mr. Kendrick who it's alleged to have done overt act 183. And I have directed, and it's only, codeine. And I've directed a verdict on that count with regard to the substantive count. Could we then leave that overt act in? When I've said as a matter of law?
Actually, I believe the answer.
So that's our question.
Right, understood. It helps to frame the question.
Okay.
And we're going to come back and talk about it, so I don't want to.
All right.
I'd like to be.
Think it through before we know what the case law is. Okay.
Thank you.
Appreciate it. All right. The next thing is on the overt acts that allege possession of a firearm by a convicted felon that aren't also substantive counts. We were adding definitions of, like, if, I don't know, Mr. Arnold was alleged to have committed an overt act of possession of a firearm by a convicted felon while he was convicted of, you know, I don't know, dealing in some kind of drugs. And we would need to have defined what is that underlying crime in our overt acts definitions. But that would only be true, I think, if we then had, well, let's not have it be Mr. Arnold. I'm talking about Mr. Kendrick and Mr. Stillwell. They've been alleged to have been convicted felons based on convictions for gang act and burglary with regard to Mr. Stillwell, shoplifting and possession of dangerous drugs out of Arizona. As to Mr. Kendrick, I just want to make sure that those convictions are in evidence, and that ought to be easy enough to check. And honestly, I think Ms. Hylton, you maybe even cited what the exhibit numbers were. I just want to make sure that is what those matched up to.
Yes, Your Honor.
So I think it was what you said was 60G, 30Q, and 487VV. So can we just pull those and or if you've got it on this, you had it as a slide, actually. If you want to just pull that up too, and let's look.
And there are other convictions for Mr. Stillwell that were admitted as well.
Right. But I'm just, at this point, trying to figure out which crimes not otherwise defined do I need to define for purposes of overt acts. And we have not yet defined shoplifting, burglary, or whatever that Arizona dangerous drugs thing is, and I'm not even sure how to define that one, but looking at the indictment, plea, and sentence would help. And are we sure that was a felony shoplifting? Because shoplifting isn't always a felony. So can we just pull those convictions?
You want me to pull what I posted in the?
I mean, the actual piece of evidence would be probably the easiest. Thanks.
This is not previously recorded. This is live. They are still not sure of how the law works, people. What we've seen this morning is that they're still not sure how the law works. Miss Melanated came back with the $4.99 super. Appreciate it. I do appreciate that, Miss Melanated. I do. We had a huge debate, y'all, of this morning. I guess we can call it a debate about whether your body can move once you are brain dead. And Miss Melanated is, to your credit, still maintaining your point that it cannot. And I do appreciate that. It's not like they don't know the law. They're trying to twist law. The law is vague, High Priestess. The law is not clear in this case. And Judge Whitaker is basically having to invent an interpretation before our very eyes. So that's what's happening. This is a vague part of the law that nobody is sure how it's supposed to work. I'm talking about this particular question. She gave a directed verdict. Can that overt act be the basis of the RICO, or does it need to be removed? Is essentially how I understand this to be, understand the question. And they just don't know the answer. So while there have been many situations where the twisting interpretation could be right, in this case, I would rather say they just don't seem to really have any background to know what they're supposed to do. If they don't know, why use it? Well, the defense doesn't want them to use it and the prosecution does. You know, that's their jobs. Both of their jobs, they're both advocating for their side of the coin. The defense, they don't want that to be used, and the prosecution, they do want it to be used. So, you know, the judge is going to have to make the determination. I know the testimony that Cheeseborough had and what a detective had, one of them was lying because somebody had to be at the scene first. Maybe you're talking about something we were talking about a little bit earlier. They're still trying trickery. The state need to go back to school. So Shirley's divorce, they have an overt act. It's possession of codeine, for example. That is a perfectly fine overt act, and it's illegal. The complication comes in is that Judge Whitaker basically dismissed that charge. That's the term I'm using. She gave a directed verdict against that overt act. So now the question is, do they just remove that altogether from the indictment, or could the jury still find that that's an overt act for the RICO, even though Judge Whitaker gave a directed verdict for it? So that's how I understand this. And I think it's a legitimate question, honestly. The state wants to keep it because that's their job, and the defense wants to get rid of it because that's their job. So I wouldn't say there's a twist in this situation. It's unclear as to, does the directed verdict remove that from RICO contention or consideration or not. They should have case law and definitions on point. Well, Deb, this is where case law, this is where it starts. So you can't have it before you have it. You see what I'm saying? So this will probably become case law at some point, but there always has to be a first question about it. There always has to be. So if this has not come up in Georgia, which they're supposed to be researching case law now, if this hasn't come up as a question in Georgia, there has to be a first time that it comes up as, well, everything that comes to be came to be at some point, okay, to get philosophical. So this could just be the moment that this question came to be, you know?
We were just dealing with other issues.
So High Priestess, remember the RICO is the charge. The possession of codeine is the overt act. So they're not, so Yak Gotti is not getting, he's not in risk of getting.
And Your Honor, unless I missed it, I don't believe the Arizona conviction came into evidence.
Yak Gotti is not getting, he's not risking getting a verdict on the coding because that's the directed verdict eliminated that.
If 438 VV. Now, you had cited in your closing presentation 487 VV.
It was 438, which is this.
Okay.
For.
All right. So it doesn't look like the Arizona conviction came in. So
Thank you for that comment, Melissa. I think that's a well-established fact. Man, if there was something illegal in there and there's proof, I don't care. So this is the question, y'all. If you need an overt act for the RICO and you have an overt act that's in the allegation in the indictment, but that overt act is subject to a directed verdict, do you still get to keep that to try to establish the RICO?
Starting with overt act number 3, y'all allege that Mr. Stillwell possessed marijuana with intent to distribute on 8/23/13. Is there a conviction for that? In which one is that?
That is going. Yes.
No, Ms. Flynn's. He's not getting constructive possession on those. She gave a directed verdict, so it's over for those.
It's neither of these. Aren't there 3 for Mr. Stillwell?
Yes, Your Honor.
All right, you handed me 2.
I handed you the 2 that we discussed.
Okay, can you hand me all of the convictions for each of them that are in evidence?
Why are people still arguing this? Just factually wrong, dead spot.
You had cited all of them in your closing, but that's okay. It's probably this one. No, this is a 10 SC. It can't be that one. Can't be that one either.
So that is what the judge is trying to determine. They're not
Okay, well,
reintroducing
I think it's
it.
still somewhere in one
I
of
think
those
the question
bins
is, would it
that
like
is in
continue? But that's what the judge has to determine. That's what the judge has to determine. So I see you're saying that the answer is no. The defense is saying the answer is no. I would think the answer should be no, but let's see what the judge says. She seems to be leaning toward no, or else I think she would have just said yes and given her opinion on it. So I think she's leaning toward no. I mean, she is the person who gave the directed verdict after all. It's not double jeopardy because they are not, because the directed verdict was for the codeine possession. That's done. But they're still on the hook for the RICO. They're still being judged for the RICO. The codeine possession was an overt act for the RICO.
Ms. Pressfield, the burglary one, there is a conviction for, so we do need to define burglary in our overt acts.
Your Honor, for the 2013 Act 3, we put up evidence of it.
I would say that the answer seems like it should be no as well.
Okay. Okay. All right. As long as there's, okay. So there's some evidence. Okay. All right.
I agree. This should have
All right, we've
already been
defined
done.
possession
I
of
agree with
marijuana
that.
Can distribute anyway. Yes.
I don't think it's necessary to define the burglary for the example that you just referenced as it relates to that conviction. They just need to determine that what they have is a felony conviction and that they've been convicted of that felony. There's no added, I think we're just adding extra charges and confusion to the jury to have.
I see what you mean. That's a good point. If there's a conviction in there, then they don't need to make a determination whether that occurred. It's proven by the conviction. All right, that's reasonable. All right, so then
yeah, I mean, y'all should expect the state to argue to try to get a conviction. I don't think this is dirty. This question is not dirty. This is it seems to be pretty straightforward, honestly, but Judge Whitaker is allowing the state to come up with some case law that would support their position, which is what she's supposed to do. This is the reason, Allison, why I think there may be a multi-day jury deliberation, because I think it's going to be difficult for them to even understand what the RICO stuff.
Are there other overt acts that have been proven by somebody else's conviction being admitted, such that we wouldn't have to define those either?
I'm starting to feel like there's going to be that they're not going to reach a verdict tomorrow, y'all. I mean, if they're taking their job seriously as a jury, there's going to be a lot of debate. Look how we can't even decide as a chat whether somebody's body can move after their brain dead. Like, we can't even decide that. We can't even decide that. So we're going to get the jury in there with all these complicated instructions and all of this that's happened back and forth. If we get a verdict tomorrow, that means that their minds were already made up. If we get a verdict between, I guess they'll get to deliberate some today, maybe. If we are able to get a verdict sometime between today and tomorrow, that means that their minds are already made up, because this is too complicated for them to deliberate and digest, particularly the RICO stuff. And again, look at how we are back and forth on just, can your body move after your brain dead? Some people are saying no, and they know it for a fact. Some people are saying yes, and they know it for a fact. And what if that's a key question to the Shamel Drinks situation? What if that's a key question? And what if you have part of the people saying yes, the jury, and part saying no?
All right, y'all, overt act 58 alleges possession of a firearm by a convicted felon by Mr. Kendrick, by possessing a firearm having been convicted of that Arizona felony. Is that conviction of possession of a firearm in evidence? Not the Arizona conviction, but I don't know if it's I assume Georgia conviction for possession of a firearm by a convicted felon?
That's the one that you have for 38 BP.
Okay.
That I told you first, the conviction for that.
Y'all do hit the like button, please. Hit the like button. I said it yesterday. We can come in here. We can debate. We can go all the way in here. You can express your true opinion up in here. Kiera said after Thanksgiving. It's starting to look that way. I think deliberation is going to take three to 5 days. I'm really feeling like it probably will not be done tomorrow. Calling the state as usual, people trying to please the state is wrong. Judge should shut it down. The judge should ask, is there any case law, Andre? If there's no case law, then she can rule how she wants, but she can't. She's a superior court judge. She's on the lowest rung of judges of court. So what's proper is, has a higher court ruled on this previously? If so, show it to me so I can follow that ruling. If not, then Judge Whitaker can make her own ruling and make her own determination. So as a superior court judge, her job is to follow precedent. So she's asking the state, and rightly so, is there a precedent? Is there an appeal or Supreme Court ruling on this kind of question? If so, please show me so that I can act accordingly. That's what her job is.
You can put it back where it goes. And then have y'all come up with any other overt acts where we won't need to define a crime because it's established by some alleged co-conspirator's conviction that's in evidence?
Your Honor, We are looking, Your Honor, we're looking at that now, and I think the court just addressed this, but just with the Arizona conviction,
Yeah, we don't need that one. We just need the, yeah, that one's satisfied.
thank you, Your Honor.
Thanks.
Yeah, I think if they come back tomorrow, between today and tomorrow, it's going to have to be not guilty. Kai, I do thank you for gifting the membership. Whoever received that gifted membership from Kai, please say thank you if you haven't already. So Sherry Lee says, maybe you can move, but you can't move in the way that we've seen. I'm just paraphrasing you here. Y'all, please do hit the like button. I'm glad we had that debate this morning, people, because this is what we should expect to happen in the jury deliberation room. We should expect them to start debating this stuff, and we should expect people to be on one side, and we should expect people to be on the other side, at least for some of these crimes, alleged crimes, right? So Buzz says their minds are made. I'm not sure about that. Or even if they are, Buzz, what if they're made? What if half of their minds are made this way and half of their minds are made that way? So even if their minds are made, like you're saying, and I know I said that too, and so maybe you're saying it in the same way I said it, which is like they would all be in agreement. But just thinking it further, what if their minds are made, but what if they're not made the same in the same direction? Because remember, there's many different charges. So they could all be in agreement on this, but they could be 50-50 or whatever division on that. Yes, D-Hab. Of course it can. We all know that. Y'all hit the like button, please. Yes, you don't have movement after the nerve is severed. Carl says, I think it will go 5 days total. Yeah, I was thinking that they were going to be under pressure to get this wrapped up by Thanksgiving, but once emotions
Sorry,
and
Overt Act 34 is Walter Murphy, possession of firearm. Do we have, is that established by a conviction? Or am I going to need to define robbery? Okay, that may have been the only reason we were defining robbery. So we would not need to if there's a conviction in for him. So we can take that out of our jury charge.
I agree that most of them
I'm
will,
glad you pointed
not
that
most.
out, Mr. Abadi. That'll make it somewhat easier.
Some of them will come into this like, yo, I hope we could just get this over with. But once they start debating, you know what I'm saying? Oh, you got the gifted membership. That's excellent.
Look in a second.
No, the jury has not been charged. They haven't even finished determining what they're going to charge the jury. VB says it's called whatever this is called posturing. My nephew was brain dead. Sorry to hear
It
that.
doesn't look like there are any other overt acts.
And
I
still
just did a
moving for 2 months.
global search in the indictment for the term convicted felon, and that looks like those were all of them that didn't otherwise have some definition anyway.
Yeah, Andre, I get that. But again, the judge should ask, is there a precedent? Is there a court who has heard this question before and made a decision? A higher Georgia court would be the best court for her to follow. She would have to follow that, essentially. If this exact type of question came up at a higher court than she's in appeal or Supreme Court in Georgia, and there's a very similar question or the same question, she's going to have to follow that decision. So she can't just say, well, I think, you know what I mean? That's not her job. The doctor did not say no. The doctor said there cannot be any voluntary movement. She didn't mention involuntary. I think people are not making the distinction between voluntary and involuntary. Involuntary would be like, have you ever had your leg just twitch or your arm just twitch? That's an involuntary movement. You didn't do it on purpose. I just Googled it. Yes, there could be movement after spinal cord being cut due to spinal reflexes. Of course. I thought that everybody would already have known that. Maybe. So this is the type of thing that you bring into the jury room where you're like, everybody knows this. And then other people are like, well, I don't know that. And I don't even agree with it. That's why I'm starting to think that there won't be a quick verdict on this. Quick being sometime between today and tomorrow. Juror 56. Juror 56. Y'all know Juror 56 might be an alternate. This is another very interesting thing. The alternates don't even know they're alternates yet, y'all. Okay? The alternates, the people who are like, we might not even need you, who've been going to this trial every day for the last how many months, year basically, they don't even know they're alternates. And they likely won't know until after the jury instructions are given or after this whole part happens. Then it's like, you know how you're walking into the club with your friends? This never happened to me, but can you imagine, you know, all of your hot friends are walking in the club and the bouncer's like, not you. You're like, whoa, but I'm with them. Nah, we don't need you in the club. That's about to happen to the alternates. They don't even know. So everybody knows that they might be an alternate, but nobody knows who the alternates are as of now. So juror 56, the one that there's probably, what are there, 12 jurors and 4 alternates? So there's, let me see, 4 divided by 16. There's a 25% chance, if I've calculated that right, and if I haven't, y'all can correct my math. I will not debate with you unless you give me a crazy answer. Juror 56, there's a 25% chance that juror 56 isn't even on the jury. Y'all understand that? So I think that's interesting. Yeah, yes. Juror 56 might not be on the jury because remember, there are alternates, but they can't tell you you're an alternate from the jump because that could reduce your interest in and attention that you pay to the trial. So they just leave everybody in the dark as to who's an alternate so that you'll be invested. And then right before it's time to deliberate, they're like, nah, not you, buddy. You didn't make the cut. Not gonna be you, cuz. So juror 56 could very well be an alternate, people. Juror 56 could very well be an alternate. Texas Sam, hello, been a while. They will be holding my trial next. Yeah. So juror 56, if juror 56 is on the jury, then juror 56 is currently lined up. If he has personality, meaning, you know, he gives a good interview, he's lined up to make the most money as of now. Juror 56 is lined up to make good money. And I'm saying this because we talked about, you know, how much would you pay for an interview and whatnot. People talked about this. Juror 56 is lined up to be like, yo, I'm doing all the interviews. But I think when you're an alternate, everything goes down. It says in California, you know you're an alternate. I don't agree with that, by the way. Not that I disagree with what you're saying, but I don't think people should know they're an alternate. I agree with you not knowing. But also can agree with you knowing. It's just, it seems like it would cause you to pay less attention. All right, Texas Sam, appreciate you. I be fighting everybody because ain't no way you made me sit. But so somebody's got to be an alternate either way. I think the alternates are already chosen from the jump. I don't know, honestly. I don't know if they're chosen at random at that moment or if they are already pre-chosen, but they just aren't revealed. That's a good question. I don't know the answer to that. Do you think we would be here if Glanville was still a judge? No. No, everything would be different. Remember, Judge Whitaker said on the record at least 2 or 3 times she wanted plea deals, if possible. Glanville, he might have said the same thing, but no, I mean things would have unfolded differently for sure. There's a video on Facebook, and it also went around on YouTube of a guy that accidentally got shot in the head in a car by the passenger. Gun went off, shot him in the head, and he was still moving. Sammy, that's gruesome, and I'm sorry that you witnessed that. Sorry that happened to that guy. But I thought everybody would just know that automatically, but everybody's knowledge is not the same. And I don't mean that to say I'm smarter than people. I'm just saying the preconceived notions you carry into a jury room are just going to be different. I'm sure there's certain things that my preconceived notion about certain things is just way off. And y'all would know that y'all be like, man, you didn't know that? And I'd be like, no, in fact, I don't agree. And I'd be dead wrong, Kai gifted another membership. We want to thank you. Whoever gets the membership from Kai, please say thank you. I wonder if they'll choose the 4-person because they chose alternates like Bev for Karen Reed. We'll have to see. Let me just Chat GPT this. And yes, y'all, I use Chat GPT extensively. I try to use Chat GPT every single day. Chat GPT is excellent, but you do have to double check. All right, let's see. In Georgia, when in Georgia jury trial, when is the alternate chosen? From the beginning or after or later? And when and how do they choose the jury foreman? All right, so I don't know the answer to this. Okay, in Georgia, alternate jurors are selected at the same time as principal jurors during the jury selection process. This is ChatGPT. According to Georgia code, blah, 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 the court may direct that 1 or 2 additional jurors be called and impaneled to sit as alternates. These alternate jurors are drawn in the same manner, possess the same qualifications, are subject to the same blah, blah, blah. Regarding the selection of jury foreman, Georgia law does not specify a mandated procedure. Typically, after jury is impaneled and before deliberations begin, the jurors select a foreman from among themselves. So according to ChatGPT, the jurors will nominate their own foreman. Do the alternates know they're alternates the whole time? All right, so ChatGPT says that the alternates, in most cases, alternates know, they are aware that they're alternates from the beginning. I'm not convinced that that's the correct answer, but it might be. Yeah, I think they have 4 alternates in this trial. Slim Life, thank you. Yeah, sometimes when you get a lot of people, you'll get some random person who gets a membership. Could be somebody who just popped in. Juror 56 for the foreman. Well, some people have suggested that the other jurors may have already selected 56 to speak out, and that's why we heard his voice. So I wouldn't be surprised. The jurors already know which way they're going on this. So, Miss Melanated, this is a thing. And I've been saying this. I keep saying this. If they followed the instructions, if they have followed the instructions, which is not to deliberate, I would think they'd be too afraid to deliberate in the courthouse because it'd be like, yo, they might be watching us. There might be surveillance camera. I don't want to get held in contempt. So I would think they'd be too scared to deliberate.
All right, y'all continue to research. I need to go up to my chambers and see if some changes might be saved on my computer up there that aren't saved in a document down here. All right.
All right. So when the judge gets up, they have to go to the seal.
Yeah.
When the judge gets up, they're supposed to go to the seal. So I don't know that they're able to keep recording the court. They're supposed to go to the seal, but it looks like they don't care about that. They're supposed to be going to the seal now. The only rub may be RICO, but that's what I was focused on, Miss Melanated, because look how much confusion RICO is producing. I don't think we're supposed to be watching this, y'all. I think that the rule is when the judge stands up, they're to go to the seal. Sylvia said that 56 isn't what? In Georgia, jurors nominate their own foreperson, and the judge chooses the alternates before the jury deliberates. So, Valor, are you? So that's what I'm saying. So the alternates, as of this moment, don't know who they are, correct? You arguing with ChatGPT too? I'm argumentative. I'm one of those people. My wife says, "You're always right," you know, sarcastically. And I'm like, that is correct. You are actually, you're not wrong when you say that. I want breakfast, but no, Bella, the jury has not, they haven't even concluded the jury instructions yet. They haven't even concluded what they're going to tell the jury yet. Yeah, bro, it's too late. You've already said you're smarter than them. No, y'all. I'm one of the first people to say when I'm wrong. If y'all were with me when the Shamel Drinks footage first came out, I was like, I don't see how there could be reasonable doubt. Then the next day I came back and I was like, I was wrong, y'all. I was looking on Twitter, I was looking on X, and I saw all of these different people showing what reasonable doubt was. And I was like, y'all got it. I'm not one of these people who, if I'm wrong, where I'll continue to just say the same thing because I don't want to say I was wrong. I'm the first person to say I'm wrong. It's just I'm not usually wrong. That's a joke, people. I do want to, y'all, let's take a look at this. I'm going to tell y'all something. This picture of the hug between Max and Shannon, man, you know, guys act like we aren't emotional sometimes. We act like we're tough guys and stuff. But y'all, this made your boy, this touched my heartstrings, y'all. I mean, I know it was a moment, I know it was a photo, but I was like, man, this is, you know, this is wild. This is, I mean, not wild, that's the wrong word. This is emotional, it's powerful. And I heard that Hylton had hugged the families of Shamel Drinks and Donovan Thomas yesterday. So we don't want to forget them, the families, y'all. Right back at you, detective. But I saw this photo and I was like, man, this is what it's all about. I thought I was wrong once, but I was mistaken. I love that. You know what? I'm too young to talk about my tombstone, but you might have something there. You might have something there. What's my sign? Anybody want to guess my astrological sign? If y'all hear if there's anybody who really knows about astrological signs, if you really know about it, it should be one, and you've been here with me every day. No, y'all are all wrong. No. Nope. If you really know about astrological signs, it should be totally clear what my sign is. Nope. It should be totally clear. Y'all, yes. Since y'all pretty much said every different sign, I'm Aries all day, all night. Isn't Aries the most likely to be the one who thinks he's wrong? He's right. Okay, well, maybe I don't know anything about it. Buzz said Leo. No. I thought Aries was like the know-it-all. Maybe I'm wrong. I know you said Aries. I put it up. I thought Aries was the know-it-all. Maybe I'm wrong. Maybe I don't know anything about astrological stuff. But yeah. But yeah, y'all, this photo made me feel, you know what I'm saying? I didn't cry, but I could understand why somebody would. Let's put it like that. This is a very powerful photo. Very, very powerful. But yeah, your boy is Aries, I'm deep in the Aries streets. I thought Aries was like the know-it-alls. Valley, you and I were very close in birth date. We're very, very close in birth dates. Aries always get a bad rep, like if Scorpios did. Yeah, Aries probably do get the worst rep. I think Aries get the worst reps. I think we do. I think Aries get the worst rep. Aries get a really bad, and we probably deserve it. I mean, y'all hear me up here. No, April 9th. My birthday is April 9th. And I really feel like that's the best day God created. It just has the best, you know what I'm saying? It's like an excellent day. April 9th. April is like the best sounding month off the top. And then the 9 is just something special about it. You know what I mean? April 7th. Yeah, that's another good day. Yeah, I'm very nice. I'm very nice. I am a little stubborn. Hopefully I'm cool, y'all. So I don't do a whole lot of God's complete numbers, number 7. You know what, D-Hab? I wanna suggest this. And I don't want to get too far into this, y'all, but what else are we going to talk about? If y'all want to just stick around, we'll talk about some of this stuff. I would argue that the most prevalent number in the Bible of significance is either going to be a 3 or a multiple of 3. It's either a 3 or a multiple of 3. Other numbers that are very significant and prevalent in the Bible is a 40, 40. But I think 40 means a lot. I don't necessarily know that the number 40 in the Bible always means like the actual 40. I think it is like saying when we say 5011 times, you know, I think the Bible says 40 to just mean a whole bunch. But 3 and multiples of 3, so 3, 6, 9, 12, those numbers you find in the Bible way more than any kind of 7s. So I'm not really sure where the 7 thing comes in. But you find 3s and multiples of 3s everywhere. Oh, yeah, okay. Well, 7 does show up in Revelation. That's true. It shows up in Revelation, but you find 3 throughout the whole Bible. You find it throughout the whole Bible. 3 and multiples, not just 3, but multiples of 3. So 3, 6, 9, 12, that kind of thing. 3 is not a prime number. Oh, as is 3. Yeah. But 7's an important, yeah, when you bring in Revelation. Now, y'all, I'm not a big Bible scholar person. I would not be debating this with y'all because I'm not sure. But yeah, y'all, let's just keep it. Let's just make it we can just make it kind of a more general chat. 7 is used to represent completeness. I'll take your word for it. I see what you did there. I see what you did. I think I see what you did there. Yeah, so 7 is definitely in the Bible, y'all. I'm not saying it isn't. I'm saying I think 3 and multiples of 3 is more prevalent throughout the entire Bible, but 7 is definitely there. I'm not saying it isn't. Aries are fiery, argumentative debate type. If you haven't noticed, yes, 7 days. That is correct. 7 days and 7 nights. Pastor, what would the mortician say? They would say yes, right? I think you're saying that they would say yes. Y'all be interested to have like a true stream about zodiacs and stuff, and even the Bible, but it's just, you know how people get, some people are very sensitive about that stuff. We would have to be able to be very open and very open-minded in order to do that. And I'm not sure that that this is the place, but that would be very fun. You know, that would actually be very fun to have a Bible and zodiac like mixed, and you know, and all of that stuff mixed into one stream. Yeah, I'm saying it would be fun to do it apart as its own thing. That's what I'm saying. I agree with that. That is what I'm saying. Maybe we'll do that. Maybe if I don't know how many people want to pop in on that, but Zodiac and Bible don't mix at all. So that I'm just gonna not say anything about that. I'm just not gonna say anything about that, because if I do, I'm gonna get myself in trouble. Maybe we'll do a separate stream at some point, and we'll be able to discuss whether they mix or whether they don't. All right, y'all. So I'm gonna move us back onto topic, because I don't want to, I don't want to go too far off into that. But it would be a very, very fun stream. It would be fun, and I think it would be. And see, that would take me down a different path. You know what I'm saying? That would take me down a different path. That would take me down a whole nother path. All right, y'all, since we don't have any court right now, I think we maybe could gain some knowledge going back to try to listen one more time to this back and forth about the overt acts, etc., etc. Etc. I will say this. See, y'all are drawing it out of me. Y'all are drawing it out of me. Okay, I'm not going to say it. I almost said something. I was this close to saying something, but I'm going to stay away from it. I'm going to stay away from it. I was very close, though. I was very close. Let's go back and review this beginning part, because this is what they're supposed to be researching right now. Okay?
Are the last things we need to take a look at. So if we want to just walk through those, I guess maybe the verdict forms are the easiest thing to look at first.
So we are re-watching this in order to get a sense for the controversy that they should be
Y'all just
working
let me
on
know.
right now. So
Go
we're
sleep,
trying to just
okay?
better understand the question that they're working to answer right now. Okay.
Yes, final docs, charges, etc. from about 6 yesterday evening. And it attaches each verdict form, the redacted indictment, which we definitely need to still address some things on. And then the jury charges may change based on what we do with the indictment. So let's just look at the verdict forms first. And hopefully those are actually in final form.
This is minor, Your Honor, but do we need an entire page for the
Well,
overt acts, or is that just a
Here's
good way
the
to break
thing
it?
is I thought about doing some lines, but then I didn't want y'all saying, well, if you put 10 lines, that implies that they should find lots of acts.
I love how
So
she said, I
if
thought
we have
about
blank
doing some
pages-
lines.
Acts.
Yo, would that be another good judgment? Yo, Judge Whitaker has been tons of fun for me. That would be a good t-shirt. I thought about doing some lines.
Or is that just a
Here's
good way
the
to break
thing
it?
is
Oh my gosh.
I thought about doing some lines, but then I didn't want y'all saying, well, if you put 10 lines, that implies that they should find lots of acts. So I thought if we have a blank page, it is literally a blank slate, and they can put nothing, 173, it'll be up to them. So that was my thinking.
Well, I certainly prefer that to the lines. So,
Okay.
but it's
All
very
right.
difficult to please us.
All right, then that's why it's there.
Well, Your Honor, as you know, the state would prefer the lines,
Mm.
but given that you've made it clear, you sort of made your mind up on this issue, I think that this is the most appropriate middle ground. The way it was before implied that there would be very few or any. And this is, as you said, it's a blank space.
Okay. All right. So any other items? All right.
And I don't know if it's the same thing as the Sharp standing up. On Mr. Stillwell's verdict form.
Yep.
For count 49 and count 52, just for consistency, I would put the not guilty first and then the guilty.
I agree. Don't know how that one happened. Ms. Persfield, can you switch those around? Thank you for that catch.
Y'all, I really do think that these ninjas be lacking is maybe the one and only piece of merch that I really have in mind. Somebody said that yesterday, and I was like, yes, because I was like, what kind of merch could I do that's not exploitative of the families, that's not exploitative of the witnesses, that's not exploitative of the defendants, that's not, that's just total fair game. I could certainly do merch for PIW, Paralegal Institute, but what YSL trial merch could I do? And I think, and also you wouldn't want to, you want to be somewhat respectful of people. I definitely think having Judge Whitaker doing the nose wipe. I think Judge Whitaker doing a nose wipe saying y'all ninjas be lacking is fair. It's totally in the public domain. I don't think it's exploitative of anybody. And that merch could possibly be coming, y'all. Y'all ninjas be lacking with a nose wipe in Judge Whitaker. I think that is totally within the public domain. It's fair. It's not exploiting anybody. And that could be on the way. That could be on the way.
Yes.
I don't think you should be putting the victim's names.
Why? I mean, if you're going to object, you need to give me a reason.
Because, I think it's clear what the two counts are. If we put a date on it, I wouldn't necessarily have a problem with it. I mean, I think it's clear that my client's trying to merge.
Good question. Dead spot. It is definitely a good question. I mean, I don't care, but other people might. I hadn't thought about that. Hadn't crossed my mind. It's not a concern of mine, but other people are other people.
I think it's necessary to put the victims' names next to each count.
All right, well, I appreciate that objection. I overrule it.
See, that I don't
All right, anything
recall
else?
that. Listen, personal. Okay, one time I asked Thugger Daily, why don't you make Thugger Daily merch? I was like, yo, I want a mug and a hoodie. I'm talking about Thugger Daily, you know, Thugger Daily. And Thugger Daily was like, well, I don't want people coming at me saying I'm, you know, exploiting or whatever the term Thugger Daily used. And I think that's sad, y'all, that there are people out there who would say, and I think Thugger Daily is right. There are people who say, oh, you're trying to exploit. No, not if you make Thugger Daily merch. But I think once you get into the I don't recall, I'm not going to say you're exploiting anybody because I frankly don't care. I mean, I do care if you're exploiting people, but I wouldn't care if this is what it is. But that is a Woody catchphrase, and it is kind of going more into that, you know, you're kind of, that's something he's known for. So while I don't care, I could see people caring more about the I don't recall thing, because Woody he's a private citizen. He's an individual. He was forced to be on the stand. He was forced to testify. This is not his job. He was wrapped up in it. So yeah, I know AV has it. And again, I'm not coming at AV. I think it's totally fine. But I think if someone had a criticism, I don't share it, but I wouldn't do it because of those criticisms out there with the I don't recall. Again, I think it's perfectly fine. And I hope she sold a bunch of them. But I'm going back to what Thugger Daily said. Like, Thugger Daily has a brand now. Like, Thugger Daily should make merch, in my opinion. I literally asked, hey, you got merch? Because I want to buy some. And Thugger was like, nah, because of what people might say. I'm like, yo, who cares what those people are going to say? This is your brand. You know what I'm saying? This is you made this. You feel me? So yeah, AV, she has the shirts. I hope she sells a million of them. AV's great. And frankly, on some level, you just have to not care because people have stuff to say. You know what I'm saying? Sorry, I keep pausing, y'all.
It's on Mr. Stillwell's verdict form. All right, hearing nothing, we will move on to Mr. Kendrick's verdict form. And it's possible that I don't know if we have a guilty, not guilty reversal on that one, but if we do, we'll
it's correct on that one.
Okay.
Or consistent. Let's use that word,
Okay.
consistent. You're right.
Yeah, I can see that. Again,
anybody have any issues?
I'm more talking just about what people say. I'm not one of the people who has a problem with that. You know, I'm not one of the people who has a problem with that. So, but it is this has become a very, like, one day I went on a rant where I'm like, you know, some people find if you use the word entertaining about this trial, like, people are fighting for their lives. You shouldn't say this is entertainment. While I do agree, using the word entertainment is wrong because that kind of characterizes the trial as a whole. To say certain things that happen in the trial are entertaining, of course they are. Of course, there's many different entertaining moments, but the trial itself is not entertainment. So I'm with that too. It's not here for us to be entertained. But as we watch, we see things that are funny. We see things that are entertaining. We see things that are tragic and sad. You know, it literally has a little bit of everything. It has ups, it has downs, it has so many confusing moments that you're like, yo, I literally don't even know what I'm seeing or hearing right now. You know, we played yesterday with the gang expert who replaced Dennis, and you're just like, what am I even watching? Like, what is even going on? You know what I mean?
That verdict form. I guess maybe you could on the, I don't know why it's not showing up on mine.
YSL is
I
definitely
have
copywritten.
lines under this blank.
Remember, YSL
But
is
it looks
Yves
like
Saint
they were
Laurent.
on yours, Ms. Persfield, so as long as they're there. Okay, all right, so looks like at least the verdict forms are in their final form. The redacted indictment, and as y'all can see, and from the email, I determined that Overt Act number 175 shouldn't be in there because it seems to not assert one of the necessary elements to have made that a crime.
Yes, Your Honor. I understand the thinking behind it, but I don't think that's consistent with Georgia law. I think we've already established and the court has recognized an overt act doesn't have to be a crime. And therefore, we would not have to have all the elements present.
You are asserting the crime of, did commit the felony offense of whatever, OCGA section whatever, so.
That was the first part. Second,
Okay.
second part is this. Under Georgia law and federal law consistent as well, the state does not have to allege all of the elements of an overt act that does happen to be a crime because it is not separately charged. The pleading rules are not the same. You can't generally demur to an overt act. And so it's, while it might not be adequate as a freestanding charge, as an overt act telling the jury what we are saying was done, that would still be sufficient. All they don't have to decide it's a crime. They just have to decide it's an act in furtherance of the conspiracy because they're not separately convicted.
I don't agree. If you have law that is on point, show it to me. But if you are asserting he committed the felony offense of possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm, and you cite 1611-133, one of the essential elements of that is that he's possessing it while he's committing a crime. And y'all don't assert that.
I understand, Your Honor. As far as it not needing to be a crime, Yates versus United States, 354 U.S. 298.
That says if you assert it as a crime inside a statute, it still doesn't have to be a crime? I know an overt act doesn't have to be a crime. Are you saying that Yates is going to tell me that if you assert he committed X crime, you don't have to actually be asserting a crime, even though you're saying pursuant to XYZ statute?
Thank you, Queen, Grandma Rocks. And I'm learning a lot as well.
I'm not representing to the court that Yates says all of the additional things you said. I don't have a side off.
The jury should be there now. I think 11 o'clock was the time it's supposed to be there.
Well-established federal case law, for example, that if a defendant is charged, let's say count one is conspiracy, and there is an alleged overt act, that overt act is also alleged as count two, independently.
Right.
The defendant could be acquitted of count two because the jury finds an element of that separate charge was not found, but it still functions as an overt act in furtherance of the conspiracy, especially when, like the ones we're talking about here, there's more than one actor involved.
There's not here for 175. There's only Mr. Nichols.
Okay. I still don't.
All right. Again, if you find some law that is on point.
I want to talk about this real quick. I did see this. And when I say see this, I didn't see her do it. I saw that somebody reported that this happened. And the first question is, did the jury see that? Which I think would be totally inappropriate. So I don't have a problem that this happened as long as it's outside of the view of the jury. If this is in the view of the jury, well, what can you do now, right? But I would say this is totally inappropriate for the jury to see. If the jury's out, I don't have a problem with this. So that would be my main question. This actually influenced my original topic that I started off today talking about, saying I feel bad for Hylton, because I think Hylton, you know, kind of going back to the topic I started this stream off with, I think she laid it all out. I think she, at some point, either before or during, she decided or she understood that this is for all the marbles, and she put it all on the line. I think most of us here at home felt she didn't do it correctly, but we don't know what the jury thinks. And I said that this morning. I said, we are not in that courtroom. We don't have the same perspective as a juror. We just don't. So she was connecting with the jury, or she wasn't. She was able to see them. She was able to gauge their interest. Probably she was able to gauge their level of attentiveness. And I would think that if she felt she was just totally losing them, she would have modified what she was doing, but she kept doing what she was doing. And so I imagine she felt she was getting across what she wanted to get across, and that they were receiving it. That's what I imagine. We here at home, we have our own perspective. We're watching it usually individually. We're normally not with other people. We already have a certain feeling about the state's case. And so the way we receive it is totally different. I'm imagining. But you're saying the state has self-awareness. She's a human. You know, if you're talking to people and they're yawning and rolling their eyes, you know. Yeah, that's gonna be it's gonna be wild to hear. I guarantee, well, I'm not gonna guarantee, but we're gonna hear different reports for sure. Meaning different jurors will have seen things differently. And I think there's obviously going to be jurors who will have seen things similarly. Thank you so much for the super, Gary.
Your Honor, we've located some authority on main case versus Elliott 571, F second 880. It's a former Fifth Circuit case. Elliott dealt specifically with the question where the defendant argued that acquittal on a RICO substantive required acquittal on a RICO conspiracy. And the court said no, it did not.
Yeah, that's not.
It's an often, it draws the distinction. But that being said, we are looking at the changes that were just forwarded to us, and think that for the vast majority of these, there may be a pretty simple, direct workaround that addresses the issues we talked about.
Okay. Well, I'm not sure we need to decide it before the jury charges anyway, so. All right. Anything else then? Otherwise, I'm gonna have the jury out and go ahead and charge them.
I saw that too, Nicole.
All right, let's get the jury out.
This is what I've been waiting for, y'all. How is she gonna explain all of this craziness to the jury? Nicole. Who's Nicole? No, divinity. They are bringing in the jury to give them the instructions by which they will arrive at a verdict. So y'all, what's about to happen is the judge, I believe, is about to give the jury the instructions by which the jury will be able to come to a conclusion, to a verdict, to a decision on the different counts. Your name comes up in green if you are a member of the channel. Where's Miss Lily today? She's going to read it, and they will have the instructions to read while having all that non-evidence. Correct. We have sound, so there's no sound on in the court right now. Yeah, again, I'm not in favor of being able to do that in front of the jury. Yeah, they're going to charge the jury. Y'all, I imagine this is very tense for them and very maybe even stressful. Doug's talking to Kokomo. Yo, no sound? What the heck? They're bringing the jury in to charge them, but they don't have any sound. Yo, they turned the sound off. Yo, these people, I don't know what the heck. Yo, she's giving the freaking instructions. Turn the sound on. Y'all, there's no sound coming from the court right now. I have my headphones on another feed, and I'm watching, and they just don't have sound on right now. So it is what it is. This is like one of the most important parts, and they have no sound right now. I'm gonna
Violation of the Georgia Controlled Substances Act, 61, possession of a firearm during the commission of a felony, and 63, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Mr. Stillwell has been indicted for counts 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act. 2 and 49 are counts of murder. 50, participation in criminal street gang activity pursuant to subsection 1 of that statute. 51, participation in criminal street gang activity pursuant to subsection B of that statute. 2 counts of possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm in counts. Those are counts 52 and 64. And then count 54, which is possession of a firearm during the commission of a felony. You will have a copy of the indictment with the relevant charges with you during your deliberations. Each defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The instructions that I give you will apply to each defendant individually. So when I say the defendant or a defendant, the instruction applies equally and separately to each defendant. Further, your determination of the issues set forth in the verdict forms must be made as to each count and as to each defendant individually. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a reasonable doubt is the doubt of a fair-minded and impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt. It's a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If after considering the evidence, you believe beyond a reasonable doubt that a defendant is guilty of an offense alleged in the indictment, you would be authorized to convict the defendant of that offense. If the state fails to prove the defendant's guilt of an offense beyond a reasonable doubt, it would be your duty to acquit the defendant of that offense. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes the testimony of the witnesses, the exhibits admitted during the trial, and any stipulations of the attorneys, which are facts to which the attorneys have agreed. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations about certain facts, and these 4 stipulations are marked as joint exhibits. Where parties stipulate facts, that is in the nature of evidence, you must take that fact or those facts as a given without the necessity of any further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Direct evidence is is that which can be seen or heard or otherwise directly sensed. It may be brought into court in the form of exhibits or the testimony of a person who asserts that he or she has actual knowledge of a fact by personally observing or otherwise witnessing that fact. It is evidence that points immediately to the issue in question. When direct evidence points by inference to an obvious, likely, or reasonable conclusion, even though that conclusion is not directly observed or otherwise sensed, that's said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that tends to prove or disprove another fact by inference, that is, with consistency with such a fact or elimination of other facts, or that only tends to establish a conclusion in question by its consistency with such conclusion or its elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence alone, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or a greater degree of certainty on the part of you, the jury, to return a verdict based on circumstantial evidence than upon direct evidence. There's no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. And whether it's dependent upon direct or circumstantial evidence or both, the true test is whether there's sufficient evidence, whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. You, the jury, must determine the credibility of the witnesses. In deciding credibility, you may consider all of the facts and the circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or their lack of interest in the case and the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are witnesses who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility, and this may include evidence of a character for untruthfulness, bias toward a party, or felony criminal convictions. In determining the credibility of any witness whose credibility has been attacked or challenged, as I've described above, and any testimony given by him or her in court, you may consider, where it's applicable, evidence offered to support the credibility or believability of such a witness. The credibility of a witness may also be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony that the same witness gave before the trial started. It's for you to decide whether there's a reasonable explanation for any inconsistency in a witness's pretrial statements or testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if that is shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of all of the witnesses. The testimony of a single witness, if believed, is generally sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. An exception to this rule is made where the witness is an accomplice. The testimony of an accomplice on its own is not sufficient to warrant a conviction. An accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused, independent of the testimony of the accomplice. It's not required that supporting evidence be sufficient to warrant a conviction, or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act, and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all of the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The testimony of one accomplice may be supported by the testimony of another accomplice. Whether or not the testimony of one accomplice does in fact support the testimony of another accomplice is a matter for you to decide. The sufficiency of supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is also a question for you to determine from the evidence in this case. Any out-of-court statements made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only against the particular defendant who made it. A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, a defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose or against some parties and not others, or for some counts and not others. I have previously instructed you as to how to consider particular evidence that was limited over the course of this trial. Such evidence may be considered by you only for the sole issue or purpose, or against only the party, or only for the counts for which that evidence was limited, and not for any other purpose or against any other defendant or for any other counts. You have received evidence of certain prior convictions of these defendants as well as certain other witnesses in this case. You may consider the conviction of Mr. Kendrick only against Mr. Kendrick and only as to count 1 and as to the required element of being a convicted felon in count 63. You may consider the convictions of Mr. Stillwell only against Mr. Stillwell and only as to count 1 and as to the required element of being a convicted felon in counts 52 and 64. You may consider the convictions of any witnesses only insofar as they may relate to attacking the credibility of that witness and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. In addition, some but not all of the factors you may consider in assessing the reliability of any identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify that person as the alleged perpetrator, and the length of time between the crime and the out-of-court or any out-of-court identification. It's for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify someone beyond a reasonable doubt as the alleged perpetrator or a party to an act. It is not necessary that the defendant show that another person committed the alleged act. The burden of proof never shifts to the defense. Defendants are charged with crimes against the laws of this state. A crime occurs when a law is violated by a defendant's intentional action. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe it existed from the facts proven before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a criminal statute, but it simply means the intention to commit the act that is prohibited by a statute. A defendant will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Whether or not you make any inference or inferences such as that is a matter solely within your discretion as the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crime of murder, that's counts 2 and 49, possession of marijuana with intent to distribute, count 58, or possession of a firearm, counts 52, 54, 61, 63, and 64, was being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt in order for you to convict on those counts. If you find from the evidence in this case that the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who is merely present at the scene of the commission of a crime at the time it was committed guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor. You are not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of a crime, unless the evidence shows beyond a reasonable doubt that the person helped in the actual perpetration of the crime or participated in the criminal endeavor. Next, I'm going to define for you the elements of the crimes that are alleged as counts against either defendant. Then I will define the meaning of any crimes that are alleged as an overt act, but that I have not yet defined. When a count of an indictment charges that a defendant committed a crime in more than one way, the state does not need to prove that the defendant committed the crime in every one of the ways alleged. The state may prove that the defendant committed the crime in any one of the ways charged. If the evidence shows that the crime was committed by the defendant in any one of the ways charged, you would be authorized to convict him of that count. And RICO is one of the counts that is charged as having been committed in more than one way. In order to convict, the state must prove that the crime was committed by the defendant in at least one of the ways charged. For conspiracy to violate subsection A of the Racketeer, Influence, and Corrupt Organizations Act, which I'm going to refer to from now on as the RICO Act, the state must prove that the defendant knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the co-conspirators committed an overt act after May 10th of 2017 to further a criminal objective of the conspiracy. For a conspiracy to violate subsection B of the RICO Act, the state must prove that defendant, while associated with an enterprise, knowingly and willfully conspired with one or more others to participate in the enterprise through a pattern of racketeering activity, and that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. Conspiracy means an agreement between at least two people to commit an unlawful act. The agreement may be express, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish or to pursue a common criminal objective. The existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state does not need to prove that each conspirator agreed with every other conspirator knew all of his fellow conspirators, was aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator. Whether a conspiracy existed is a matter for you to determine. Overt act means an outward act made in furtherance of a conspiracy. The overt act may, but does not have to be, a crime in and of itself. Some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are when you have the indictment back with you, because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined when I'm defining the substantive counts. Enterprise means a group of individuals who are associated in fact, whether or not all of the members know each other. To be an enterprise under the RICO Act, the group must have a common purpose and ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity. The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats, use of an item with an altered identification mark, possession of a firearm during the commission of a felony, possession of a machine gun, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, possession of a weapon by an inmate, possession of a cell phone by an inmate, possession of codeine with intent to distribute, possession of hydrocodone with intent to distribute, possession of marijuana with intent to distribute, possession of MDMA with intent to distribute, possession of methamphetamine with intent to distribute, possession of cocaine, or possession of oxycodone. I will define these crimes for you shortly. Racketeering activity also means any act or threat that involves murder, robbery, theft by receiving stolen property, or dealing in narcotic or dangerous drugs. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The criminal objectives of the conspiracy alleged here are preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, obtaining money, weapons, or other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs, and obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. A person commits the offense of violation of the Georgia Street Gang Terrorism Prevention Act, which I'm going to refer to from now on as the Gang Act, when that person, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. To prove a violation of subsection A of the Gang Act as alleged in counts 50 and 57, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang. To prove a violation of subsection B of the Gang Act as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang. That is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity. For malice murder, the state must prove that a defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation, and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to show premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state may, but does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For possession of a firearm during the commission of a felony, the state must prove that a defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is one of the following: a crime against or involving another person, or a crime involving possession of marijuana with intent to distribute. Murder and possession of marijuana with intent to distribute are felonies, and for purposes of this offense, a firearm includes any handgun. The indictment charges each defendant with possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. I am not going to charge you on that crime because the state concedes that the description of the crime in the relevant counts of the indictment left out an element of either the defendant having previously been convicted of a felony, or of the defendant having previously been convicted of a felony involving the use or of possession of a firearm. That should be or. So you will be considering only the lesser included offense of possession of a firearm by a convicted felon when you get to those counts. And for possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. And again, for purposes of this offense as well, a firearm includes any handgun. For possession with intent to distribute marijuana, the state must prove that the defendant possessed any amount of marijuana with intent to distribute. Intent to distribute means intent to unlawfully deliver or sell. Marijuana means all parts of the plant of the genus cannabis, whether growing or not, the seeds, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds, or its resin. Marijuana does not include the completely defoliated mature stalks of such plant, fiber produced from such stalks, oil or cake, or the completely sterilized samples of seeds of the plant which are incapable of germination. And it does not include hemp or hemp products, and it does not include samples of tetrahydrocannabinols or THC. The state must prove that the defendant possessed the marijuana and or the firearm at issue in this case. Possession may be either actual or constructive. It also may be either sole or joint. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the marijuana or over the firearm, depending upon which count you're considering. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the marijuana or the firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana or the firearm. Sole possession means that only the defendant had possession of the marijuana or the firearm. Joint possession means that the defendant shared possession of the marijuana or the firearm with at least one other person. If you find that someone other than the defendant had an equal opportunity to possess the marijuana or the firearm, you would be authorized to convict the defendant only if the state proves that the defendant knowingly possessed the marijuana or the firearm. And I'm now going to define for you any alleged crimes that are alleged in the overt acts that I have not already defined in the substantive counts. So the following definitions apply only to certain acts that are alleged in count 1 of the indictment as overt acts. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the alleged perpetrator assaulted another person with a deadly weapon. Assault means to commit or to attempt to commit a violent injury on the person of another. And to prove assault, the state doesn't have to prove the other person was actually injured. However, the state must prove that the alleged perpetrator attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Aggravated battery. For this crime, the state must prove that, for aggravated battery, the state must prove that the alleged perpetrator maliciously caused bodily harm to another person by seriously disfiguring a part of the body. In deciding whether or not an alleged perpetrator acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. For armed robbery, the state must prove that the alleged perpetrator took another person's property from the immediate presence of the other person by using an offensive weapon and with the intent to commit theft. An offensive weapon is an object that's either likely to cause or actually does cause death or serious bodily injury if it's used against someone. Conspiracy to commit murder. A person commits conspiracy to commit murder when that person conspires with one or more others to commit the crime of murder. Murder has been previously defined. Criminal attempt. A person commits criminal attempt to commit a crime when, with the intent to commit that crime, the person performs any act that constitutes a substantial step towards the commission of the crime. Criminal gang activity has been previously defined. Criminal use, a person of an article with an altered identification mark. A person commits the offense of criminal use of an article with an altered identification mark when he possesses a firearm from which he knows that the manufacturer's serial number or any other distinguishing number or identification mark has been removed for the purpose of concealing or destroying the identity of that article. Possession of a firearm by a convicted felon has been previously defined, but in addition, with regard to that offense, possession of MDMA with intent to distribute, possession of cocaine, and robbery are felonies. Possession of a firearm by a first offender probationer. For possession of a firearm by a first offender probationer, the state must prove that the alleged perpetrator possessed a firearm while on probation for a felony as a first offender. Robbery and criminal damage to property are felonies. Possession of a firearm during the commission of a felony has been previously defined, but in addition, for these overt acts, possession of codeine with intent to distribute and possession of cocaine are felonies. Possession of a machine gun. The state must prove that the alleged perpetrator possessed a machine gun during the commission of any of the following offenses: participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine. A machine gun means any weapon which shoots or is designed to shoot automatically more than 6 shots without manual reloading by a single function of the trigger. Possession of controlled substances. For possession of cocaine or oxycodone, the state must prove that the alleged perpetrator possessed any amount of cocaine or oxycodone, both of which are controlled substances. Possession with intent to distribute. For possession with intent to distribute codeine, hydrocodone, marijuana, MDMA, or methamphetamine, the state must prove that the alleged perpetrator possessed any amount of marijuana or any amount of codeine, hydrocodone, MDMA, or methamphetamine, which are controlled substances, with intent to distribute. And intent to distribute means intent to unlawfully deliver or sell. Sale of marijuana. For sale of marijuana, the state must prove that the alleged perpetrator sold any amount of marijuana, and sell here means to transfer marijuana in exchange for money or anything else of value. Possession of a weapon by an inmate. For possession of a weapon by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized weapon. For possession of a telecommunication device by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized cell phone. Conspiracy to possess a telecommunication device by an inmate. A person commits conspiracy to possess an unauthorized telecommunication device by an inmate when that person conspires with one or more others to commit the crime of possession of a telecommunication device by an inmate. For terroristic threats, the state must prove that the alleged perpetrator threatened to commit a crime of violence and that the threat was made. Theft by receiving stolen property. A person commits theft by receiving stolen property when that person receives or keeps stolen property and the person knows or should have known was stolen, unless the property was kept or received with the intent to restore it to the owner. Knowledge on the part of the alleged perpetrator that the property was stolen, or evidence sufficient to show beyond a reasonable doubt that the alleged perpetrator had reason to know the property was stolen, is an essential element of this offense. Knowledge that the property was stolen may be shown by circumstances that would excite suspicion in the mind of an ordinary person. The burden is on the state to prove beyond a reasonable doubt that the alleged perpetrator had knowledge, or under all the circumstances should have had knowledge, that the property in question was stolen and was in the alleged perpetrator's possession. All right, that's it for the overt act crimes. All right, the law provides that criminal action shall be indicted and tried in the county in which the crime was committed. In a prosecution in any case in which it can't be determined that what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt it might have been committed. We don't have that here, do we? So essentially just the state must prove that the criminal actions alleged as counts in this case, that they have to be tried and indicted and tried in the county in which the crime was committed. So venue, that is that the crime was committed in a particular county, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Venue may be proven by direct or circumstantial evidence or both. To prove venue for the RICO count, the crime is considered to have been committed in any county in which an incident of racketeering occurred, or in which an interest or control of an enterprise or personal property was acquired or maintained. The defendants are each charged with certain offenses that are set forth in various counts of the indictment. Each count is a separate and distinct offense, and you must independently evaluate the evidence against each defendant and as to each offense. The fact that you reach a conclusion with respect to one offense or with respect to one defendant does not necessarily mean that the same conclusion will apply to any other charged offense or to another defendant. Each count of the indictment before you is separate and distinct. You must evaluate evidence as to one count independently from evidence of each other count. You must evaluate the evidence as to each defendant independently, and you must render a verdict as to each count and as to each defendant individually. If, after considering the testimony and the evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant in Fulton County, Georgia, committed an offense as alleged in the indictment, you would be authorized to define the defendant guilty of that offense. In that event, the form of your verdict for that offense would be to find the defendant guilty. If you do not believe the defendant is guilty of an offense as alleged in the indictment, or if you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense. In that event, the form of your verdict for that offense would be to find the defendant not guilty. You are to make a separate determination of guilty or not guilty as to each offense and as to each defendant. Your verdict as to each count must be unanimous. That means that you must be unanimous in your determination that the state has proven every element of that count as defined and listed above beyond a reasonable doubt. And you'll have a copy of these instructions out with you so that you can see what each of the elements of each of the offenses is. Again, the elements are listed above where the crimes are defined, and you must be unanimous that each element has been proven. Let me explain what that means for a few of the elements for count one a bit more specifically. And that's the conspiracy to violate the RICO Act. You must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. But because count one is charged as a conspiracy to violate the RICO Act, it's not required that the state prove that any conspirator actually committed an act of racketeering activity. And on the overt act element, you must be unanimous that a conspirator committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. And you would note on your verdict form that and any of other overt act committed in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of either defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against any party. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it's wrong. However, you should never give up an honest opinion simply to be congenial or to reach a verdict solely because of the opinion of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. And these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. During your deliberations, any communications from you to the court must be in writing, signed and dated by the foreperson, and given to a bailiff. And let me add that given that the evidence is closed, my ability to respond to questions may be limited. Evidence that was admitted by audio or video recording can only be played here in the courtroom, so any request to review or listen to that evidence again must be made in writing by you to the court, and then it'll be replayed in the courtroom. And that is the end of my instructions. I'm going to excuse you all to the jury room now to elect your foreperson. Don't begin deliberations until you have the indictment, the evidence, and the verdict forms and some copies of this charge out with you. And I'm going to ask jurors number 387, 409, 449, and 508 to hang back with me. And the rest of you can return to the jury room to elect your foreperson.
All rise for the jury.
All right, y'all are the alternates in the case. Considering the length of this trial, it was critical that we had alternate jurors in case we lost any jurors. And as I think y'all know, we in fact started with 2 more of you and lost 2 along the way. I don't know how long deliberations are going to take. And so it's possible that even now we may end up losing a juror or more. So y'all are still on jury duty. You're not going to be deliberating right now, but you continue to be under all of the instructions that have been applicable to you for the entirety of this trial. You cannot discuss this case with anyone. You cannot allow anybody to discuss the case with you. You cannot go now and look up any articles about this case or anybody involved in it. You can't look at any kind of social media or any other kind of accounts of this trial or anybody involved in the trial. Essentially, you're still on jury duty. I am going to, for the next hour or so, keep y'all around here. And Sergeant, maybe, I don't know, I'm sure there's probably another jury room that they can retire to. While y'all are on jury duty and the jury is deliberating, I want y'all to stay within an hour or so of this courthouse. If we're ever on a break, we've got Thanksgiving break coming up. Obviously, y'all can go and do whatever your Thanksgiving break plans were, because the jury's not going to be in session, court's not going to be in session, we're not going to be deliberating. But even when you're on those breaks and any others that might occur during the deliberation process, you still can't talk to anybody about the case or allow anybody else to talk to you about the case or look for any information in any way about the case. So essentially you remain on the same instructions. Just when we're on break, you're on break too. When the jury is deliberating, I need y'all to be where, if we need you, we can get you within a goodbye. It's been great. I may see you again, to your fellow jurors, and then we'll have you in one of the other jury rooms for a little while at least. And if I'm going to release y'all for the day, I'll let y'all know that. But again, just kind of stay within an hour or so of the courtroom. And just like you've sort of kept your cell phones in a way that we can communicate with you, continue to do that in case we need to. Thank you very much.
So there could be a verdict today in theory, y'all.
Are there objections to the charge? Okay. On page 2? Okay.
When reading participation in criminal street gang activity for count 50, you said subsection 1 and not A. So I just wanted to
Hang on a second. Let me get there. Page. Where are you talking about?
So count 50, where it has participating in criminal street gang,
Yes.
you said section 1 and not A.
Okay. Do you want me to call them all back in and say I meant to say A, or they'll have copies of this out there and it'll be on the verdict form correctly?
Yes, Your Honor.
All right.
That's fine. I didn't know if I had something different than what you had, and so I wanted to make sure that what I have in front of me was correct.
Okay.
Only as to page number 9, when you last paragraph, any out of court statement.
Hang on. Yes.
As we were reading it, the thought came that maybe we should add any out of court statement made to law enforcement or made to the police, made by one of the defendants on trial in this case after the alleged criminal act.
We probably should have.
So just
I gave y'all this, I don't know how many different times to look at and ask you. I don't know how many different times for any kind of comments or corrections. So what do you want me to do?
can we add it, and then when you send it back,
Just, sure.
that's all, Your Honor. I'm just going back.
Made by one of the defendants, made to law enforcement by one of the defendants on trial?
Yes, Your Honor.
Okay, we can do that.
And as of right now, those are the only ones that I see.
All right, appreciate it. Thank you. Anybody else?
I have no objections to your reading of the jury charges, Your Honor. I just need to renew my request and objection to exclusion of jury charge 3.01.10, which is the justification, as I requested justification for my client's possession of firearm by a convicted felon. I requested that charge, so I'm just renewing my objection to the exclusion of that charge, as well as the separate and distinct charge
that overt acts need to be proved. An overt act needs to be agreed upon unanimously by all the jurors. I know Your Honor stance that you referenced the need for unanimity, being unanimous. I always struggle with that word.
Okay.
Within the jury charges, and I understand that, but I'm just going to renew my objection.
Okay.
Thank you.
All right. Then we will, y'all have agreed as to what evidence goes out?
Yes, Your Honor, there is we're including a flash drive with a list of the exhibits, the Stillwell exhibits.
Okay.
And I thought it would be appropriate, and if it's not appropriate, please object. It's just a list of the exhibit numbers, because the flash drive is little, so we can't list them all. So we're printing on a piece of paper,
Okay.
and we're just going to attach the flash drive to the piece of paper.
Okay. And those don't go out. You're just saying you're listing them.
My understanding, well, they can't play them. My
Right.
understanding is that all the media was going to go in the back room. They can't play it, but then they could ask if they wanted us.
Just so they'll have a list of what it is?
I'm not even proposing a list of what it is, as in what each exhibit is, but just that these are the exhibits that are on this flash drive. I'm not suggesting.
We don't normally send the actual media out with them.
Okay,
I mean, they
had
can,
this-
it's certainly in evidence and they certainly can consider it. They just would need to say, hey, I'd like to watch the FedEx tape again.
Okay, my understanding, I had spoken to some members of the state about this. The understanding I had was that the media was going to go out, but of course they have no way to play it, but then they could request.
Okay, are they gonna even, if it all, for instance, goes out in a bin, are they gonna even know what it is? Like, are they all labeled? Yes? I mean, it's fine with me if that's the way y'all want to do it.
The only other thing we were going to ask to do, and I believe the defense counsel has an objection, we were going to send a legend out with the letters and what letter is associated with what act, so that they would know.
What
We've
letter
organized
is-
them.
I don't know what you mean by that.
So every act that we presented, so for example, VV was the Chamel Drinks homicide, so that they could know when they pick up a letter, what that was in reference to.
I'm going to object to that, to the state's kind of direction of compartmentalizing the evidence. And quite honestly, some of the evidence that was admitted under certain letters applies to certain other cases. I mean, these aren't distinct. I know that they're charged as distinct overt acts, but Walter Murphy testifies, for
Right.
instance, and he has things they admitted to Walter Murphy might have a WW, just for instance, but what he testified to involved different acts.
I mean, I think that as they were listening to the evidence, they could write down the number of the exhibit. So if they want to flip through their notes and say, you know what, I was really interested in 53 WW, then they can find that, or if it's media, they can ask to re-listen or replay it. I don't think that it's really appropriate to say, here's kind of the state schematic of the evidence. Okay. So have y'all otherwise agreed on what evidence goes out with them and what evidence doesn't?
So I've been presented some case law this morning, and we've discussed it. I don't have any problem with the GBI reports going back. I know that was one bone of contention. I don't have any problem with the ME reports going back. We've been going back and forth about two issues: the CAD reports and the demonstratives. I'm objecting to both the CAD reports and the demonstratives going back.
Okay. You wanna?
I join in.
Okay. All right. Does the state feel that the CAD reports or the demonstratives should go out?
Yes, Your Honor, we have case law regarding demonstrative evidence.
Okay.
that the market does go back to the jury, and it's not a violation of the continuing witness rule.
Would you like to share that with the court?
Yes, Your Honor.
Okay.
The state will cite Ruffin v. State, which is 333 Georgia Appeal 793, which is a 2015 case.
Mm-hmm. Okay. And then how about the CAD reports? Is the objection, what's the objection to the CAD reports? Okay. And does the state have a position on that?
Your Honor, the state does not believe that the CAD reports are a violation of the continuing witness rule, and we are looking, I thought we had the case on point, but we are looking for that case as well.
Y'all, I think they're sorting out things now that we would have expected to have already been done. This is very, because they already sent the jury back and they're still talking about evidence and stuff. Yes, I agree with this. Yak's in a much better place. I mean, Shannon's facing the same murder charge as Yak plus another one. So off the top, Yak is in a much better position. I agree. I would have thought this would have already been done. Very strange. I mean, I shouldn't say strange, but inconvenient. Let's put it like that. Yeah, the jury left already, didn't they? Yeah, because they couldn't be talking about this evidence in front of the jury. Jury's already gone. Or else they'd be talking about all this evidence in front of them, which wouldn't make sense. Love is there, y'all. You can see her there. She's in the back row. Well, the row behind Hylton. She's still on the team, though. Verdict could be today if they can figure all this stuff out and get this over to the jury within the next hour or so or two. If they get it to the jury by 2 o'clock, the jury would still have, what, about 3 hours to deliberate. So they're not supposed to be talking to deliberate yet, y'all. They're not supposed to be talking to deliberate yet. They're in the jury room, but they're not supposed to start deliberating. So that what they might be doing right now, I think they're supposed to be selecting their foreman right now. Okay. So I think they're selecting their jury foreman right now, but they're not supposed to actually be deliberating yet. Yeah, they're selecting their foreman at the moment. It is very nerve-wracking to watch this live. It is nerve-wracking to watch this live. It is.
Okay.
I have a case, Your Honor. It's a March 2021 case. It's LPATTAROTTI, State 385, Georgia Appeal 675. It stands for basically what continuing witness applies to, and CAD report would not be something that is listed as something that wouldn't go back because it would be a continuing witness. It's an original evidentiary document, non-testimonial.
Does it cover CAD reports at all, or is it just kind of, here's what continuing witness means?
It's just kind of just here's what continuing witness means. I couldn't find a case specific or on point as it relates just.
It's hard to believe, honestly.
Which leads me to the conclusion they go back.
Yeah.
I think the state wants the cap.
So does the defense have any case law on CAD reports? So I'm looking at a case, Muse, from the Supreme Court from last year, 316 Georgia, 639, and it also doesn't cover CAD reports specifically, but it's talking about surveillance videos. And it says, here the surveillance videos were not the reduction to writing of an oral statement, nor a written statement provided in lieu of testimony. And a CAD report, I mean, it contains the reduction to writing of an oral statement, doesn't it? So it may be that it can go out redacted.
The CAD reports are the 911 calls, I believe, y'all. I think those are the 911 calls and maybe any related calls to, you know, dispatching police or emergency personnel. So now the judge is trying to use case law to help determine what to rule on this, which is what she's supposed to do, people. You know, this is exactly what she's supposed to do. She's supposed to look first.
What does CAD stand for? Computer aided.
The jury does not have the case yet. Kind of figuratively they do, but not really, because they don't have the charge to actually start deliberating yet. So they're close, but they don't have the deliberation yet. They're supposed to be selecting their four-person right now. What do you mean coming to an end? A lot of people think the jury's going to be quick. After a week, they all voted not guilty. So 7-17, I think most people here would agree that a week is long. You say it quick, then you said a week in your example. I think most people here would say quick is anything maybe today or tomorrow. I think you start getting into Monday and stuff, particularly with the holiday. I think most people this chat would say that's a long time.
I wanted to share this in case it helps. My thinking is with the arguments we've had on CAD reports and 911 calls, in our many days of going through upcoming exhibits, the court made determinations on testimonial versus non-testimonial with how we walk through and redact it. And so my understanding with the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person's oral statement or testimony. In terms of that non-testimonial analysis is part of the genesis of the continuing witness rule. But, and that was why I wanted to share that. And this is coming from, I believe it's the same case that Mr. Abadi cited, the PATTA. Yeah. But that, I just wanted to share that because it just hit me that that pre-analysis, of course, with the CAD and 911 specifically, we have argued and the court has ruled on that part. That was all I wanted to share, Your Honor.
There's another case that's pretty new. Davis v. State, 371, Georgia Appeals 469, 2024 case.
Chuck T, can probably yes, will probably no.
I mean, in the Paparazzi or whatever it is case, the continuing witness rule is inapplicable where the documented issue is original documentary evidence or where it's non-testimonial because it's not a reduction of or substitute for oral statements or testimony. It's certainly not a substitute for oral statements or testimony. And it is original documentary evidence. And I think we already redacted out of every CAD report, at least since I've been involved, any hearsay, right?
Your Honor, it is true. It is what Mr. Atkins said, to my recollection, is completely accurate. As we did have a series when we went through these CAD reports, a series of hearsay objections and confrontation clause objections,
Right.
and some were redacted.
Yeah. All right, so then I think it would be my conclusion that it is all right for them to go out as long as they're all redacted to cover the evidentiary rulings that I made previously, or that the predecessor court made previously. All right, did y'all, I hadn't had a chance to look at the demonstrative law yet. Yes.
Sorry, y'all. I had to take a call. What happened? Hey, Queen, what's going on? I was on a call. What happened there? Nothing? Okay. Nothing? Okay, got you. So I think y'all are being optimistic with a verdict today. If they came back with a not guilty verdict today, y'all, that would be a scandal. Wouldn't be illegal, but it would be a very hard punch in the face to the prosecution. I'm imagining all of y'all who say verdict today, you're saying it would be a not guilty verdict, right? Not guilty verdict today in a few hours would be a kick.
All right. My reading of reference is that demonstratives can go out with the jury. Y'all, if y'all got something contrary to that.
Let me just be clear what demonstratives we're talking about.
Major turning points. Glanville recusal scandal. Judge Whitaker, of course, her taking over as opposed to a different judge.
I believe there's some physical evidence that Ms. Weaver may have in her.
DA Love being sat down or marginalized.
For the drugs,
Neither of those is going out to the jury.
Okay.
If you have pictures of them, those can go out.
Biggest turning points would be Glanville's recusal and then Wooney Lee's reading of the freeway, which led directly to the plea deals. That would be my two. Glanville's recusal and then Wooney Lee, that whole situation that led to the plea deals. That would be my two.
What do you suggest? Is there anything besides guns and drugs that she has?
We're going to look at the evidence
Okay.
list.
Y'all aren't suggesting that either of those go out with the jury, are you?
No, we're talking, we have the jewelry upstairs.
Okay.
Some of that may or may not.
Not sure we want that to go out with the jury either, considering the allegations in this case by one of the attorneys. Unless we've got an armed guard in there.
We're going to go over the exhibit list, trying to see what else Ms. Weaver may have.
Y'all got pictures of the jewelry and pictures of the guns and the drugs, right?
Yes.
Okay. And those are those in evidence?
Some of the picture of the jewelry.
Okay.
So Woody, I wouldn't say Woody was a turning point. Yes, very important, but I don't think anything changed because of Woody.
Mhm. Sure, absolutely. Yep.
Glanville's recusal changed the entire trial. Wooney Lee's reading of the freeway and everything that stemmed from that changed the entire trial. I don't believe that Woody changed the trial. I do think his testimony was important. It's going to be important for the verdict, but I don't
There
think
seems to be pretty.
I mean, you could certainly say
Excuse
Woody.
me, Your Honor.
Yes.
Regarding Ruffin v. State, having looked at the demonstratives the state plan would like to send back to the jury, these are demonstratives that were, if not all, at least for the most part, I think all, produced by the state for use with their witnesses.
Okay.
Whereas in Ruffin, that was an anatomical chart apparently used. Well, actually, I can't tell if that was, it looks like it was used by a medical examiner in the parenthetical.
So I'm looking at, it's a fairly old case from the late 90s, but it says items of demonstrative evidence. It's Gabbard versus State. Hang on. Let me find that part.
Oh, Gabbard v. State,
Yeah.
Your Honor.
Mm-hmm.
233 Georgia App 122.
Yes.
Let me pull that up.
These were also anatomical drawings to illustrate victims' testimony.
There's a more recent case, Moore v. State, Georgia Supreme Court case 311, Georgia 506. It addresses demonstratives as well as the cell phone presentation.
I would say Woody is probably the single reason that this case has gained more notoriety than it had. You know?
Sorry, was that Moore v. State?
Yes.
Thank you.
311, Georgia 506.
Thank you, Mr. Abate.
I don't think that the jurors will know about the other cases, no, except for anything that might have been mentioned during trial. The jurors really are not supposed to know hardly anything. Woody is definitely a force of nature as it relates to this case. And he has, besides it being so big because of Thug, he has definitely caused the corruption angle to be magnified a lot. Andre is just constantly ranting about who he hates. I just got some lunch, y'all. Yeah, Woody did change his trial. He did it on purpose, though. I mean, he did a lot of interviews where he talked about injustice, about people violating his rights. It wasn't just what he said in the trial.
This case, Your Honor,
Mm-hmm.
I think it seems to imply that the lead detective is the one that prepared the PowerPoint summary that went out to the jury, not a demonstrative prepared by the state. Unless I'm reading it quickly, but it appears to be a distinction there.
Okay, so I'm looking at a case, McKinsey versus State, 300 Georgia App 469. It says the continuing witness rule does not apply to demonstrative evidence designed to illustrate testimony given by witnesses. Here, the documents complained of were designed by an investigator of, it was the DeKalb County DA's office, based on other admitted exhibits, including cell phone records, dates and times that checks were cashed. The documents were admitted at trial and served only to summarize the other admissible evidence. There was no violation of the continuing witness rule. I mean, that was more like a summary document, but I guess that was demonstrative and summary. And it was prepared not by the witness, but by one of the parties, and it was not subject continuing witness. Seems okay to me.
I'm going to have more of a challenge distinguishing that one, Your Honor.
All right.
Yeah, I don't know.
So I think unless y'all come up with something else, that I'm going to overrule the objection to both the CADA reports as described, redacted, and demonstratives going out. Other.
So there are some pieces of physical evidence, Your Honor, hats,
Okay.
other clothing items that
Yeah.
we're having someone go to retrieve to bring them down.
Okay.
And I think by the time we retrieve that, gather everything, we'll be ready to
All right.
collect everything and have it sent back.
One other matter, there are two demonstratives that were admitted by Mr. Steele.
Okay.
These were admitted at some point during the trial.
So I'm
In January.
yeah.
I don't-
Those are just blow-ups of
Yeah.
the language of certain
Yes, Your Honor.
overt acts.
It was admitted when Trontavia Stevens was on the stand. I don't particularly have a strong feeling one way or another about them going back. I'm not sure. It's appropriate.
I'm thinking those aren't needed because they're going to have the indictment itself out, and that's really just a magnification of certain of those items on the indictment. So we won't send those out. And if y'all want to look through whatever other demonstratives there are, it might be a good idea. I feel like I asked y'all to do this several times, several weeks ago.
They just went through it, I
Hmm.
believe, Mr. Atkins.
All right. Okay. Well, good. Thank you. So I keep. Hmm? Can you do that? Yes. Hmm.
The state has demonstratives that were the result of their writing during testimony.
Right.
I don't believe that those are covered under the case law that we're talking about. This is just literally writing in trial. I don't think that makes it a demonstrative. Essentially, they were writing to encourage the jurors to write. Is kind of the way I saw it. Send a message, write this down because it's important. But I don't believe it's appropriate for these to go back.
Thoughts? I mean, it didn't seem like that was being used to help the witness illustrate their testimony. It was more to help the jury kind of. Okay, so those will not go out.
So I'm gonna put these right here with the, not those.
Okay.
Rev,
All right, let's take, y'all can continue to do this. Let's take a quick recess though. And y'all do that during the recess and then maybe we'll come back and once it's settled, okay?
Rev, think about this. Did she say come back at 3? Did she say come back at 3 o'clock? Rev, I don't think the feds are going to pick this up because what everybody thinks about the feds is, oh, the feds only take the strong cases. That's why they tend to win. The feds would have to use the same evidence that's already here. Like, chances are they're not going to get any additional evidence. So they would be arguing with the same evidence. So what would be their incentive to pick up a case that, though could have been argued better, didn't have the evidence to reach a positive, at least it doesn't seem like at this point, reach a positive conclusion. Did she say 1:30? Okay, 1:30. Yeah, I don't think the feds picked this up. Like, why? Why would they pick it up? You already have guilty verdicts. You have Thug has a guilty verdict. Mongtung has a guilty verdict. Wooney Lee has a guilty verdict. Gunna has a guilty verdict. Like, what would be the feds? What would be the incentive to pick up this case with flimsy evidence, all the controversy surrounding it, and then the main guy already is guilty. He already pled guilty. So, you know, what is the additional incentive to get this guy guilty again? Oh, DOC says Woody pulled a Frank Lucas. He redeemed himself. I think a lot of people would agree with that. I don't think that the feds are going to touch this because I would think the feds would be interested in taking on a state case where the state was not able to get a guilty verdict, but where they should have. And so the feds might say, well, state, you couldn't do it because of whatever. We'll do it on our end. But you have the lack of conclusive evidence, one, and then you also have a bunch of guilty verdicts already. So why? It's not whether Thug can be charged by the feds. It's what is the incentive of the feds to charge Thug? Why would they do that? That's the question. So we're not so much asking can they, it's what would be the reason they would do it when he's already pleaded guilty. If there were more interstate crime involved, the feds might have looked at it. I agree with that. But they would need additional evidence that we haven't seen. Now, if there's additional evidence, like significant evidence that just wasn't presented, or if the feds want to go and start reviewing financial records and all that stuff that the state didn't do, and they're going to be able to find some stuff, then maybe, you know, if they're going to start pulling bank records and, you know, start trying to put together. But then you also have the state that's already trying to seize his stuff. So I just don't see it. I don't see it. I don't see why the feds would try to go after all of this. Yeah, we're on break until 1:30, everybody said. Can Woody be charged and investigated for the M charges? Yep. So, y'all, there's a lot of kind of coulds happening. And I think we also need to think about the woods, you know. Woody could be charged, and even he was charged with Donovan Thomas's murder. In a sense, unless he has some kind of deal, they could charge him with the Donovan Thomas murder again if they wanted to. They could. I think the fact that they gave him immunity and told him that if he takes credit for it, they would charge him with perjury. I think that would work against them. And I think the state would have a difficult time charging him for the crime when they told him they know for sure he didn't do the crime. So that would be tough. All right, Kimberly, let me explain to you the Woody immunity. Woody did not get immunity for what he did. Woody got immunity for whatever he said on the stand. So he did not get immunity for whatever he might have actually done. He did it. He got immunity for whatever he said about what he did on the stand. So let me give you an example. Let's say Woody did a crime and there's a videotape out there of him doing this crime. Okay. Let's say somebody has this videotape or DVD or whatever. They have it saved to their hard drive. Let's say they have it saved to the hard drive of some computer. Woody gets on the stand and he talks about this crime. The authorities cannot use his words that he says on the stand against him. They cannot use his words against him. So if he admits to the crime, they cannot use those words against him. If they don't have any independent evidence, then he's free and clear with relation to that crime. But let's say somebody is reviewing their hard drive and they see Woody on video doing the crime, and they send that video to the authorities. Even though Woody had immunity from his words being used against him, the authorities could take that video and charge him and prosecute him and just never use his words and just have as the evidence that video of him doing it. So he's not his act. There is no immunity for the act. There's immunity from using his words that he said on the stand against him. If independent evidence that is not associated with his words were to be found or to come out, they could still prosecute him for anything he said on the stand. They just can't use his words against him. That's the immunity that Woody got. Does that make sense? So Woody is not free and clear for anything he's ever done. He's just free and clear as it relates to them using his words against him. If independent evidence were to come out against him, they could still prosecute him for anything that he said. So Woody was smart not to just get on the stand and start taking credit for a lot of stuff. Why? One, because even though those words couldn't be used against him, and any evidence that's found as a result of his words by the police couldn't be used against him, if his words joggled the mind of an independent witness or somebody and they sent evidence over to the police about, oh yeah, you know what, shoot, I was recording that day, let me see, oh, there he is, that in theory could be used against him. They just would never bring his words in court up, but that evidence could be used against him. So he was smart to not just start running his mouth about everything. Does that make sense? Plus, not only that, but he also might have to pay in the streets for admitting to certain things. So he was smart enough to not just start getting up, to not get up there and just start taking credit for everything. Imagine if he would have taken credit for killing Donovan Thomas. There's people out there who would probably want to kill him if he did that. So beyond just the legal ramifications, he also understands I can't just go up here and say I did this. You know, I mean, that would be quite stupid of him to do so. A mistrial request compilation would be fire. I did do that. I did that, Clizzle. I did a mistrial request compilation. I did like 6 videos of mistrial requests. I called it Mistrial Madness. I'll show you. I did Mistrial Madness 1, 2, 3, 4, 5, and 6. Some of them got good. Some of they actually did. They performed relatively well. They performed pretty well, actually. I'll show you. I'm about to show you right now the mistrial. And thank you for the super seat, sir. What does Queen say? I'm going to have to go back. Oh yeah, I'll show y'all right now. I'm about to show you. Let me pull it up. I did a mistrial madness. There were a bunch of mistrial motions. Yeah, if y'all are not subscribed, do subscribe to the channel. If you have not liked this video, please do like it. What happens if there's a hung jury? So we would not expect a hung jury on all the charges, but whatever charges the jury hangs on could be either retried or just dropped by the prosecution. Whatever charges the jury is hung on is kind of like a mistrial. They could just leave it, or the prosecution could bring it back. Yeah, y'all hit the like button, please. Hit the like button. I'm about to show y'all the Mistrial Madness series. Let me show you. Okay, here we go. This is the Mistrial Madness. So this was number 7. Oh, dang, I guess I made it to 7. 7, 6, 5, 4, 3, 2, and 1. So this was mistrial motions all the way up to, I don't think the Wooney Lee one was included in this.
You saw on this
That's
social
not what
media
you
page.
asked. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court.
Look where we
and
picked
opposing
up.
counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay,
So
this
this
is
is
Justin
the
Cobb's
day-
phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless.
So
because
this was September. So this was the mistrial motions through
Overrule is
October. This was mistrial motions through October 2nd. I could probably do one more to just wrap up all the mistrial motions. So Anna, this is what I would say. What if you don't have any evidence of a potential crime, but the guy who potentially did those crimes gets on stand and starts talking about them freely because I have immunity. You can't prosecute me for my words. And then somebody who does have evidence out there who might not even realize it. They might have been recording in that area that day and they're like, oh, let me check my, you know what, I was over there that day. Let me double check that. Oh my gosh, look at that. So like, just because there's no identified evidence doesn't mean that the evidence doesn't exist. You see what I'm saying? So what, it doesn't benefit Woody. Yeah, y'all, you heard those jets going overhead? Those were jets. 2 F somethings flying overhead. It doesn't benefit Woody to get on stand and just start blurting out all the crimes he committed. It doesn't help him at all. The only thing it could possibly do, I shouldn't say the only thing, the main thing it could possibly do is expose him to problems, whether it be, because again, also you have to think about the streets, Anna. Any of his crimes he committed could have potentially been against other street dudes too. So, you know, do you want to get up there and just start saying, yeah, I shot this person? He did say a little bit of that, but, you know, I don't think that is to his benefit to be up here telling the world all of the different street beefs he was in and what he did and didn't do. So yeah, so if y'all want to watch the mistrial motions, I tried to collect all of the ones that I could find. And just FYI, the very first mistrial motion that I found was literally during opening arguments, y'all. It was during opening arguments. So mistrial motion started from day one. Ray Johnson, but doesn't the state and feds have different laws and ways about going at things? Yeah, they do, but they have the same evidence, though, Ray Johnson. So now, what I said earlier is maybe the feds would investigate to find additional evidence. So, like, for example, the state said they didn't review Thug's, I don't want to say medical records, his financial records. So the feds, in theory, they could say, well, maybe we can find something there, you know? So if you see a federal... If you were... Hold up, y'all. I got to take this. Bear with me 1 second. All right, y'all. Sorry about that. So, I don't think the feds. Why would the feds want to pick this up? Like, people keep talking about that, and I'm just confused about that. Why would the feds want to pick up this case? They already got a guilty verdict. I would say that the feds would want to pick it up if they strongly felt federal laws were violated and there was no guilty verdict. Why would they want to pick up a trial when Thug just pleaded guilty? That's my question. So is this just like kind of a fear that this won't be over when it's over? Or do people have some reason to really believe that the federal government would want to come in and pick this up? Because I don't think that they would want to pick this up, you know? Mr. Boom, glad to hear that everything will be okay. But geez, just out of the operating room, that doesn't... Were they operating on you? Definitely want to wish you the best. Sorry to hear that. But bro, we heard that the feds have refused this, so they won't pick it up. People just asking. Yeah, I think people are afraid of that. It's not that they couldn't. I'm sure they could figure something out, but why would they want to when there's a guilty verdict? That's my question. Why would they want to? If there was a not guilty verdict, then I could certainly see the fear, like, oh, he done got away with something. They're not gonna let him get away. But he pleaded guilty. He got sentenced. He was in jail for 2.5 years. We're talking about Thug here. You know, a lot of these, I don't think anybody's been found not guilty yet out of this whole group. So the state system is working. You know what I'm saying? This whole group's been found guilty. Every last one of them. Has anybody been found? Has anybody beat the charges yet? Y'all know what's funny? Think about this. Think about this. If Shannon or Yak get found not guilty on all charges, they will be the first and probably the only people. We have to see what happens in the future. They will be the first and probably only people who thus far will have been found not guilty. Yes, Slim, we will definitely add you as a mod. You've been rocking and rolling with us. And there you go. Thank you. Appreciate it. So yeah, I don't think that there's very much likelihood that the feds pick this up at all because they're getting so many guilty verdicts. I would be very concerned maybe if, you know, out of 28 people, you had like a bunch of them who were found not guilty. Then I can see people saying, oh man, you know, feds, they're not going to let this slide. But the way it's working, this is the way justice works. Have y'all ever seen a person that was found guilty by the state and then had to face fed charges? Not saying it's never happened, but that's not the norm. The norm is that the state can't convict you and then the feds will come get you. You know, it's not normally that the state convicts you and then the feds come get you unless it's an egregious crime. You know, in egregious situations, you might get convicted by a state and the feds still come get you. But I'm not saying it never happened, but you know, I don't think this is going to be one of them situations. Yeah, there are, I don't think it's 18 of them. There are a bunch of them, though. I'm not sure the exact number. In the military, they do. I could believe that. But so I'm certainly not saying that the feds won't do any kind of prosecution. But what I would expect is we would see new evidence. Like, again, the fact that the state didn't go after financial records, that's a huge gap that was left open by the state. And if the feds were to want to pick this up, I would very, very strongly believe that we would see financial records, extensive financial records come into play. You know? Used to be a mod on other Discords for other channels, and 2 of them self-destructed due to YouTubers sharing ownership with someone. I would like to do a Discord, y'all. Amy, do you think we could build a Discord for this channel? For the whole paralegal thing? I would love that. I used to spend hours. I used to spend my whole day in Discord. It's hard to be 10 plus charges. That's why the state brought so many charges. Yeah, I don't see the feds going into this, y'all. Also, there's the optics too. The feds have Diddy on trial. The feds have Dirk. Both of these guys in the process of trial. I don't think the feds want to go after Young Thug after this. That's another thing. The optics would look terrible. You got Diddy, who's a rapper, you know, marginally so, but he's in hip hop. You got Dirk, who's in hip hop. So wouldn't it look like they're targeting black music artists if they were to go and pick up a case of a music artist who's already convicted? YNW Melly, is that fed though? I thought that was a state case. Appreciate you too. Slim Life. Yeah, so I don't see it. It's very problematic that Whitaker performed inappropriate by allowing the state to get away with all BS, but instead she's correcting and scolding the state instead of denying. Yo, I think what we gotta, young boy also. I think we gotta just allow a certain amount of things to happen in trial that we wouldn't want to happen. I mean, Whitaker, she tried to come in here and clean this thing up, y'all. Yeah, that's what I was thinking. When I was talking about somebody who got convicted in the state and also had federal charges, that's what I was thinking about. Derek Chauvin, I think his name is. Yeah. But didn't he have a federal trial already in process before his state trial was over? But yeah, that's exactly who came to mind for me too. So it does happen sometimes. I just don't think it's common. The fact she said she's fixing their mess. Yeah, I think that's what that was what caused this trial to go downhill. That she said that, and I don't know that that's going to be the memorable moment, particularly for people who weren't watching every day. But we'll remember it, because if we forget, one of us will remind us. Oh yeah, remember she said she was fixing their mess? Somebody has been to Fed, said they could. They could what? They could certainly pick up this case if they wanted to. Chauvin trial was state then federal after that. So my question is, the indictment. Wasn't the federal indictment out there before the state trial wrapped up? Like, was he already convicted by the state and then the feds put the case on him? Or was it at the same time? They are not deliberating right now, Bella. They are not deliberating right now. The jury is, I imagine, in their jury room. They've probably already selected their foreman, and now they're waiting to get the indictment and other documents from the court so they can start deliberating. They're not deliberating yet, y'all. But this is not true. This is not correct either. They've heard the jury charge. So Judge Whitaker did charge the jury. We can look at that a little bit. This is her charging the jury.
Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. In addition, some but not all of the factors you may consider in assessing the reliability of any identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify that person as the alleged perpetrator, and the length of time between the crime and the out-of-court or any out-of-court identification. It's for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify someone beyond a reasonable doubt as the alleged perpetrator or a party to an act. It is not necessary that the defendant show that another person committed the alleged act. The burden of proof never shifts to the defense. Defendants are charged with crimes against the laws of this state. A crime occurs when a law is violated by a defendant's intentional action. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe it existed from the facts proven before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a criminal statute, but it simply means the intention to commit the act that is prohibited by a statute. A defendant will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Whether or not you make any inference or inferences such as that is a matter solely within your discretion as the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crime of murder, that's counts 2 and 49, possession of marijuana with intent to distribute, count 58, or possession of a firearm, counts 52, 54, 61, 63, and 64, was being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt in order for you to convict.
Yeah, this is a replay.
If you find from the
Court's
evidence in
back
this
at
case that
1:30.
the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who is merely present at the scene of the commission of a crime at the time it was committed guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor. You are not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of crime, unless the evidence shows beyond a reasonable doubt that the person helped in the actual perpetration of the crime or participated in the criminal endeavor. Next, I'm going to define for you the elements of the crimes that are alleged as counts against either defendant. Then I will define the meaning of any crimes that are alleged as an overt act, but that I have not yet defined. When a count of an indictment charges that a defendant committed a crime in more than one way, the state does not need to prove that the defendant committed the crime in every one of the ways alleged. The state may prove that the defendant committed the crime in any one of the ways charged. If the evidence shows that the crime was committed by the defendant in any one of the ways charged, you would be authorized to convict him of that count. And RICO is one of the counts that is charged as having been committed in more than one way. In order to convict, the state must prove that the crime was committed by the defendant in at least one of the ways charged. For conspiracy to violate subsection A of the Racketeer, Influence, and Corrupt Organizations Act, which I'm going to refer to from now on as the RICO Act, the state must prove that the defendant knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the co-conspirators committed an overt act after May 10th of 2017 to further a criminal objective of the conspiracy. For a conspiracy to violate subsection B of the RICO Act, the state must prove that defendant, while associated with an enterprise, knowingly and willfully conspired with one or more others to participate in the enterprise through a pattern of racketeering activity, and that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. Conspiracy means an agreement.
Y'all know what confuses me is this. How can they determine that when all of these other guys are on trial still, and some of those overt acts include guys who haven't even gone on trial yet? That's a little bit confusing to me. Like, I guess you just are determining if you think that thing probably happened. Not quite sure about how that works.
Agreement between at least two people to commit an unlawful act. The agreement may be express, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish or to pursue a common criminal objective. The existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state does not need to prove that each conspirator agreed with every other conspirator, knew all of his fellow conspirators, was aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator. Whether a conspiracy existed is a matter for you to determine. Overt act means an outward act made in furtherance of a conspiracy. The overt act may, but does not have to be, a crime in and of itself. Some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are when you have the indictment back with you, because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined when I'm defining the substantive counts. Enterprise means a group of individuals who are associated in fact, whether or not all of the members know each other. To be an enterprise under the RICO Act, the group must have a common purpose and ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity. The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats, use of an item with an altered identification mark, possession of a firearm during the commission of a felony, possession of a machine gun, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, possession of a weapon by an inmate, possession of a cell phone by an inmate, possession of codeine with intent to distribute, possession of hydrocodone with intent to distribute, possession of marijuana with intent to distribute, possession of MDMA with intent to distribute, possession of methamphetamine with intent to distribute, possession of cocaine, or possession of oxycodone. I will define these crimes for you shortly. Racketeering activity also means any act or threat that involves murder, robbery, theft by receiving stolen property, or dealing in narcotic or dangerous drugs. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The criminal objectives of the conspiracy alleged here are preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, obtaining money, weapons, or other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs, and obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. A person commits the offense of violation of the Georgia Street Gang Terrorism Prevention Act, which I'm going to refer to from now on as the Gang Act, when that person, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. To prove a violation of subsection A of the Gang Act, as alleged in counts 50 and 57, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang. To prove a violation of subsection B of the Gang Act, as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang. That is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity. For malice murder, the state must prove that a defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to show premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state may, but does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For possession of a firearm during the commission of a felony, the state must prove that a defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is one of the following: a crime against or involving another person, or a crime involving possession of marijuana with intent to distribute. Murder and possession of marijuana with intent to distribute are felonies, and for purposes of this offense, a firearm includes any handgun. The indictment charges each defendant with possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. I am not going to charge you on that crime because the state concedes that the description of the crime in the relevant counts of the indictment left out an element of either the defendant having previously been convicted of a felony or of the defendant having previously been convicted of a felony involving the use or of possession of a firearm. That should be or. So you will be considering only the lesser included offense of possession of a firearm by a convicted felon when you get to those counts. And for possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. And again, for purposes of this offense as well, a firearm includes any handgun. For possession with intent to distribute marijuana, the state must prove that the defendant possessed any amount of marijuana with intent to distribute. Intent to distribute means intent to unlawfully deliver or sell. Marijuana means all parts of the plant of the genus cannabis, whether growing or not, the seeds, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds, or its resin. Marijuana does not include the completely defoliated mature stalks of such plant, fiber produced from such stalks, oil or cake, or the completely sterilized samples of seeds of the plant which are incapable of germination. And it does not include hemp or hemp products, and it does not include samples of tetrahydrocannabinols or THC. The state must prove that the defendant possessed the marijuana and or the firearm at issue in this case. Possession may be either actual or constructive. It also may be either sole or joint. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the marijuana or over the firearm, depending upon which count you're considering. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the marijuana or the firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana or the firearm. Sole possession means that only the defendant had possession of the marijuana or the firearm. Joint possession means that the defendant shared possession of the marijuana or the firearm with at least one other person. If you find that someone other than the defendant had an equal opportunity to possess the marijuana or the firearm, you would be authorized to convict the defendant only if the state proves that the defendant
Y'all, this is a
knowingly
replay.
possessed the marijuana or
There's
the firearm.
the court is out right
And
now.
I'm now going to define for you any alleged crimes that are alleged in the overt acts that I have not already defined in the substantive counts. So the following definitions apply only to certain acts that are alleged in count 1 of the indictment as overt acts. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the alleged perpetrator assaulted another person with a deadly weapon. Assault means to commit or to attempt to commit a violent injury on the person of another. And to prove assault, the state doesn't have to prove the other person was actually injured. However, the state must prove that the alleged perpetrator attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Aggravated battery. For this crime, the state must prove that, for aggravated battery, the state must prove that the alleged perpetrator maliciously caused bodily harm to another person by seriously disfiguring a part of the body. In deciding whether or not an alleged perpetrator acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. For armed robbery, the state must prove that the alleged perpetrator took another person.
Oh, it says stream ended 5 minutes ago. What's up with that? What the heck?
The language of those last couple of overt acts, that we figure that out.
They started a new stream, it looks like.
And do we otherwise have all of the evidence that's going to go out?
Your Honor, there was a challenge during the lunch break to get into Judge Randall's chambers.
The deputies can get into anybody's chambers.
They just got it maybe about 5 or 7 minutes ago.
Okay.
They're getting the evidence, they asked for a chain of custody form, and so they're trying to get a chain of custody form.
Okay, well, I mean, it goes from one court reporter to another, so do you want the court reporter to just walk up there and take possession of the evidence?
Yes.
That's probably the best way to do it. Then we don't need a chain of custody form. It just is with the court reporter.
You want me to do that?
Yes, we'll do that. All right, so we will recess for our delightful new court reporter to do that. Thank you, Ms. Taylor.
You're welcome.
My gosh, people. Gemini, not only is there no verdict, the jury doesn't even have the case yet. This has not been given to the jury yet, people. And the jury shouldn't even be talking about this. They should not even be deliberating yet, as far as I know. Somebody correct me if I'm wrong, but I think the jury is still not even in deliberation mode yet. This robot, detective robot, is on pins and needles. They don't have, the jury doesn't have this case yet. So they are just waiting around, I guess. They would have started their they shouldn't have started deliberations yet. They would have selected the foreman, and that's it. I don't know what else they were supposed to do in the meantime. So, Yeah, they just back there doing whatever it is they do. So I don't think it's time for pen. Well, you know, if you feel pins and needles, you know, but the jury's not doing anything yet. So you know what I'm saying? I think we're gonna go to y'all know what we've been doing for Thanksgiving that has worked out really well. Y'all want to hear a quick story? Do y'all want to hear a quick story? I am not gonna. Okay, I'm only gonna tell you part of the story because I don't want to get in trouble. But last year, and I think this is over the last 5 or 6 years, at least three out of the most current years, we have gone to Fogo de Chao, which is a Brazilian restaurant. Carniceria. We've gone to a Brazilian restaurant for Thanksgiving. And so Fogo de Chao has a really good Thanksgiving. It's kind of costs some good money. I think it's like $60 a person. So it costs a little bit, but I think that's what we're going to do this year too. That Fogo de Chao Thanksgiving. Last year, if y'all have ever been to Fogo de Chao, you know that they come around and they cut the meat, right? They cut the meat. So they come around with like a skewer with a piece of meat on it or multiple pieces, and they cut it. So last year, I go with my family. It's like, I think it's 6 of us. And the guy's asking me what piece of meat do I want? Like, do I want the rare or whatever? So I go to raise my finger to point, like, give me that piece right there, you know? But somehow he's coming down with the knife and whop, he just slices my finger open. And it's bleeding everywhere and stuff. And they have to take me to it. I didn't require any stitches or anything, but that knife was really sharp. I mean, sliced my finger right open. And they had to take me back there, give me a Band-Aid, blah, blah, blah. And then so the manager's like, listen, your whole bill, don't worry, it's on us. So we wound up having like a $500 bill because I think once we knew that, people started ordering dessert and stuff. You know what I'm saying? They're like, oh, we don't have to pay for it, so we might as well get some more stuff. So yeah, that was my last Thanksgiving. I got us a free, I think it came out to about $500 because I got my finger sliced open. And I told the manager, I was like, look, that was not that dude's fault. Please don't fire him. Please don't, I don't want there to be any repercussions on him. I was just raising my finger up to point at what I wanted. And it was a total accident. So I don't know what happened. But yeah, definitely. Yeah. Yeah. Yep. I got my finger sliced open by the meat carver. Yeah, it was worth it. There's another piece to this story, but I'm not going to tell y'all. Yeah, I took that one for the team. Here in Atlanta, it's over $100 a person. What's funny is my mom always asks, is there any human available? Yeah, I took that one for the team. And now I'm like, shoot, I that one's the closest one to my house, and I want to go back. But I think we might go to a different one. But yeah, they have a really good Thanksgiving. I mean, it was a really good experience. But that was at least the third different location we've been to for Thanksgiving. How do you spell it? Fogo, Fogo. I think it's Day, D-E. Is it Day? Yeah, Fogo, D-E, and then Chao, C-H-A-O. Yeah, Fogo de Chao, like that. Yep. Yeah, for real, like, yeah. Yep. So yeah, that was good. I think we're going to do that again this year. But shoot, my wife was like, let's do that again this year. And I was like, man, that bill was like $500. She's like, well, don't be cheap. I'm like, yo, you know what I could do with $500? I'm your boy thinking about just cooking. cooking a turkey at home, 500 pounds. Anyway, I thought that was kind of a cool story. Totally true story, y'all. Took one for the team and got us all to eat for free. And yes, we did leave a tip for, at some point, somebody was going to wonder. Yes, we did. Now, there were people who said, don't leave no tip. And I'm like, well, if it had been the server who cut me, I might have not left her a tip, but it wasn't her fault that the meat carver accidentally cut my finger open. I mean, it was just as much my fault as theirs. Yeah, Miss Flynn, we have two turkeys right now. Oh, here we go. Mary Kay says next year it'll cost $1,500. I guess that's the inflation, right? Yeah, those knives are really sharp. I mean, of course the knives are going to be sharp, but that thing was, yes. Let me see. My wife just been.
Judge Glanville's chambers is going to, it's apparently a significant amount of evidence. They're going to basically wheel it down here to this courtroom, and Ms. Taylor, our current court reporter, is going to take possession of it. So that'll happen in the next 10 minutes or so.
Well, at least they're being professional. My wife just spent $526.
Can somebody, yes, I could do that. Look in Odyssey and find out the date that's on the original re-indictment to put on this one. You know, when they signed, or who's got possession of the signed indictment? So that might still be, is it in here or is it still with, is it making its way downstairs? We need the date, so we need to see the. I would think that would be.
$526. A ham, a turkey, 3 pies, 3 packages of Hawaiian rolls, a bag of potatoes, a thing of butter, 2 gallons of milk, 2 buckets of whipped cream, and canned. I got to see the rest of this. Canned what? 500 bones for all that? That's crazy. Unique, making it all from scratch. What do y'all non-US people think about Thanksgiving?
All right, have y'all looked at the highlighted language for the proposed ways to handle those couple of overt acts as an A and a B?
Yes, Your Honor. And the state had a proposal to, I think, simplify the matter in terms of starting with 183.
Okay.
If the state just redacted possession of codeine with intent to distribute and possession of cocaine, because this is the street gang charge, so the jury will still be tasked with the other revisions of did Arnold or Williams possess those items individually. So for purposes of 183, the state proposal is to redact to where it only remains possession of marijuana with intent to distribute and possession of firearm during commission, which tracks the language.
Okay. So leave all 3 of them and have those 2 kind of offenses only.
Yes, Your Honor.
Okay.
And for 187, the state's proposal is the same, to remove possession of codeine with intent to distribute and possession of cocaine.
Okay.
Can I ask a question? So would that mean that we would end up with what
What is essentially 187A
183A.
and 183A,
Okay,
right?
thank you. That's what it seems to me, and I just want to make sure my
But those
understanding is
wouldn't
correct.
say A anymore. They would
Right.
just say 183 and 187.
Yes, Your Honor.
Okay, yeah, that works if that's,
And the state, and I can email this, but with our previous discussion on the 133 charges and the language, the state, if you stop, like, for example, take 189 or 190,
okay,
if you stop after, an associate did commit the felony offense of possession of a firearm by convicted felon, and then redline everything up to where you start by possessing a Glock, and then we would obviously remove for 189 specifically, we would remove the machine gun,
right. Okay,
and then just pick back up, possession of a firearm in indictment, and then cite the felony in the date and keep an overt action furtherance.
that works as long as, so the question on the floor for that had been, can an overt act be modified to drop it down to a lesser, essentially? Do we have an answer to that?
Your Honor, I'm going to let Mr. Floyd
Okay,
address that with the court because we do have a,
give me just a sec.
yes, Your Honor.
I almost sliced the tip of my thumb off cutting a piece of ginger one time.
Yeah.
It reattached nicely and I have feeling in it, but I was wondering if that tip of the thumb was going to be gone. But it's not. It's back.
All right, thank you for your patience.
Of course, Your Honor. So the approach we took in this, to try to avoid any problems was only to remove language, not to add anything. Nothing's added.
Right,
I want to be clear, it is not exactly the same situation, but the most analogous thing I could find in the time available is an 11th Circuit RICO case, United States v. Watchmaker, spelled exactly as it sounds, 761 F. 2nd, 1459 at 1468. It's a 1985 case.
okay,
In that case, in that situation, analogous to this, the court found there were certain predicate acts for which no evidence had been presented. It removed them from consideration from the indictment that the jury saw.
right,
That was held not to be a problem.
okay,
And so here we're removing actually less. We're actually removing a subset of that as it references the specific individual defendant in whichever circumstance we're talking about. The others are not at trial. They would have no ground to complain.
Right.
They're not parties.
all right,
So I think it's on all threes at least. But I can't really find a problem with it because we've restricted in this circumstance solely to deletion, not
Okay.
addition.
It would seem that, I mean, of course, I haven't had a chance to read this watchmaker case yet, but if they're removing an entire predicate act, that would seem to be more analogous to removing the entire overt act rather than amending the overt act. But again, I haven't read watchmaker. I'm just wondering if amending the overt act, we would be running into a constructive amendment claim, constructive amendment of the indictment.
Well,
Because-
two aspects. I didn't mean to cut you off.
No, please go ahead.
Okay. Two considerations on that, Your Honor.
Mm-hmm.
One is the meaning of the word amendment in this circumstance. So if we were changing it to refer to another offense or adding words, that would constitute an amendment. This, to the extent it's an amendment, is exclusively an amendment by deletion. And it is tailored to those aspects where Your Honor found there was an absence of evidence. There's no prejudice to the defendant. It's favorable to the defendant. I'm not aware of anything that says you have to cut beyond the scope of where you found there was a shortage of a failure of evidence. And I don't think there's anything that compels that conclusion. In other words, I don't think this is a throw out the baby with the bathwater scenario.
I would argue that the amendment is actually not favorable to us. That amendment by deletion actually broadens out that overt act. It does not work in our favor because you're removing the
I agree.
elements.
It doesn't work in the defense's favor to make it easier for the state to prove an overt act.
Yeah, and that thus it's conduct beyond that which would appear in the original grand jury indictment, and that would amount to constructive amendment.
Yeah. You know, I mean, even I'm reading Watchmaker right now, and part of it says the court did not change the terms of the crime with which Keating was charged, which I'm not changing the crime, but I'm changing the crime in the overt act. I think the safer thing to do is just to redact the indictment to remove those overt acts. I'm not convinced that it might not be error to do the way you propose. I think logically speaking, it sounds like it should make sense, but in the absence of something that makes it clear to me that it's not error, I would hate to borrow a term from one of y'all, get to, the 90, y'all haven't said it, but almost, I don't know, never mind. It was some kind of football field reference that I'm not going to be able to do right. So just never mind. The 1 yard line. And then, yes, y'all probably
I
said 2
thought you were going
yard
to say
line.
risk introducing further error into this
No, I don't know that there is error in this case at all. I don't know.
Okay.
There is typically, there are no perfect trials. We know that. It will be up to potentially some other court to determine that issue down the line. But right here today, I would hate to be on the now 1 yard line and do something that does cause an error that couldn't be corrected.
And so, Your Honor, if I can respond to that, two points. One, it's important, I think, to be specific as to which acts we're talking about.
Okay.
So with 183, there's no change in the nature of the crime. We're only talking about striking out those specific things as which there's no evidence.
Right.
I can't imagine any problem from that.
Yeah, no, I agree. I was talking more about the possession of a firearm by the whatever they were, 174, 175, 189, and 190. I'm just going to redact out completely.
Okay.
With regard to 183 and 187, I think those are fine to have just gotten rid of the things that I directed a verdict in Mr. Kendrick's favor on.
Thank you, Your Honor.
And Your Honor, with regard to, I have 2 points.
Okay.
One is, when you're talking about, forgive me if I get the number exactly wrong, but 170, I think it's 174, 175, 89, and 90.
Yes.
And so with those, the specter that's been raised is, to paraphrase the defense, the appearance of error where none currently exists, as we are at first in inches. However, because of the way you have instructed the jury to handle the overt acts, if they find these, and if there's a defect, those an appellate court simply strike them from consideration.
Unless they're the only acts they find.
In which case you would know that as well.
All right.
Because they're going to number them.
Understood. I'm just gonna redact them. Y'all will still have over 100 overt acts for them to evaluate.
Dang, that's wild, y'all. She just redacting that. Just getting rid of certain overt acts
All right,
off
so
of
I
the
am
indictment.
redacting out to delete 174, 175, 189, and 190.
Wow. That's kind of significant. Not that I know it'll affect the case, but or the verdict.
And then on 183, it will be the language that is now 183A, but it won't say A, it'll just say 183. And then the same with 187. Yes.
This argument may be fixed, but with both of those, of course, redlining or removing, the possession of codeine, the intent to distribute and possession of cocaine from the bottom.
Right.
The last version I saw on 183 and 187 still had those included.
Oh, it doesn't anymore.
I think the state may be looking at the B language and not the A language.
That's perfect, Your Honor.
All right. All right, I think I can't do the rest of it until Ms. Persefield comes back because she has the same document up and for some reason it's not letting me remove the highlights. All right, I see that our mainly physical evidence has arrived from Judge Glanville's court reporter's office. And Ms. Taylor, our current court reporter, will take possession of it. And do you all know what's going out and what's not? Because the jury has had this case for an hour and a half now, but they haven't been able to deliberate because they're awaiting the evidence. And that is why I told y'all for the last several weeks to make a determination about what evidence was going to go out so that when they got the case, they could get the evidence too and begin deliberating. So I'm kind of ready for that to happen.
This is wild, y'all. Can you imagine the nerves? Can you imagine the nerves? But it's going to the jury soon. They should have it within, I would imagine, in the next hour or so. So the jury is supposed to be in that room just waiting. So y'all, what are they gonna do while the jury is deliberating? Like, are they just gonna sit in court? Like,
I just saved it. See if you can open it again, maybe. There's a tiny bit of formatting that
what are they gonna do? Just sit in court and wait?
So starting with like 173, which will be on page 41. Right, yeah. So then we go to 176. Is that correct? Take out which? Yes.
I wonder. I mean, but what is the camera person gonna do? Or will there be any footage, or will they just? I guess the camera person's gonna turn off the feed and then turn this down a little. I guess the camera guy's gonna turn off the feed and then just come back for the reading of the verdict. Y'all think? I don't think any trials are like this, LTO.
All right, Ms. Percifield has what we think is the final redacted indictment. So with the changes we just discussed, so if everybody can take a look at those, they start on about page 40 or so. Just take a look at those, confirm that they are what everyone has agreed we're going to do, and then if so, we'll print it out and that'll be ready to go to the jury as well.
Y'all's getting close now. Getting real close to going to the
At
jury.
which time the last thing we will be waiting on is the evidence.
Yes.
The jury might have questions, yeah. Whitaker's already kind of set the pace with that by saying that she's not going to be necessarily going to be able to provide a lot of clarification. So Slim Life, you're saying like if the jury takes 5 days, you're just going to have 5 days worth of Seal to watch? How the heck is that going to happen? Karen Reed, they put a ticker up with the time the jury has been deliberating. Melissa, with Karen Reed, Melissa, did you watch the entire Karen Reed trial like every day or a majority of the time? If so, I have a few questions for you. I want to do like a Karen Reed deep dive once this is over and get ready for the Karen Reed trial. I've heard that the Karen Reed trial is very, very emotion filled with the multiple sides of people who have opinions on that trial. But how long did the Karen Reed verdict take? How many days or what have you? Anybody familiar with? Okay, so should I even get myself involved in that, Melissa? I heard Karen Reed was not
from getting this to the jury. Perfect. All right.
Okay, so we're gonna go on to the seal.
All right, while y'all are doing that, I'm just gonna put on the record that with regard to the guns and any other physical evidence that's not gonna go out with the jury, for instance, the drugs, The DA is the official custodian of that evidence, and so the DA will remain in possession of that evidence, and y'all need to keep that in your locked evidence room. The court reporter is not going to be taking custody of that, the guns and that other type physical evidence that is not going out with the jury.
5 days. Oh my gosh. So y'all, should I go into those waters? I read on Twitter, on X, that the Karen Reed trial brought out a lot of toxicity. I don't know. I have no idea. Okay. But I read that like there are very, very, very polarized sides on the Karen Reed. All right.
Can some member from each team be dealing with the rest of what's just paper evidence and making sure that everybody is on board and on the same page with regard to that?
We've done that.
All right.
We just need to make sure we send them. I think we know we separate things. We just got to make.
Okay, I am ready to hand all of this to the jury in the next 5 minutes. So whatever needs to get done, let's do it now.
All right. Karen Reed is going to have a redo in January, I believe. I'm going to review that. Once this is over, I'm going to do a deep dive into that. Oh, far worse. Whoa, far worse than Georgia. Yeah, I'm going to do a deep dive on it. Why did the Karen Reed trial blow up, though? Like, this trial, I know why it blew up. You have a internationally renowned artist, and you have Woody, and you have Judge Glanville that threw Brian Steele in jail. So, Doug, Woody, and Glanville throwing Steele in jail blew this trial up. What caused the Karen Reed trial to blow up? What's special about it? When I say special, I mean what marks the difference with Karen Reed as it relates to all the other trials happening in the country?
Then y'all will have to wheel it over and we'll display it in the courtroom.
So we can't keep it up here while it's
No. No, I mean, they might deliberate for a month and a half. We might need to use, I'm going to be using this courtroom for the other defendants on this indictment. So no.
All right, y'all, let's not get toxic in here. I just don't know. I literally have no idea. Oh. Whoa, okay.
Plea that was taken out.
Okay.
And a transcript for Mr. Sledge.
All right.
So these are all different things that.
Okay, all right, y'all. All right, cool. Maybe we'll do a Karen Reed catch up stream later.
444Y and 1AS are not going back. They were, I think maybe Ryan, I don't know, something to do with, no, I don't know what they were. I just have a note to myself that those are continuing witness.
Ooh, okay. Yeah, I'll look into that.
I've looked at the revised indictment that we just received, and it's acceptable to me.
Thank you.
Guys, do you know what
Why should be the court in
5 days, though. Jeez Louise.
That may have been Mr. Sledge's pleas or something like that.
Yeah, it works. See it? It's right there. You cover it, sorry.
I think it's the Weinstein has it. You looking for statement? Yeah. I mean,
Y'all know that one of the things about this trial, one of the most heartbreaking things about this whole thing for me is just people don't trust the government. I mean, they don't trust the prosecutors at all. Like, this is a huge L for them. And it's almost like if the prosecution wins, they lose more trust. They almost can win trust by losing the case. What do y'all think? I feel like if the DAs lose the case, it's almost like they won't really win trust, but it's almost like the pressure valve will be released so that people can start building trust again with the DA. But if the DA wins, it's going to be hard for people to rebuild their trust. All right, y'all, let's drop the Karen Reed. I'm sorry. I didn't know that we were going to get off into a Karen Reed debate here. I had heard it was toxic, but I just wanted to get a sense for, is that true, So April says she has more trust in Hylton. I wouldn't trust Love with the courtesy. April, remember, Hylton's been the point person for the last month or so. Hylton did those closing arguments last night. That wasn't Love.
Okay.
So, you know what I'm saying? I also typically agree with you, but Hylton's been out front. Love's been in the background. She hasn't been the one questioning the majority of witnesses, and she didn't do the closing argument. So what are they just gonna put?
I'm just gonna put on Ms. Taylor. I'm going to put on the record that I realize if you put on the record for me, put on the record for me.
Okay.
Give me a second.
Okay.
All right. So 1AS that I referenced before, I've realized that is.
Y'all, will there be an official announcement like
exhibit number
as of
Mr.
now
Pledge's
the
plea, and
case
it's
is
not
officially with the
exhibit
jury?
number for
Something
this
like
trial.
that,
The
or
exhibit number for this trial is 444Y. They were just the same thing. Yeah.
But the 444Y would stay in that.
It's in evidence, but I don't think it would go out.
So that came in the notes that was about.
no, Lou. I was asking, like, at some point
They're the
will
same.
Whitaker
That was
say
it was 1AS, but
and
that's
the
not an exhibit to this trial.
case is
So it
now
was just
officially with the
way
jury,
that
meaning
exhibit
that
was referenced
she just
in
placed it with
Pledge's
them?
agreement, so don't worry about that at all. Okay. Yeah. Okay.
Okay, so we should get a time clock. Okay. All right, cool. So it's still not with the jury yet, then.
All right. I mean, if we're ready to start wheeling it in, we don't have to have all 5 things at once. We can wheel in number 1, carry on number 2. I am.
All right, y'all, they're doing it.
She wants the verdict form.
They're all right there in the middle, right there. Yeah.
Here they go. That's all of them right there. That's everything. Oh, it's not in here? Wait, it's not. The indictment's not there. The indictment's not there. The indictment. There is no indictment yet.
With the printed out.
Have y'all had a chance to look at the redacted indictment?
I feel like, yo, nobody come at me, but I kind of feel like with all these people in suits and stuff moving around, it kind of feels like what happens like when church is either about to start or
All those
church is
demonstrative
letting
that
out,
are right there, go. Okay.
like everybody in their Sunday best moving around. Not the feeling, obviously, but like seeing all these suited people walking around and moving around, it's like unusual to see nowadays.
And Your Honor, this is just for the purposes of the record. The state has reviewed the revised indictment and it's going to be printed. I was just going to put for the record that the state, would object to the removal of the 133 counts, overt acts, that are 174, 75, 189, and 190. Thank you, Your Honor.
I also could, well, funerals happen in a church though, right? So not always, but oftentimes.
She's waiting for the I don't know. These ask them.
These are ready, right? These do they have
Right here?
or no?
Yes,
This-
you can use the lid, just don't give me that paper.
Oh, this is ready?
That's the cover. No lid?
Shoot, minimum, Sean.
What happens?
So what?
They're over there. They're over there. LT.
So the thing is, if the jury gives the prosecution the L, then people will at least trust the system in that the jury will see through the bull. Whereas if the jury gives the prosecution a win, then the people will lose faith in the whole system because they'll say, well, the prosecution can do what they want and the jury can't see through it. So, I think the jury is like, it's like kind of the jury could save the system, not necessarily the prosecution, but the jury could save the reputation of the system somewhat.
No, I have a few things, but we're waiting. I just figured I kept all that together. Yeah. I'm gonna try it like this. Oh, good. Thank you, just in case we need it. Yeah, or wheel it back there. I don't know where you want it. I guess you can take it into the jury room and next time we use it.
Hey, Green Man, imagine this. Whatever the taxpayers have paid, the defendants have paid a significant portion or percentage of that out of their pocket. Just imagine that stat.
All right, while the jury is deliberating, Ms. Persfield's going to check to make sure she has a cell phone number for each of the attorneys, because obviously we have no idea when and or if they might want to ask a question or look at evidence. And so we all need to be on standby. We're all still in trial. And I need for people to be able to get here, in 5 minutes time. Ideally.
Sounds
If you
like
have a
she's saying the
special
jury has
case
a
you need to
case
be,
now.
We can talk, but in short order, and obviously the defendants will continue to come over each day that the jury is in deliberating so that they can also be available to come to the courtroom if need be.
I apologize if the court has already stated this. When will the jury end their deliberations today, and what is the schedule for them
Oh,
tomorrow?
it's in what time?
Yeah.
Well, I have instructed them through the deputies that they need to stay at least until 5. If they want to stay beyond that, they're free to. I mean, not past 7 ever, which I don't think they're going to want to anyway.
Kiara, she just signaled that the jury has the case. She didn't say it officially, but she insinuated that the jury now is deliberating. She did not say it officially, but she insinuated that the jury is now deliberating. All the attorneys have sat down. It appears that the jury is now able to talk about the evidence. And
All right, and so they would like to continue to come in and start at 9, which is fine with me. So I'm going to say, just like a regular day, 9 to 5 with a lunch break. There will be days that the court provides lunch for them, and on those days they can choose to deliberate during their working lunch if they want to, or they can not deliberate and just take a break and eat. I'll make it clear that they can only deliberate when all 12 of them are there together. With regard to tomorrow, since it is the day before Thanksgiving, I'm going to say that they can leave at 3. And other than that, if there is some day or time that we need to alter that schedule, we'll just take it up as it comes.
And if they, I don't mean to ask for such detail, but if they decide to stay past 5, will we be notified of that so that we know to stay around the courthouse after 5? Or if they decide to stay after 3 tomorrow, will we be notified of that? I just want to make sure I don't leave the courthouse if they decide to deliberate late.
Sure.
If I have cell phone numbers for everybody, I'll do a fun group text chain and then text everybody what's going on, very briefly.
Thank you.
No, Friday was already scheduled as a holiday date a long, long time ago. No.
May I approach?
On the record, off the record.
all right, y'all. So the jury is now deliberating. They've been deliberating for the last, say, 10 minutes or so. Or they've been able to deliberate for the last 10 minutes or so.
We're only using WhatsApp. Come on.
Okay, there's your counter. But it doesn't look like it's working yet because it's starting off at 1 hour and 2 minutes. So hopefully they'll get that counter reset. Okay, so they set the counter now, and we are, I guess, at 2 minutes. We really have more than 2 minutes, but so does that mean that the law and crime? So the law and crime, what are they just never going to turn their stream off? Hey, people who've watched these verdicts before, does the stream just stay on forever now, or does the counter just pick up wherever it would have been the next time they bring the stream up again? I get that, Sandy. It goes to the logo, but will it stay on all night is my question. Or will it go off and it just, whenever we come back, we'll just see wherever the counter happens to be at that time?
It doesn't look like it, but I swear there's.
Oh, no, I get it. That's your so it doesn't have to look good to me.
I will do that. So right now, if y'all are interested in working in the legal field, there are lots and lots and lots of opportunities, both in-person and virtual work, part-time, full-time, contract employment. There's just a lot of work right now. Income potential. I would say now, particularly if you're in a good city, like if you're in Boston, you're in New York, you're in DC area, Atlanta, it's a good city. Probably the best city for paralegal right now is Chicago. Anybody in Chicago in that area, if you're good, you're gonna make money. And income, I would say, if you're good, you can start between 25 to 35 bucks an hour. Starting out, if you're good. If you're really, really good, you can definitely start more than that. But 25 to 35, I only say 25 on the lower end for people who are maybe in lower paying areas. There's a very big pay difference. Paralegals would be 25 to 35 starting out. You could go higher than that, but I'm just trying to give a conservative range. Lawyers, I would say nowadays a typical lawyer is looking at least.
All right, with that, that is everything. The jury has the case, and we are in recess until such time as we hear from the jury.
Yeah, y'all, please do like the stream. Lawyers make a lot more than paralegals, y'all. But paralegals can earn six figures these days. Paralegals can earn six figures these days. Our classes, if you have a high school diploma, you should be able to pass our courses.
And that way, if there is a question,
If you have a high school diploma, yeah, I will. Yeah, what are y'all gonna do when this is all over? I'll put the link in the chat. So what do y'all want to do? Y'all want to hang out a little while? We'll hang out for a little while. And just try to, first of all, y'all do hit the like button, please. Going to law school 4 years, is it worth it? I wouldn't say it's worth it for the money, but I would say it's worth it if you want to work in the legal field. I would say it is worth it if you want to work in the legal field. I'll show y'all the course a little bit. Let me show you the course. I think I showed this the other day, but let me show you our website. So this is our website. We do have a sale we're running right now. Typically, the course is $19.99. It's $9.99 right now for the next, basically through the holiday. We have some testimonials on here. Let me log in real quick. I teach some of the classes myself. I will probably be teaching a paralegal class personally coming up. I haven't done it because I've been doing this live streaming every day. But this is what the course looks like. Anybody who's been to university, who's used Canvas, this is Canvas. It's like a rival to Blackboard. So we use Canvas. So you get all of your classes. You have homework. You have 17 homework assignments. You have quizzes. You get access to Nexus. We teach you legal citations, legal writing, so on and so forth. And then once you finish everything that's in here and you pass the final exam, once you pass the final, then at that point, we will give you an internship placement. All right. So that is briefly about the course. So can you apply for positions after the class? Yeah. A lot of our students actually get a position while they're in class. So yes, 100%. So yeah, y'all, it looks like, so how are we supposed to know? Like we can't, can we just, do y'all want to just, y'all want to rewatch Hylton's? Y'all want to rewatch Hylton? Well, let's, you know what? Let's rewatch Doug's closing from yesterday. I'll put that on for people who want to hang out. I will put that for people who want to hang out. 1 second. That would have been what, yesterday? Do y'all want to rewatch Hylton? Give me a sec. I've been meaning to rewatch Doug.
Seek out doubt. They don't want you to think about doubt, but the standard is.
Counsel, approach real fast for me.
All right, let me fast forward this. Yeah, I'm playing Doug's. We're going to play Doug's. Y'all don't want to hear Hylton. I wasn't seeing all that while I was. Dang, was it that bad? Almost slipped up how? Let me say this real quick. I'm gonna answer y'all questions about licensing, about accreditation, about all of this stuff. Okay, I'm gonna answer these questions real quick. First of all, let's talk about. Let me just answer your question. Are your certified students recognized by a national paralegal professional organization upon graduation? No. There's no paralegal school that when you graduate, you're considered certified. Certification and certificate are not the same. So you can go to any paralegal school in the world. When you get your certificate, you're not considered certified. Certificate, earning your certificate is one thing, being certified is another thing. So you don't get certified by a school. You get certified by an independent certifying body. Okay, like, so there is no school that will certify you. You earn your certificate. if you want to get what is called certified, you have to take a standalone certification test. Okay, so let me just give you an example. So we work with this certification called NALS, National Association for Legal Support Professionals. You would have to register with them, or you could go with NALA or with any of these certification organizations. You take their test. That's how you get certified. But certification does not come from a school. It comes from one of these organizations where you take their certification test. So you could go to college, you earn a certificate. You could go to an institute like us, you earn a certificate. That is not certification. Certification is when you take the test like through NALS or NALA or whatever. I shouldn't say never. I wouldn't bother doing this myself personally. I don't see a lot of value in the certification in the job market, but people do it. If that, just saying personally, I wouldn't do it, but unless there was a specific job that told me you absolutely have to do this to get this job. Most of the time, jobs don't care about the certification. They just don't care. So that's why I wouldn't do it. But if you wanted to be certified, you'd have to take one of these tests. So that's how you become certified. Frankly, across the country, y'all, most jobs don't care about certification. Most jobs don't care about your paralegal. They don't even care about your paralegal certificate, kind of. They don't. Really, the paralegal certificate is mostly for people who want to get in the field. If you want to get going, you don't have any experience, you need something, right? Because you're competing with people who do have education and or experience. And also people who are already in the field who think it looks good on their resume. And it might help them snag a job, move up in their company, et cetera, et cetera. But outside of that, I'm not going to get certified personally, unless, again, there's a very specific job that's like, look, you go get the certification, you can get this job. Then I would do it. Other than that, I'm not doing it. But paralegal certificate, if you don't have any experience, you don't have any education, then yeah, you have to be able to show some kind of reason why they would even call you in for an interview. So having education can help you out. Plus, I always tell people, let's say you don't have any experience, you don't have any education, you do happen to get an interview. What are you even going to talk about? Like, you wouldn't even know what to say in your interview to get the job if you don't have any kind of background. So having the education also gives you enough information in your head to even discuss, to even have an intelligible interview with a law firm. So hopefully that tells you the difference. Certificate is what you earn after a course of study. That's what we have. A certification is what you get once you just take one of these standalone tests, like from NALS or NALA or one of these other organizations. Okay, so that's the difference. Hopefully that would having a criminal justice degree help with a job search as a paralegal? Probably not. It won't hurt you, but it probably won't help you. Having a criminal justice degree probably will not help you much. I mean, it might help marginally. It might help just a little, but it probably won't help that much. Frankly, the thing that will help you best with your job search as a paralegal is working with me. Once the YSL trial is over, I'm going to be your best bet. And I'll explain that to you on a one-on-one basis. I'm going to just get to playing this trial again. Once this trial is over and I get back to my regular life, I can tell you and convince you that I'm working with somebody who works with lawyers, who talks to a lot of lawyers, etc. No, states do not require you to be certified. No, they do not require you to be certified. I don't believe there's any state that requires you to be certified to work in the legal field. I don't think there's one. So I'm not familiar with any state that requires you to be. In fact, I just said I wouldn't even get a certification. So if states required it, then I would say I would get it. You know what I'm saying? But I said I wouldn't get it. If it were a requirement, I'd have to get it. So no, you do not need to be certified in order to work in the legal field. All right. Any other questions, y'all? I'm going to put my email here. If anybody is if anybody's interested for real in earning your certificate and working, hit me up. Take advantage of the sale, y'all. It's 50% off right now for the next 5 days. So anybody interested, hit me up. Let me play this.
Good afternoon. I'm Doug Weinstein, as y'all know, and I have the pleasure of representing Diamante Kendrick, along with my co-counsel, Katie Hingerty, who's sitting back there right now. Mr. J. Apt also represents Mr. Kendrick, but he can't be here right now. And good afternoon, Your Honor, and good afternoon, counsel. I am thrilled to finally be able to speak directly to you all. We've seen each other in the hallways, we've seen each other in the break room and here in court, but I haven't been able to address you directly. The first thing I have to say is thank you. Thank you for your time over the last year. Thank you for your attention. It is sincerely appreciated. And I am going to do something that you have not seen much of. I am going to try to move at a brisk and deliberate pace and not take up any more of your time than I need to, because I think we have already taxed that enough at this point. I know that your time is valuable. I know you want to be able to spend the holidays with your family. I would also like Mr. Kendrick to be able to spend the holidays with his family without the weight of this trial hanging over him. So let's get a move on. You have heard a bit about Diamante Kendrick over the course of this trial. So I want to just talk about him for a few minutes. As you heard, Diamante, first of all, he originates from Miami. He came from Miami, he moved here, but he was a football star at Grady. And he had a scholarship to UGA to play football. That's a path out that a lot of people take. That is a path up. For a lot of folks in Diamante's situation, the path out is football, either as a career or as a scholarship opportunity to get a college education, to make a better life for yourself. And then another alternative is often music. And while he had that chance to go to UGA, it got derailed. And it got derailed through something that was at no point Mr. Kendrick's responsibility, but it got derailed. So he had to look for something else. And what did he look for? He looked for music. He turned to music because he didn't want to live in that life anymore. He wanted to move beyond it. But yeah, he made some mistakes back then. He made some mistakes back in 2015. And he has paid his price for that. He has paid his dues that he owed society for that. And since that time, he has done nothing but turn to his art, turn to his music, writing lyric after lyric after lyric, laying down tracks. But instead of allowing him to move on with his life, he has become sucked up in this targeting of Jeffrey Williams and has become collateral damage. And these attacks and use of his lyrics against him
the use of the lyrics against Jeffrey Williams is frankly shameful. It's an attack on the First Amendment. And there's been so many rights, so many notions that I think we hold dear as a nation that the state has simply swept away. So why has the state taken a year of your life away from the work that you enjoy, the family that you love, your travel, your vacations, your children, grandchildren, parents? Why have they done that? What has been the point? The state told you in their opening that there was a point, and the point was that Jeffrey Williams was the head of a wolf pack. That is what they told you. But I don't think anyone sitting in here has seen that. You'll make that decision, not me. But I don't think anyone has seen that. What have they proven about Jeffrey Williams? They have proven that he was a man that through incredible hard work, dedication, and talent came up out of Cleveland Avenue. And instead of forgetting everyone back there, instead of leaving them behind, he tried to reach out to those people that were friends of his that he came up with and say, you don't have to live this life. You can come with me. You can get into music. You can hone your craft. I can take you on the road with me. I can take you out of this. And some people took advantage of that and pulled themselves out, took advantage of Jeffrey's help. Some people tried to do that and failed, and Jeffrey Williams sent them back home. They didn't succeed. And Mr. Kendrick took a hold of that. And Mr. Kendrick took advantage of that opportunity that Jeffrey helped him. But instead, law enforcement put a target on Jeffrey Williams' back, because God forbid anybody pull themselves out of that. Because what does society want to do? Drag them back again. Never let them leave their past behind. God forbid someone leave that behind and pull themselves up from their bootstraps. That's what we tell ourselves as a country. If you work hard enough, you can pull yourself out. Let's see what you guys say. So I would argue that we have not wasted your time here for a year. I'm going to argue that the state hasn't wasted your time, that this court hasn't wasted your time, and that we can salvage something out of this year that we have taken from you. And that is to send a message. And you're going to send a message by going in the back, looking at the evidence that's presented to you. And I think any review of that evidence would have you come back with findings of not guilty on all the charges against Mr. Kendrick. Diamante Kendrick is one of Jeffrey Williams' best friends. And as I said, he's a casualty of law enforcement's war on Jeffrey Williams. Mr. Kendrick is charged with racketeering, murder, and several other charges, about 4, all relating to drugs and guns that were found at Jeffrey Williams' house when Mr. Kendrick was over there visiting. What evidence, what testimony, what witnesses, what physical evidence has the state shown you that Mr. Kendrick committed these crimes? I would say almost nothing that you've seen in this courtroom. Sure, they've played some videotapes, but what have you seen from this witness stand? Nothing. When this case began, we stood up here in opening and we told you the state would not be able to present evidence against Mr. Kendrick. We told you they're not going to be able to show you guns tied to him, that there would not be ballistics tied to Mr. Kendrick. There wouldn't be fingerprints tied to Mr. Kendrick. There would not be witnesses putting Mr. Kendrick at the scenes of these crimes. There wouldn't be any video of Mr. Kendrick involved in the tragic murder of Donovan Thomas.
We told you that this case was a Krispy Kreme donut hole. I think the phrase I might prefer is a nothing burger, but that's what we told you. That's what we promised you. And that is a bold promise for a defense attorney to make. And it's one you'll rarely hear, but we made you that promise. And we also told you what would happen, that the state was going to parade hundreds of witnesses through here to throw everything they could against the wall to see what would stick. And frankly, I would submit that nothing has stuck, that we have kept our promises to you. What did the state promise you? Again, a wolf pack with a ruthless wolf pack leader. It's late in the day. With a ruthless wolf pack leader that is here. And instead, you saw that man that wouldn't leave his friends behind. As the state has told you, as Mr. Sharp told you, the state has to prove these charges beyond a reasonable doubt. And they have to prove every element of these charges beyond a reasonable doubt. So let's just talk about reasonable doubt for a moment. So when the state began today, they told you that you don't have to seek out doubt. They don't want you to think about doubt. But the standard is they have to prove their case to you by guilt beyond a reasonable doubt. Can you see that? Okay. They have to prove their state to you by guilt beyond a reasonable doubt for each of the charges, for each of the elements. It can't be down here as highly unlikely. It is a very high standard. Possibly guilty, probably guilty doesn't do it. It has to be guilt beyond a reasonable doubt. The court is going to charge you. They're going to tell you, for example, that grave suspicion is not sufficient. And let me read you the charge you're going to hear. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raises a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Mr. Short already explained so much about the evidence presented regarding the tragic killing of Donovan Thomas. And I need to start by saying I have deep, deep sympathy for the Thomas family. I cannot imagine what it must be like to lose a loved one to gun violence or any type of violence like that. I myself have 5 children, and just the thought of losing a child tears me up. So I don't know what they must be going through. But I think the evidence that has been shown to you does not demonstrate in any way that Mr. Kendrick is guilty beyond a reasonable doubt of the killing of Donovan Thomas. And as Mr. Sharp so ably demonstrated to you, I think that there are others whose perhaps guilt or responsibility for Donovan Thomas's death has been demonstrated far more than my client's alleged responsibility. Briefly, to not belabor the point that Mr. Sharp brought up, let's talk about Kenneth Copeland, Little Rudy. He was a character, right? I mean, he sat in that witness box, and he's a charismatic fellow, a very interesting guy. And he has certainly made the most of his star turn in this courtroom. But he never testified on this stand that Diamante had anything to do with the killing of Donovan Thomas. He never testified on the stand that Demikian Garlington told him all this stuff, that Kendrick was involved in killing Donovan Thomas. He didn't tell you anything about at the McDonald's, he learned anything about the killing of Donovan Thomas that Diamante Kendrick was involved in. You didn't hear it at Sky House. You don't hear that from the stand from him. To the degree you heard any of that, it is in that June interrogation tape that was played to you. He was not under oath during that interrogation. And you heard the circumstances from Mr. Sharp, all the pressure that he was under. That was his 5th interrogation following the murder of Donovan Thomas, and the first time he comes up with this story clearly concocted by Demikian Garlington. How do you like the testimony of Demikian Garlington? Oh, you didn't hear any testimony from Demikian Garlington. Everything Garlington allegedly said, you heard through other people. And again, why did he lie to police? To use Mr. Sharp's phrase, because I always steal from the best. He didn't want to wear the blue jumpsuit. He didn't want to go to Rice Street. He didn't want to be in the Fulton County Jail. He didn't want to face years of prison. He finessed the police. He finessed the police. He is a master liar. He is an admitted master liar. And he has methodologies he uses to lie and try to make it convincing. And he explained all of that to you. Again, why doesn't he want to go to Rice Street? Well, he told you what jail was like. On my cross, he explained what jail was like. When he most recently spent time in jail, he had a broken toilet full of feces. There were flies everywhere. He had no food to eat. He had to put his shirt over his face to act as a mask to try to keep the smell down. What rational person wouldn't do everything they can to avoid that? And of course, now is the next question. How do you know when to ever believe Kenneth Copeland? And I don't have a great answer for you on that. I can tell you what he said on the stand during my cross. You know, he said, hand to God, I am telling the truth now. I have God in my heart. I have God in my head. Now, the state would have you believe about Mr. Copeland and Mr. Zachary, who I'll address next, that they got on the stand and they lied here. And they lied here, I'm sure they're going to say, because they're afraid of the defendants. And that is why they lie. But I'm going to argue to you that actually they got on the stand here and they told the truth. And they did it really almost in an act of bravery, because when they get on the stand, the people they're afraid of is the state. They're afraid of the state. The state is the one that has the power to prosecute them. The state is the one that has the power to put them in prison. The state is the one that has the power to put Mr. Copeland in that jail cell with the non-working toilets and the feces and everything else that he is trying to avoid. But despite being afraid of the state, Mr. Copeland gets up here and tells you the truth. Quindarius Zachary, again, he lies to police. He lies to police repeatedly. And when I confronted him with those lies, why did you lie? You know, he said, Yak never told me nothing. Yak never showed me nothing but love. Never showed me nothing but love. But he lied on him anyway. And why did he lie? Because Garlington came to him with a play. And what's the play? The play is to blame other people for the death of Donovan Thomas. Who did Mr. Zachary see in that infinity? He never saw nobody in that infinity but Woody. The Texaco. Oh my gosh, there's the smoking gun. There's the smoking gun that shows that my client murdered Donovan Thomas. He's on video at a Texaco station a block away before the murder. Heaven forbid. He pulls up in that Texaco in a Pontiac. He leaves the Pontiac. he goes, you've seen this video 1,000 times. Well, maybe not that many, but it must feel like it. He leaves the Pontiac to go into the Texaco, and he buys some junk food in the Texaco, goes back into the Pontiac. He sits in the Pontiac, he talks to another car that pulls up, he gets back in the Pontiac, and he leaves in the Pontiac. Go in the back, watch the video 1,001st time. You're never going to see him get in an Infiniti. You're never going to see it. How does he get in the Infiniti? Was there a witness that got up here and put him in the Infiniti? No. Do they have video from the surrounding area that shows him transferring into the Infiniti? No. I mean, presumably he teleports into the Infiniti. I have no idea what their theory is going to be when they argue to you, but I'm going to be fascinated to hear it because there's been no testimony about him in an Infiniti. How do we know it's an Infiniti in a drive-by? Well, the state is pretty sure it's an Infiniti. The state put on, this is one of my favorite experts of all of the state's experts, they put on an Infiniti identification expert who has worked with, Infiniti for years. And he can tell in any kind of grainy video that that car is an Infiniti. That's an amazing expert, but I'll take his testimony. That's fine. I think he's right. I think it's an Infiniti. And Mr. Kendrick is not in an Infiniti. And it's pretty hard to do a drive-by shooting if you are not in the car that did the drive-by. It is absurd. So again, there's no eyewitness testimony of Mr. Kendrick involved in the shooting. No weapons tying Mr. Kendrick to it. No ballistics, no fingerprints, no gunpowder residue, no DNA, nothing that you would expect to see. Now, the state has told you, well, you can look at circumstantial evidence. This is true. You can. And the state put up a dollar bill with some puzzle pieces missing. So, well, you can kind of infer that that's a dollar bill. And that's true. But don't go try to spend that dollar bill anywhere, because that dollar bill will not spend. And this evidence is not sufficient to convict beyond a reasonable doubt. Where's the cell phone data? Oh my gosh, you poor folks. You had to spend days listening to experts come in here and talk to you about cell phone location data. Where was Mr. Kendrick's cell phone location data putting him there? They didn't show you any. Who killed Donovan Thomas? I don't know who killed Donovan Thomas, but I think Mr. Shart's theory has some merit. Let's turn to the allegations that YSL is a gang. The state had to bring in 5 different gang experts. You guys had to sit through 5 different gang experts to try to convince you that YSL is a gang. Now, they gave you the definition of a traditional gang, and these gang experts, who, as Mr. Sharp pointed out, all sit there and train each other in this insular little unit, but they told you, yeah, they're not a traditional gang. They don't meet the definition of a traditional gang. But lo and behold, we have another category of gang. It's a hybrid gang. Ooh, a hybrid gang. This is fascinating. Let's talk about hybrid gangs. What's a hybrid gang? Oh, a hybrid gang is whatever we say it is at any given point in time to fit our narrative. That's what a hybrid gang is. I use the term nose of wax. They can twist it any way they want to fit the group of people they want and say they're a hybrid gang. It's a catch-all. It's a catch-all used to throw all kinds of people together and say, well, you don't meet the definition of a gang, but because we are gang experts that train each other, we have decided you are a hybrid gang. Well, hybrid gang. So a hybrid gang apparently is one where, according to their experts, Bloods and Crips can live together in peace and harmony with each other to accomplish some type of goal. Does that make sense to anyone in here that has any basic understanding of the way that gangs work? You've had the state's own witnesses come here on the stand and talk about how ridiculous it is that you can say, that anyone can say that YSL is a gang when you can have Bloods and Crips and Independents and all of these people be members of this alleged gang. As Mr. Sharp talked about, there's none of the traditional gang elements. There's no beating in. Anybody can call themselves a member of YSL. You know, someone, I guess, alleged there might be a $25 dues fee or something ridiculous to that effect. But there's nothing that shows them together as a gang. Oh, well, wait, they are a gang because look at these pictures of YSL wearing green clothing. That must mean they're a gang. You guys are mostly in blue and black. You associate with each other here today. Are you guys a gang? The state is all in red today. Are they a gang because they're all dressed in red? Poor Miss Hingerty happened to come in red today. I guess she's a member of the gang as well. It is absurd. Lil Wayne has ESPN on his arm. ESPN. I guess Lil Wayne is surprised that he's a member of YSL too. My client's got ESPN on his body. No, that can't be because he was a football star and in his mind probably liked ESPN. It must be because he's a member of a gang called YSL. So it's wonderful that the state's gang experts have such insights into the mental thinking of my client and Lil Wayne and everybody else. Now, the state may say, well, they're not a gang, even though they all dress in red today, looking quite dapper. Because, well, they don't have some criminal objective. Well, I don't know. Let's look at the way the state indicts people. The state's around Investigator Viverito. Investigator Viverito is the last person I can find anywhere on video or that you've seen on video holding that missing $500,000 watch. Did she steal the watch? Was that an overt act and can further into the conspiracy? Maybe I should go to a grand jury and try to indict this. It's the state gang or something ludicrous like that. Everything gang investigators see is viewed from the viewpoint of it must be a gang. Mr. Kendrick, look at the photo they showed you of Mr. Kendrick in the bandana shirt. Go back and look at it in color. The gang investigator says it's red. It is orange. Orange as the sun. You look at it, you decide, don't take my word for it, don't take their word for it, don't take the state's words for it. Use your own eyes. But when you're a gang investigator, everything has to fit the narrative. And that's the narrative. The snake on Mr. Kendrick's chest. Did he get that snake because YSL is a gang? Or did he get that snake because it represents the tree of knowledge in the Adam and Eve story? Well, they can tell you. I saw a mentalist Saturday night at a show, and this mentalist was amazing. This mentalist, you would think of something, and the mentalist would tell you, "Oh my gosh, you're thinking of a number between 1 and 50. It's 47." It was actually quite impressive. Apparently, Investigator Viverito and these other gang experts are mentalists. Maybe they will be at the next fundraiser I go to. I'd like to see some more of their tricks. Mr. Kendrick does modeling shots. So someone will say to Mr. Kendrick, "Hey, hold this hat." Oh, that's gang. The hat has a rat with a line through it. That's gang activity. We're sending a message to everybody. There's a photo taken outside at the time of a video shoot for music. Oh my gosh. Oh my gosh, look at that. Gang activity. There's photos of Mr. Kendrick wearing clothes that say SLAT outside of a recording studio. More gang activity. More people trying to pull themselves out, get into music, exercise their First Amendment rights, more gang activity. It's just exhausting, folks. All right. The racketeering charge. Racketeering is very complicated, as you all know. And the state explained racketeering to you. So I'm not going to go into all of the details of what it takes for you guys to find racketeering. Although I do want to repeat, you have to find each of those elements beyond a reasonable doubt, and you're not going to be able to do that with Mr. Kendrick. So I only want to focus on a few parts. Just bear with me. It's late in the day. Late in the day. Just give me a little more time. A few parts of the racketeering charge. First of all, the state has not shown a conspiracy beyond a reasonable doubt. What is a conspiracy? It is an understanding to accomplish or pursue a common criminal objective. Criminal. There's been no common criminal objective shown. What has been shown to you and what was shown to you even earlier today? A series of independent, disparate acts over and over again. All kinds of different people committing criminal acts. I'm not going to argue to you that criminal acts were not committed, but they have not shown any relationship between these acts. They have not shown you anything that's shown it was done for a common criminal objective. That was not demonstrated. Again, as Mr. Sharp said, when Mr. Stevens was here, Tick, and Mr. Stevens was talking about selling pot, he did that for his own benefit. He's not paying up the ladder. And by the way, there is no ladder. Investigator Viverito told you because this is a hybrid gang, there's no structure to it. So I don't know how Mr. Tick is supposed to, Mr. Stevens is supposed to spread the money around. But it doesn't matter. They're going to say there's a common criminal objective. Nothing has been shown. Tick. I have to go on a side note on Tick, Mr. Stevens. Mr. Kendrick, Mr. Williams, they were trying to avoid the fate of Mr. Stevens. Mr. Stevens, remember, I'd love you to go back and listen, read his testimony. Remember, look at your notes. At the age of 11, society threw him away. They threw him away. They tossed him in juvie, where he learned about gangs and drugs and everything else. Threw his life away. And he's trying to get his life in order again. And he's dragged back into this. State says one of the objectives was money and power. Where's the money flowing? Where's the money? Where's the money coming in? The state had the power of the courts, their subpoena power. They could have gotten Jeffrey Williams' banking and financial records. They could have subpoenaed his accountants. They could have gotten all of that to see the money flowing. Did they do it? No. Why didn't they do it? Well, I'm going to argue to you they didn't do it because there was nothing there. If they did it, it would undercut their case about seizing Mr. Williams' assets, about seizing $8 million worth of jewelry that he earned in the music business, about seizing all of those cars, about seizing the ring off of his finger and keeping it. We don't want to see those records because we don't want evidence that he earned all of this from his music and his hard work. No efforts of money and power as part of a conspiracy deriving from this gang. The judge is going to tell you in your instructions, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. Mere association. And that's what you have here, mere association. A bunch of guys that grew up together, were around each other, and that some of whom were trying to make it out, and some of whom were trying to help others make it out. Mr. Kendrick was trying to make it out. Mr. Kendrick would not let himself be thrown away like happened to Mr. Stevens. So I don't believe there's a conspiracy that's been shown beyond a reasonable doubt. What else has the state not shown? Well, they've not shown a lot, but I'm just going to focus on a few. The state hasn't shown that Diamante Kendrick knowingly and willingly joined this conspiracy, and they must show that. Well, first of all, I understand their difficulty. I understand their problem. How do you show that you knowingly and willingly joined a conspiracy with a criminal purpose when one doesn't exist? So that's their first challenge. That's their first challenge. What did they do to try to show knowing and willing join? Well, he hung out with some guys that did some bad things. He allegedly is part of this YSL gang that's not a gang. And by the way, you heard testimony, Mr. Kendrick was signed to the YSL record label. So I guess he knowingly and willingly signed to the YSL record label, but that is not the same as knowingly and willingly joining a conspiracy. Depending on the outcome of this case, at least to this point, being signed to a record label, even a rap record label, is not a crime in the US. What else hasn't the state shown? They haven't shown a pattern of racketeering activity. And the key here is pattern. And part of the key to pattern is there has to be interrelatedness. And I'm sorry about the legalese. I promise I am. But I have to talk about it. These acts have to be interrelated. And instead, what you've seen for a year of your time is isolated incident after isolated incident. We're going to throw everything against the wall and hope something sticks. But even if a few things stick, if they're not interrelated, it is not a pattern. So I believe that when you look at all of the evidence, you're going to need to go back to the jury room. And I believe once you deliberate, you're going to find that Mr. Kendrick is not guilty beyond a reasonable doubt of conspiracy to violate RICO. The last charges are easier to discuss and we'll go faster. Every count, counts 57, 58, 61, and 63. These are the last four counts against Mr. Kendrick. All of those relate or based upon drugs and guns found at Jeffrey Williams' house. Not a single witness, photograph, fingerprint, lab test, DNA, everything you can imagine. Nothing shows that Mr. Kendrick possessed any of those guns and drugs. Nothing. When they arrested Mr. Kendrick that day, did they test his clothing for any type of samples that there might be drugs or? No, nothing. You didn't see any of that. Why was he arrested? Why is he arrested for drugs and guns? It's merely his presence at Jeffrey Williams' house that day. The judge is also going to tell you this, and bear with me while I read this, because it's too long to memorize. You are not authorized to find a person who was merely present at the scene of the commission of a crime at the time was committed guilty of consent in and concurrence in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. They're trying to show Mr. Kendrick guilty of those crimes just by being at Jeffrey Williams' house. I don't know about y'all, but when someone invites me over to their home, I do not ask before I go there, do you have drugs stashed away throughout your house? I do not ask before I go there, have you got a machine gun hidden under the couch in the basement? Have you got guns stashed in your cabinets? I don't ask that. And when I get to their house, I don't go looking for those things. Why did they charge him with this? Why did they charge Mr. Kendrick with this? Because, as I have told you, and from what you could see in this courtroom, Mr. Kendrick has done nothing but work on his music, but they have to drag him in. They have to suck him in to this vortex caused by their relentless, ridiculous pursuit of Jeffrey Williams. It is offensive and it is absurd. And presumably they felt they needed to do it to help out on the RICO case and to help get Jeffrey Williams. Briefly turning to each of those counts, count 57, participation in criminal street gang activity. That is purely based on his alleged possession of marijuana and a firearm. But again, no one got up here and said Mr. Kendrick possessed any of the firearms or any of the drugs at the house. Now, here's what the state is likely to say. This is what I'm anticipating. Possession can be one of two ways, and you will hear the judge instruct you on this as well. It can be actual possession, you're holding it, or constructive possession. Constructive possession requires the state to show that Mr. Kendrick intended to possess those weapons, intended to possess those drugs. So when the state tells you that, I want you to please remember what I've just told you and think, what witnesses have you seen? What evidence has been presented that Mr. Kendrick intended to possess those weapons or those drugs or that marijuana? Nothing. Zero. Donut hole, nothing burger. The other three counts, 58, 61, 63, those are all marijuana or firearms. And again, I don't need to repeat myself. While I have had wonderful help from Ms. Hingerty and Mr. Apt on this case, for the most part, Diamante only has me up here representing him. The state has an army of prosecutors, investigators, law enforcement to assist them. So, Diamante only has David. And I just pray that I have done my best to slay this giant Goliath that is pursuing him. The state has not met their high burden of showing guilt beyond a reasonable doubt. I would even argue the state hasn't met these lower standards either. It's just not been done. I think when you go back there and deliberate, you'll come up with the same idea, the same conclusion. This case against Mr. Kendrick should have never been brought. That same Saturday night when I saw The Mentalist, a friend was saying to me, well, your problem is that the state has the last word. You're going to get up and talk to the jury, but then the state gets to go again. And they're great lawyers from the state. And they may not remember what you say. They're going to have the last word. And I said, no, you are wrong. You are wrong. The state does not have the last word. The jury has the last word. You guys have the last word. Each of you will decide the fate of Mr. Kendrick. Each of you individually will decide whether the state has met their high burden on each of these counts and on each of the elements of the counts to show that he committed this beyond a reasonable doubt. When you go back and deliberate, I believe that you can go back and send the message that targeting people, fixating on individuals who have managed to climb out of their circumstance, attacking people for their music and their lyrics and their art is wrong, is wrong. Targeting only people of color for their music and lyrics is wrong. Winnie Lee, when he was on the stand, told you, he told all of us, Even though I am a Black man, not everything I write about is true or autobiographical. He has an imagination. Mr. Kendrick has an imagination. He has things to say about what he sees in the world around him, as does Wooney Lee, as does Jeffrey Williams. And the use of lyrics and artistic expression against individuals is wrong, it's un-American, and it shows the desperation of the state that they have to reach to that level in order to try to make a case against Mr. Kendrick. You can show that maybe, just maybe, we really do believe it when we tell people that through hard work, you can pull yourself up from wherever you came from. And that we, as Americans, as people, we believe in redemption. So I ask you to please remember that during and after the state's closing, to remember that when you're deliberating, to remember that each of you individually gets to make that decision of guilt beyond a reasonable doubt. So I'm going to ask for the sale, because that is what you're supposed to do, right? And I'm going to ask you to go back there, deliberate, and come back with not guilty verdicts for Mr. Kendrick on all the charges against him. Thank you for your attention. Thank you for the last year of your life that you sacrificed to be here and fulfill your roles as citizens. I really appreciate it.
All right, let's take a short break, which is going to be our last break of the day. Then we will hear from the state again. Then I will release y'all for the day. We'll come back tomorrow. I'll give you the instructions. So let's take, maybe a 10.
I almost wanted to applaud after that, y'all. He had me almost wanting to do a clap. I think Hylton was upset at Doug bringing up Doug doing the race. Oh, I said race car yesterday, and people got on me. So let me not say race card again for y'all get mad at me. Let me not go there for y'all start. That's not the race card. Okay, because I get it. It's a negative. Y'all schooled me on that yesterday. But Hylton didn't like him bringing up race as a factor. So y'all sure you don't want to listen to Hylton again? Y'all sure you don't want to see the Hylton stuff? Y'all don't want to watch Hylton again do her thing? Yeah, I know race matters. It's just yesterday when I said race card, people weren't feeling it. All right, who wants to see Hylton again? Some people are really against watching Hylton again. All right, cool. All right, okay. Gosh. All right, gosh. Okay, so, all right, we won't do Hylton. All right, so then what do we do, y'all? We are officially 1 hour. Probably this is about 10 minutes. I think 10 minutes slow. So we're about an hour and 15 minutes into the deliberation. Let me say this. Yeah, the reason why people don't want to see Hylton again is because Hylton's closing argument yesterday was, you could call it a disaster. Love did not do any closing arguments, Kiera, so there's really no love to play. Oh yeah, Andre, I was trying to say, and I'm thank you for your explanation, Queen. Andre, an individual cannot launch a RICO charge against somebody else. RICO is criminal. Only the government can bring criminal charges. So anytime you hear that this person launched RICO against that person, you know it's not correct, because this person, this business, they cannot bring RICO charges. The only organization that can bring RICO charges is the government. So Drake cannot bring RICO charges against Kendrick. Now he can bring a civil action, and he can cite RICO elements of RICO in his civil action, but it's still a civil action. It is not a criminal action. RICO is criminal. Y'all don't want to watch Hylton. So what do y'all want to watch Max again? I mean, y'all, we have to fill the time with something, right? They're going to be deliberating until 5. We should keep this stream going at least until the end of the day, just in case. Hylton will trigger people because Hylton's her performance was quite unorthodox, I imagine. Love's opening statement. The only reason I don't want to play that, Ty, is because the sound, the audio was, y'all want to see that? I'll put it on, but gosh, the audio was so bad back then. The audio was so bad back then. Hold up. But I'll put it on, why not? But the audio was really freaking bad at that time. I think y'all might have forgotten how bad it was. Plus, there was a motion for mistrial as well. So I'm finding it now. Bear with me.
Is that right? Okay. We talked a little bit about meals and how you can, there's a cafeteria that's directly behind you. We talked a little bit about that. Since you were here, you like the space back there? Yes. It no longer looks like a dump. We painted it, got you some fresh tables.
All right, y'all. Here we go. I still have not played the press conference for Wise Gal. Is Wise Gal on right now? Wise Gal, are you on right now? If so, we'll play this press conference for you. Are you here? Andre, you shouting out Wise Gal. You don't even know if she's in the chat. I'm not. Yo, how can somebody tell me to stop talking on my own stream? I don't understand this. I'll talk as long as I want to talk. Wise Gal is not here. All right, then we're just going to go with Love's opening statement. So this is for everybody who wants to see DA Love in her opening statement.
Now, this is the law of the jungle, as old and as true as the sky. And the wolf that shall keep it may prosper.
All right, no problem, buddy.
But
No
the
problem.
wolf
No
that
problem.
shall break it must die. As the creeper that girdles the tree trunk, the law running forward and back. For the strength of the pack is the wolf, and the strength of the wolf is the pack. Thank you so much, ladies and gentlemen, for being patient. Thank you so much for being honest during this very lengthy process that preceded this point here today. During the voir dire process. I appreciate you all being here, exercising your civic duty, and honoring your obligation to pay close attention to what's going on in this courtroom for the next several, however many weeks. some people like to say that opening statements are a roadmap to what the trial will show. Instead, I'm going to give you an overview, a bird's eye view, because you're going to be sitting here with evidence for the next several weeks at least. And you will be able to see what that evidence is. Nothing that I say to you during this part of the trial, nothing any other attorney says to you during this part of the trial is evidence. But I can tell you what I expect the evidence to show. And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book. In case anybody recognized it, those were Rudyard Kipling's words and not mine. But they are appropriate for where we are today. For 10 years and counting, the group calling itself Young Slime Life dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members. It consisted of 3 or more members with common identifiers, signs, colors, linguistic choices that committed crimes on behalf of and in furtherance of Rock Crew itself. That particular organization aligned itself under an umbrella of a larger, more traditional street gang called Sex, Money, Murder, Bloods. They adopted the nomenclature. They would do things like replace C's in words with the letter B, because traditionally Crips and Bloods were not aligned with one another. So Cleveland Avenue became Believeland. Some of you may have indicated during voir dire you've heard or are familiar with the Cleveland Avenue area. Maybe you've even heard of Cleveland Avenue Day. The evidence will show that this is where that comes from. The evidence will also show that sometime in 2012 or thereabouts, an internal rift or divide occurred among the members of Rock Crew. Now, the defendant, Jeffrey Williams, seated back there yawning right now, he was an original member of Rock Crew. And the kind of crimes that Rock Crew did consisted of smash and grab burglaries, stealing ATM machines, things of that nature. When Rock Crew split up, YSL, or Young Slime Life, was formed. And the defendant, Jeffrey Williams, was its proclaimed leader. Young Slime Life came about and consisted of 3 or more people when it began. 3 or more people who were willing to and who did commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL, because this was a group of people associated, in fact, who used common identifiers, common names, common colors, common symbols to communicate with one another and to express themselves to the rest of the world. So YSL, as the evidence will show, they didn't move individually. The members and associates of YSL, they moved like a pack, with the defendant Jeffrey Williams as its head. You'll hear from witnesses, both law enforcement and lay witnesses, who personally experienced and who personally witnessed the activities, the crimes that were committed. You will hear from law enforcement officers like Kimberly Underwood and Tyrone Dennis, whose main goal wasn't to go out in the streets and lock up people who looked like them. It was actually to touch souls in the streets, to touch young people, and to alert them of the dangers and the drawbacks of becoming a part of and becoming involved in gangs like YSL and Rock Crew. You'll hear about conversations with educators. You'll hear from members and associates of the gang itself. Now, as to how those members and associates will respond or act once they're actually in court and on the stand, that's something that I am truthfully not able to predict to you fully. But the court has given you instructions on determining and judging the credibility of the witnesses. And I trust that all of you will in fact follow those instructions. The evidence will show that YSL checked all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft, theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotic sales. And last but certainly not least, murder. What you will not hear any evidence of is that the defendants were not involved in a criminal street gang. You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now, this is
Let me object to that statement, please, as burden shifting.
Object basis?
Burden shifting. And under Parker versus the state at 277.
Why don't we take that up and I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
Yes, Your Honor.
Just rephrase it. Ladies and gentlemen, I'm going to explain to you at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier, that the burden never shifts to the defendants to prove or certain innocence, they're presumed innocent. And it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time, okay? All right.
The evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The defendants on trial here today have, through their actions, displayed not only their allegiance, their alliance with one another and with the gang itself. Through their actions, they have displayed an unspoken agreement to participate in that gang through a pattern of illegal activities. And again, the head of this gang is seated in this courtroom too. The last paragraph of that poem that I read or spoke to you earlier goes as follows. Because of his age and his cunning, because of his right.
This is argument. This is not.
What's your objection, Mr. Harvey?
That it's argument.
Okay, Mr. Harvey, hold on. Madam, it is argument at this point in time, so I'll sustain the objection, okay?
Yes, Your Honor.
All right.
The evidence will show that these defendants, that the members and associates of YSL, they knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when members and associates of YSL got in trouble, got locked up, the first person they called was either this defendant or one of his family members. Now, they didn't call him directly because he knew and they knew that he needed to have distance between himself and the crimes members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have his sister reach out to somebody else and eventually get back to King Slime, as they call him. You will hear evidence that members of YSL committed armed robberies. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members. You'll hear evidence that when one of the associates or members of YSL did something to what Jeffrey Williams had perhaps considered a friend, they were threatened with their very life. Tell them to get that stuff back or they will be killed. You'll hear evidence that YSL, they had opposition within the city of Atlanta and Fulton County. That there were other gangs that were at various points in time at odds and even at war with YSL. One of those gangs was known as the IF gang, IF, Inglewood Family. You will hear experts come in here and tell you more about how the Inglewood family bloods in any way made its way down to Fulton County. You will also hear evidence about how one of the members, one of the beloved, of whom YSL considered an opposition group, was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies, 2015. Gunned down, openly and notoriously. Because the evidence will show that part of the reasons that criminal street gangs operate the way that they do is to establish dominance and to establish control and to establish fear. You're going to hear that this gang stole at least 3 lives from this community over the last 10 years. At least 3 that are referenced in this indictment. You'll find that as a result of this gang's activities, a young woman who had nothing to do with either YSL or any of their opposition was gunned down by people trying to get back at YSL for what they did. You'll hear evidence that after the murder of Donovan Thomas, no less than 50 shootings occurred over the course of the next several months. You'll hear evidence that hundreds of bullets were fired into cars, into homes, and into people as a result of the rift young Limelight had with other people in the community. So what are they accused of, and what are you here for today? The judge read the 4-hour-long indictment to you 12 months ago. He didn't read it to you again today, but he generally gave you what each defendant is being charged with and what the state has the burden of proving beyond a reasonable doubt as it relates to each defendant. But just to broadly touch on those, the crimes that the state will be proving to you over the next several weeks include conspiracy to violate the Racketeer Influence and Corrupt Organizations Act. That is an absolute mouthful. So we'll just say RICO. There's no substantive allegation of RICO violations here. And by that I mean there's a difference. Here the state is alleging that these defendants, they had an agreement, unspoken, but no less an agreement, to obtain property, things of value, cell phones, cars, stolen guns, through a pattern of illegal activity. The evidence will show that it's sort of like if two people said, okay, you know what, we're gonna go toilet paper our dean of admissions house. And they sat there thinking and talking about it, and someone overheard them and reported them to the police. And the police came and said, okay, I'm gonna arrest you all for conspiracy, for planning to go and do this. The evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those two people to be found guilty of conspiracy. So say one of you goes and says, let me go get the toilet paper now. Then y'all are in trouble. That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023, after this case was indicted, as the evidence will show. But their actions are what the state will be looking to you to evaluate and determine. Does this action show that they're agreeing to participate in this organization, this enterprise, through racketeering activity? You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses out of which drug sales were conducted, where they held Longhorn guns by the door, where they stood ready to act on command if either one of their number called. Who's on trial before you today is Rodelius Ryan, Flamarvius Nichols, Marquavius Huey, Jeffrey Williams, Shannon Stilwell, Diamante Kendrick, and their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor. You have an objection? Yes, sir. Basis. A motion. All right. Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters at your deliberation room, and we'll call you back in just a minute, okay, when we finish up our business, all right? Remember the court's admonitions, ladies and gentlemen. All right, please be seated. Our jury has left us. All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to this honorable court's attention? 1. And 2, how do we just violate court orders? So yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
All right.
And I'd like the screenshot to be captured for Mr. Weaver to put in the record.
I'll admit it as next court exhibit in order of the state's presentation anyway. So, all right. So that'll be court 1 for purposes of the trial. So, Ms. Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
As it relates to Mr. Ryan and the exhibits that the state intended to play and to display for the jury, I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use. As it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal, I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence that the state expects will show, or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
Don't represent Mr. Ryan.
Mr. Blaylock, then.
I would never said this ever. That's it.
Okay, what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before this honorable court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
Brought up to this honorable court, outside the presence of everybody. We're an open statement. I am lied to. I am saying that. I am lied to. Or if anyone else got that exhibit, I did not get that exhibit. And I see everyone's head shaking no. And now it goes against the court's order. We are bound, duty bound to follow some of the court's order.
I'm going to join in the objection on behalf of Mr. Steele.
Let me see the.
I can put it back up.
Yes, ma'am.
And Your Honor, while I am putting that back up, I will state in my place that initially when there was the objection from Mr. Steele, I didn't have a clue what it was about because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that, I ruled upon that last week. I did. That we were not, I would take it as it came in this case. And if the evidence got to that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
and Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask for a curative instruction and a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have
all right.
The slide.
Well, now
I have it now. I'm
court
about to
has
share
court one for purposes of the motion for mistrial. All right. Yeah, on slide 11 of 65, that I see where you have that at the bottom, represented by Brian Steele. So we can leave that for the time being. Leave it for the time being because it is what it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time. So
curative instruction on the first day of court, y'all. And as y'all can see, none of these curative instructions, none of these limiting instructions, none of this stuff was repeated. None of this stuff was repeated. I don't know if the jury is getting this in a written form. I don't know if they're getting this in a written form so they can consider this as they deliberate. Curative instruction on the very first day. And how many more of these instructions were there throughout this trial? And how the heck is a jury supposed to take all this into account when it started on day one of a year-long trial? Anyway, let's keep going.
I'd like you to do me a courtesy, if you would, and allow me to do that now and preserve the motion for mistrial.
You've made your motion for mistrial, and the basis, and I'm going to mark the whole state's presentation as is as court one for the purpose of your motion, and it will go in as stated.
And I have two other issues I'd like the court to just take up. One is just remember, I know you ruled on it, but the state said earlier today.
All right, Ms. Love.
Yeah. Thank you, Your Honor. Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made.
Sorry, Kimberly, it's not a curated instruction. I don't know if that's just a typo from your phone or what, but it's a curative instruction. So you're giving an instruction to the jury to cure something that just happened. So what happened was they saw something they weren't supposed to see. So you might try to cure that by telling them to disregard it or not take it into account or something like that. So you're trying to cure a mistake, basically.
About other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at
I'm going to
trial.
deny that portion, but to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it, and it also is subject to foundation, and just like this. So I assume that what you told our jurors is what you expect the evidence to show. Yes.
Yes,
All right,
definitely.
so I'm gonna overrule that part of his objection. What about the last thing you mentioned?
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name on here.
I got that, but he's talking about, is there anything else you're going to use in opening you haven't shown to defense counsel? He's telling us, well, I said that. I told you to do that a week ago.
Your Honor,
because here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. So have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, can you find out if our jurors are ready? Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Your Honor, we have a few. Your Honor, Jay Apt on behalf of Mr. Kendrick, can we have 5 or 10 minutes to review whatever Ms. Love is going to send us?
You can take a comfort break, and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch. Okay? All right, have we concluded our sharing exercise? I told you all to go ahead and talk with each other through when we broke.
I did share it, Your Honor.
All right.
If I may, Your Honor.
Yes, ma'am.
Regarding the court's earlier concern brought to the court's attention by Mr. Williams, Ms. Hylton shared with me what was said on the bench. But as it relates to Cordelius Ryan's post after the murder of Shamel Drinks, that was provided from day one in discovery, Your Honor. And it is not a crime that he is alleged to have committed. We may have put that on a list, including things, but Your Honor, that is not an intrinsic act in the sense of it being a crime or criminal act. And it is what the evidence is going to show happened. What I have in the PowerPoint, I can show to the court if you like. I sent that to defense counsel prior to today. I think I sent it Friday before 5. But what I have said is that on the day that Shamel Drinks was, I'm sorry, Jamari Holmes, my apologies to the court and to the family members here. What I said was that on the date that Mr. Holmes was gunned down, 12 hours after that murder, Mr. Ryan posted on his Instagram account, I bet YSL makes the news. And what I endeavored to say to the jury, that the evidence will show is just that, that they were advertising and representing and boasting on behalf of the gang itself immediately after the murder occurred. And these are elements that the court, I believe, will hear from detectives and evidence. These are things that the courts have said jurors and the courts should look to in determining whether something is done in furtherance of a game. And so I would ask the court, I didn't take it out as the court instructed. I would ask that the court allow you to make reference to it. And thank you, Your Honor, for your time.
All right, Mr. Williams. Oh, sit down, Mr. App. You can just wait a minute. All right, Mr. Williams. What's your response, madam?
That the court already ruled on that, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court already gave.
Okay, but it may not be what I think that Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily be intrinsic. It might be for another purpose, is what they expect the evidence to show. So, but here's the issue that kind of I'm disappointed is the court. You all could, we've had months and months and months. We could have taken this up before. I could have made it very clear. I don't need to take it up right on the eve of our jury sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to seek clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so. So I don't think it's intrinsic. It may be for other purposes, and I'll let the state reference that if they have a good faith basis to, that if they believe that's what the evidence will show. Okay?
They put it in their motion as—
Say again, madam, I'm sorry.
They put it in their motion as intrinsic evidence, though. So they shouldn't have put it in their motion if they were going to—
Yes, ma'am, I would probably agree with you, but did I ever rule on that issue?
You said that you would do it later as it came
Okay,
out.
well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity on it for both sides. But do you have any other basis for the ruling? I mean, for my ruling, madam, any other argument?
No, just I wish that the court would just follow their own instruction.
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner, okay? And give me the full breadth of, so I can rule upon it accordingly. That's what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old, Shymel Drinks, and my client has nothing to do with that.
That was another area I'm correct.
But I didn't get that
Ms.
slide
Love says
presentation
Ms.
earlier.
Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
Okay, all right. Now, Mr. App, what is it you want to tell me?
I am so sorry, Your Honor. But thank you for allowing me to speak. I do have an objection, Judge. So, Ms.
What's your objection specifically, sir?
Attempted to email us during the break the PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsels and staff, and Mr. Matthews was able to open it, and I looked over his shoulder and was able to see some of it. There are at least a dozen more slides that were never turned over to us, even though the court instructed us to share it with the state and for the state to share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. I'm objecting because the court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening argument.
Yes, ma'am, and then I'll go on to the next person.
Thank you, Judge.
Yes.
Your Honor, I did not send only 4 slides or attachments. I sent to counsel for the defendants the photographs, the evidence that I intended to put into the opening PowerPoint. As far as the state's theory of the case and theme of the case and the words that I wrote, those are things that were being developed, ongoing, and I did not understand the court's directive to me that we needed to turn over the words we would be speaking. As far as these photographs go, Judge, I said to them, if they can, actually, I sent them to them. So there are some, I have only about—
Your Honor, they're done.
Hold on, wait, let her finish, and then I'll let you respond, Mr. Abbs.
So all of these slides that involved Christian Eppinger. I sent to them. And other than the slides involving Christian Eppinger, there is a slide of the vehicle that Donovan Thomas drove on the day he was gunned down. It's the back of the vehicle with the placards of showing the bullet defects. That will be shown. There's no one that has made any objection to that evidence being introduced at trial. Nothing that I have put in the PowerPoint includes anything that has been objected to as being admissible at trial. And I believe that I'm not certain if Mr. App thinks that we only served 4. Maybe, I don't know if he had trouble opening it up, but we served, I think, all of them, if not the great majority of them, because I don't have that many. I don't even have 20 photographs in this PowerPoint. So everything, and I can show the court, I will share it if I did not with the court as well. But these photographs, I have a picture of Donovan Thomas in life. I have a picture of the barbershop where he was gunned down. I have a picture of the back of Donovan Thomas's Tahoe. I have a picture of Donovan Thomas's headshot. At the time of the autopsy, no cutting, no nothing, just his face with the number. I have a picture of, as I stated earlier, Your Honor, the truck with the defects noted. And then I have pictures of Christian Eppinger, all of which were provided, and that's the extent of it. The majority of the slides have my words, my work product on them.
All right, Mr. App, before I go ahead and respond.
Your Honor, no one's suggesting that she had to turn over the text of her opening argument, but if she's going to show a PowerPoint to the jury, that is what the court instructed us to share. We're visual exhibits, and that's what she's doing. She's placing it up on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative, she could have shared it, and she didn't. And she did it. And she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think if that's the case, then she's just lying to the court. But if that's not the case, and she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared with prior to opening. If there's no one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of her opening that violates this court's order that we were supposed to share our exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening. And if she wants to introduce them later as evidence during the course of the case, then so be it. But I think there is good grounds for this court to, and Your Honor got upset because these issues could have been handled. They didn't have to wait until now. This is wasting time while the jury's waiting. Your Honor's right. And it's not our fault. It's her fault for not doing what the court instructed. And as a result, the appropriate and reasonable remedy is to prevent her from sharing any of these slides with the jury that she did not share with defense counsel prior to today. Whether they're evidence or whether they're text is part of her opening.
All right, Mr. Matthews.
Yes, Your Honor. Good morning to the Honorable Court. I'd like to direct the state's attention to slide 15. In slide 15, the third bullet point, it references October 1st, 2020, in terms of that quote from the text message. In the indictment, Your Honor, if you look at Overt Act 102, that's where that particular quote comes from, Overt Act 102. In Overt Act 102, the date of that alleged text message was March 12th, 2020, not October 1st, 2020, as in the PowerPoint presentation. So number one. Number two, the quote in the indictment is different from the quote in the PowerPoint. So that's two errors in slide 15 pertaining to Marquavius Huey. And then you go to slide 16. Slide 16 is an overt act that is alleged in the indictment as overt act 123. In the state's opening presentation, the date they have is October 1, 2020, but in the indictment, that particular overt act is November 16, 2020. So that's a third error in the state's opening slide presentation. So those need to be corrected to mirror the indictment so that it's not misleading the jury and in fact giving wrong information to the jury judge. So I would ask that the state correct that, remove it, or correct it.
All right, anybody else? Yes, Mr. Short.
Your Honor, on behalf of Mr. Stillwell.
Speak up, please.
On behalf of Mr. Stillwell, slide number 47, it suggests that Mr. Stillwell is still committing crimes on behalf of the gang, even after being indicted on these charges. We began to discuss intrinsic acts and other unindicted allegations last week, but we did not get through it. And my understanding was that anything that you had not ruled upon, we were not supposed to reference or discuss in opening statements. So those are clear references to unindicted charges that we did not get a ruling on its admissibility yet. And I would ask that that just be taken out of the presentation and no mention be made of those.
Anybody else? Yes, Mr. Steele.
Thank you, sir. If you would look at also number, I'm looking at now, 48, 49, 53, 54, 55. That's your prerogative, that's within your zone, that's law.
Would the court allow Mr. Steele to repeat those slide numbers? Because what I think that he's referring to is something that I placed in here that the court said during its preliminary instructions to the jury. And it was regarding the court, as a matter of fact, it was the last thing that the court said. And all that I did was put on the slide, judge's law.
In terms of what slides are you talking about? Mr. Steele again?
I have 48, 49, 53, 54, 55.
So 49, 48 through 55?
Excluding, so it's 48, 49, but then skipping to 53, 54, and 55.
48 and 49. Your Honor, may I share via Zoom the slides that Mr. Steele?
I would, yes, please.
Thank you. And you said, Mr. Steele, you said 45?
Just share the presentation, please.
Yes,
So how many of y'all remember that this trial was like this from day one?
Okay, so Your Honor, I'm showing on the screen slide 48, which is the last thing that the court.
Take notes.
Yes, Your Honor.
All right.
And
49.
That was directly from what the court just said.
All right. 50.
And 50.
It's not 50, sir, 53.
53. Okay, let's get down to 53. And 53 is what I expect the evidence is going to show. So I'm going to, in speaking to the jurors regarding the witnesses and the instructions that the court has given them, I'm going to say to them, some of them, as I've already alluded to, some of them may not be wanting to speak. Some of them, you're going to see evidence that some of them are afraid angry, some of them are embarrassed, some of them are intimidated, some of them don't remember, some of them don't want to remember. That's simply what the evidence will show. And Your Honor, what I'm asking that the jury does in listening to and considering the testimony of any such witnesses is, as the court has already instructed, which is just to use your common sense, because you alone decide who you believe. We're asking you to listen carefully, take notes, and pay attention. So there's nothing in that slide 53 that is in any way infringing on or entering into a lane that does not belong to the state. We are entitled and allowed to show and to state to the jury what the evidence will show. The way that I have decided to represent it in writing makes it no less so.
Yeah, but it borders on argument at this point in time.
So if I can change it, because I do expect that the evidence will show that some of the witnesses are afraid, some of the witnesses are embarrassed. So I can take out.
Well, that's different. You might want to just redo it.
I can do that.
Any further objections, folks?
Yes, Your Honor. I went over to the state's table, Carson Matthews, I went over to the state's table and brought to their attention an error in slide 42, and I think it's incorrect.
All right.
Is that correct, Nate?
Not yet, but in a moment.
All right, here's what I'm going to do. Folks, this is exactly why I told you I wanted you to, and let me go ahead and just say this. Ms. Love, I told you to give them your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out if there's something they object to. So this is what's caused this delay. Because at this point, like I told you, there's no secrets in the trial of this case. You all have gone through quite a long process. But this just highlights the concerns the court had in terms of just breaking up the presentation for our jurors. So what I'm going to do, ladies and gentlemen, I'm going to go ahead and call our jurors out. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30. During the lunch hour, Ms. Love, I want you to play or the slides that you have that otherwise have not been shown. You need to show them to the defense counsel and make sure they're correct. In the absence of them being corrected, I'm going to exclude your presentation.
They have the presentation.
But it needs to be correct. I don't want, if I get another objection about an error, I'm going to exclude it for the purposes of the opening statement because you didn't follow my instructions. This is why I told everyone. They need to get and the defendants needed to give you their opening statements and the things they wish to use during their openings as well, because we're having interruptions and delay, and that's what I wanted to avoid for our jurors. That was the reasons I told you all to do that. So,
Your Honor, as far as any typographical errors,
I'm not worried about that. But I'm not worried about that. But the errors that Mr. Apt, Mr. Matthews, and Mr. Sharp have made are errors, and Ms. D. Williams need to be corrected. Okay?
yes, Your Honor, I will, of course, do it.
But everyone else needs to see it so they can be comfortable and make sure that you represented something that what you expect the evidence to show to be correct. Okay?
Thank you, Judge. Will do. And Your Honor, I also wanted to point out to the court that even if I misspoke, the court has already instructed the jury and will continue to instruct them that nothing I say is evidence, and if I misspeak or miswrite,
But that's not the point. I'm going to tell them that. And I told them that already. But that's not the point. The point is so that we can have a smooth and orderly presentation of evidence. Okay? So, all right. Sergeant Ingram, can we go ahead and call for our jurors, please?
Your Honor, we'll look at also number 6-2.
You can go ahead and take up that during the recess. Okay?
Yes, sir. Thank you.
All right.
Good.
Yes.
Verdict is no. Verdict on the table at the moment. So let's go into part 2 of the opening statements. Do y'all want to know something? I think I told y'all this. Something crazy. When Brian Steele says truly humble under God, I got copyright claimed on that. So I'm going to have to find out where he says that so I can avoid that. Let me pull up the transcript. Oh, okay, it does have a transcript. Let me see how far into this opening statement he says truly humble under God. Okay, so he says it 24 minutes in. So 24 minutes in, when he starts saying truly humble under God, I am going to have to do something. I'm going to have to mute it out. Yeah, they're still deliberating. It's been 2 hours. When I play truly humble under God, he's going to say thug stands for truly humble under God. When he says that, I got a copyright claim on that. No joke. No, I'm totally serious. I got a copyright claim on him saying that. So it's a pain in the, you know what, to have to go back and cut that out. And YouTube takes hours and hours to cut it out. So when we get to 24 minutes and 30 seconds, when he's about to say that part, I'm just going to skip it. So we'll play it for now.
Happy holiday season to everyone. Jeffrey Williams was born into an environment, a community, a society that was filled with depression, despair, hopelessness, and helplessness. He was born and raised in the Jonesboro South housing projects. That's here in Southeast Atlanta. It's a very small 3-bedroom apartment. He lived with his 4 brothers in one of the small bedrooms. His 6 sisters lived in the other small bedroom, and his mother lived in her small bedroom. In the wintertime, it was freezing. In the summertime, it was scorching, because there was not that much money to go around to pay for utilities. The refrigerator and the cabinets hardly ever had any healthy food, and sometimes no food at all. In order to have the appearance of being able to wear different clothing, Jeffrey would share clothing with his brothers and sisters, neighbors, and friends in the community. And although the clothing was oftentimes dirty, at least it gave the appearance that he can have a different look from the day before. When Jeffrey would exit into the community, most homes' windows were boarded up. There were burglar bars on every entrance. There's litter. It's not uncommon to find shell casings and human blood remains from the shootings that occurred. There was glass on the ground from the broken window of the cars. The cars are gone. In this environment of severe poverty, severe crime, Jeffrey developed two deep, embedded beliefs about our criminal justice system. The first one is that it is not justice. Our criminal justice system was not just, at least for people that he saw. Jeffrey would see over and over again people in the neighborhood who were known to be the liars. These are the people that would lie to their kids, lie to their mothers, lie to their brothers and sisters, and then somehow those people would be used by prosecutors, allowed to come before judges. And they would have reduced charges, reduced prison sentences, reduced probationary sentences, no charges at all, on their oath that they come in the courtroom to tell the God's honest truth.
Your Honor,
You have an objection, ma'am?
I have an objection.
What's your basis?
Your Honor, I'd rather approach and not speak it out loud in front of the jury. It will take 1 second.
All right.
Thank you.
Yo, is that the same red blazer she wore? Is that the same red blazer? She started off red and she finished red, y'all. Somebody else might have said that. I was doing something. Also, she read and she read, huh? She read and she read and she read, huh? Oh, okay.
Jeffrey learned that these liars, these snitches, these rats, they would come into the courtroom, take a witness stand to tell the God's honest truth. They were still the same liars. And they would testify against people accused of crimes. Jeffrey thinks that the entire justice system is corrupt. It should be blown up. And everybody who feeds into that are awful people, stealing lives away from others. The next abiding belief that Jeffrey had growing up is his despise for the police. He would see people walking on the streets. This could be an adult, teenager, a child, wearing their backpacks,
holding a football, bouncing a basketball, and the police just swarm in. They're aggressive. They search the backpack. They throw the football over the house. They kick the basketball down the road. It got to the point when people saw the police coming, they just ran. It's different experiences in different parts of America. It's different experiences in different parts of Atlanta. Jeffrey would be driving with his sister, the youngest sister, Dora. They're about a year apart. Dora is younger than Jeffrey. She's the youngest of 11 children of Jeffrey's mother. Jeffrey's the second youngest. He's the youngest young man. Those two, Dora and Jeffrey, are the same father. None of the other 11 children of Jeffrey's mother share the same father. And Dora and Jeffrey would be driven, get pizza by their dad, and constantly. The car would be stopped for a window tint violation, a failure to maintain a lane, failure to use a turn signal, illegal left turn. His father would be handcuffed and sat on the curb, Jeffrey and Dora on the other side of the curb, the police rummaging through the car, saying, if we find anything, these kids are going to DFACS custody. That's how he grew up. So what really solidified Jeffrey's distrust for the police happened 3 days before his 9-year-old birthday. Jeffrey's born on August 16th of 1991. We are now August 13th of 2000. Jeffrey's older brother, they called him Beanie. He was 20 years of age, 11 years older than Jeffrey. He's shot in the chest. He collapses outside, not far from Jeffrey's apartment. The neighborhood comes out. Jeffrey and his family come out. They're praying over Beanie. It's going to be okay. There's help on the way. 911 was called. And when it seemed forever, when the police finally did arrive, they didn't go immediately to Beanie. They had to push back the crowd. Jeffrey's mother was hysterical. She was screaming for her child to survive. The police handcuffed Jeffrey's mother, put her on the ground. And when they finally went to Beanie, put a sheet over his face. Beanie was dead to the police, even though his chest was still going up and down, he still breathing. The Jonesboro South housing projects were closed by the city of Atlanta in the year 2007. Jeffrey's now 16 years of age. His family was displaced. They were scattered. Most of them, not all of them, reunited and were now living in the Cleveland Avenue area. Jeffrey was not educated in his home about go to university, work as a flight attendant for Delta. Somebody would loan you money so you could start a business. Jeffrey believed that the only two ways he can break the generational hopelessness and despair for his family, himself, and he wanted to break it for as many people as he could who are in this struggle, was to be a professional athlete or an accomplished musical artist. Jeffrey chose the latter. And from that day forward, every week, every month, every year, to this day, Jeffrey practices to make himself a better musical artist. In Jeffrey's neighborhood, Rap. It's a subset of hip hop. Gangster rap is a subset of rap. That was the most popular music at that time. So Jeffrey sought to find out how can he accomplish his mission to be a successful rapper. So he had the internet. They were poor, but they had phones with the internet. So he would Google and look up and get on social media every accomplished rap artist and see what made them special. And Jeffrey would listen to beat after beat after beat. These are billions of musical chords that he listened to. And he tried and he forced himself to be able to speak fast within the beat and rhyme words. Jeffrey can't sit there and write out the words. He doesn't spell well. But he can listen and learn and look up what words mean, or just make up words to put them into the beat. And Jeffrey studied 2 rap artists particularly. He idolized a gentleman named Dwayne Carter. His performing name is Lil Wayne. Jeffrey also idolized Tupac. And Jeffrey looked at what is Lil Wayne doing that's making him so successful, because Lil Wayne is right before Jeffrey. He is born on September 27th of 1982. He's 9 years older than Jeffrey. And Lil Wayne, by the time that Jeffrey came along, has exploded. He is a superstar. And Lil Wayne changed the culture. It was more than just the sound of the music. Now, Jeffrey studied Lil Wayne so much, he sounded like Lil Wayne. You're going to hear witness after witness that Jeffrey sounded just like Lil Wayne. But Jeffrey realized that Lil Wayne had a following, a fan base, and people who dressed like Lil Wayne. It used to be that rappers wore baggy pants, big uniforms from teams. Lil Wayne changed it. He wore proper fitting pants. Lil Wayne tattooed his face. He's the first one. Jeffrey has tattoos on his face. Jeffrey changed the clothing. He took what Lil Wayne did, and Jeffrey wore tight fitting pants. He's the first. He did that because when he would take his ill-fitting clothing from his sisters, they were tight jeans. Jeffrey wore tight necklaces. He wore dresses. He realized in order to become successful and to accomplish his mission of breaking those bonds, he had to capture people's experiences and make it interesting, both musically and creating a brand. He's advertising. Jeffrey was called Little Jeff. His father is Jeffrey Williams Sr. He was called Big Jeff. But Jeffrey is sounding like Lil Wayne. He's trying to emulate Lil Wayne on social media. He called himself Little Jeff and Lil Wayne. He thought that doesn't sound too good. That's a bridge too far. So Jeffrey wanted to have a performing name. So he looked to Tupac. You will learn that in 1983, the incomparable talent Michael Jackson released a song that went around the globe, P.Y.T., Pretty Young Thing. About 13 years later, Tupac is featured on a song with Smooth. And that song is P.Y.T., Playa, P-L-A-Y-A, Young Thugs. And on that song, there's a repeat of words. And this really connected with Jeffrey. It's a black man that not too many understand. That's what Jeffrey felt about people with nice color skin. Jeffrey had interest in women, but he never considered himself a player. A player to Jeffrey was somebody who had the girls kind of coming at them at all times. Jeffrey wasn't like that. Jeffrey was shy. He was really tall and really skinny. He was malnourished. His teeth were rotten. There was no money to go to a dentist. And all the sugar from the candy that he ate to keep substance in his body rotted his teeth. So Jeffrey would speak by covering his teeth with his lips, or often speak like this with his hand or his arm over his teeth. Because
all right, people, it's 5 o'clock practically, and I think I can leave this stream going if y'all want. I'll just let it run and run and run, or we can end it. It's up to y'all. What I did want to do is just show you this from Joseph Papp. Y'all go follow him, Joseph, JOZEFPAPP_ on X. He's normally in the court doing excellent reporting. And I just wanted to show y'all the breakup of the jury, or the breakdown. Okay, I'll just put this back on. I'll put opening statements back on, y'all. But I wanted to take this opportunity to just show you this real quick. The jury makeup is black women, 7 black women. What's the chances that these are mothers? Probably 6 of the 7 at least are mothers. I would be surprised if they didn't all have kids, but probably at least 6 of the 7 would be moms. So would they be moms? Would they be more likely to think, what if my son or daughter wasn't here? I would want justice. Or would they be more likely to think, what if my son was accused of this kind of thing and he didn't do it, right? So we don't know. Black men, 3. Okay. 1 white man. Did y'all get the sense that
are there in the jury room, let a deputy know, and we'll bring the evidence in. We'll secure it each night when y'all leave. So we'll bring the evidence in and y'all can start deliberating again. Don't deliberate until all 12 of you are there. And I'm just going to probably read y'all the entirety of the jury admonition. We're not every day gonna start out in court and then end the day in court. Y'all will just go to the jury room and do the same thing each day. Just wait till the 12 of you are there. Tell the deputy, they'll bring the evidence in. You can start deliberating, and just deliberate till 5 every day. As you know, if you have a question or if you want to see any of the evidence that's not back with you, write that down and let us know, and then we'll come to court. Otherwise, just treat it like a work day. At the end of the work day, you're always going to be under these same instructions, so just follow them. But I'm not necessarily going to bring y'all back here and say it every day. Just continue to be under the same instructions. So as I told y'all yesterday, to maintain the integrity of the trial, remember that you need to decide the case based on the evidence that was admitted during the trial and the law as I explained it to you. Consider only the evidence admitted in this courtroom. Don't conduct any research on your own about the case, people involved, places mentioned. Don't refer to any books or documents that may not have been admitted during the trial. Don't take or review any photographs or video of anybody involved in the case, except if it is already in evidence. Don't use dictionaries or any other kind of reference materials, including online reference materials, to help you in this case. Don't use Google or any other internet search engine. Don't consult websites, blogs, podcasts, any kind of social media apps, including but not limited to a various grouping of social media: Facebook, Instagram, Twitter, X, TikTok, Twitch, YouTube, Reddit. I mean, anything like that. Don't use any of these sources of information or anything else to get information about legal terms or concepts or about the law. Don't watch, read, or listen to any accounts of this trial that might appear in the news media, whether online, in print, television, radio, or otherwise, including in any kind of a social media. In short, do not seek information about this case, including hypothetical questions, from any source outside the confines of what the evidence is that is have been admitted in this trial. Remember that you are the only ones who have been qualified as fair and impartial jurors to decide this case. No other influence should affect your decision. And it is because of that that you should not and cannot discuss this case with anybody else, including your family and friends, or let anybody discuss the case or anybody involved in the case with you or around you. That includes discussing or sharing information in person, by phone, by email, text, blog, any kind of social media. If anybody does approach you about the case, or if you happen to hear somebody talking about the case, you need to let one of the deputies or court staff know that immediately. Please remember, you should continue to consider the evidence as you all deliberate with an open mind. And leave your, as you have this whole time, leave your notes or notepads with you in the jury room each night. And in the morning, I won't necessarily see y'all unless you have a question or need to see some evidence. So just begin your deliberations after you're all there. All right, y'all have a pleasant evening. Thank you. All right, we're adjourned for the day, and we will just remain in recess until we hear from the jury again, whenever that next might be. And if we don't hear from them at all tomorrow, I've told them they can leave at 3 since it's the day before Thanksgiving. We have Thursday and Friday off, so Monday will be the next time they would be deliberating. So if I don't have reason to see any of y'all tomorrow, everybody have a pleasant Thanksgiving. Thank you.
He had low self-esteem. He was made fun of and bullied growing up. So he got rid of the player. That was not going to work for him. But he kept the young thugs. He got rid of the S. And he became a performer, young thug. And from that day forward, he insisted everybody call him Young Thug. On every type of tweet, Facebook, social media of any kind, on any records, he refers to himself as Young Thug. And that fit in to the appearance of the gangster rap. Because most people think about a thug as a criminal. But to Jeffrey, thug had a different meaning.
Y'all couldn't hear me?
Some of you read books.
Oh, shoot. Sorry.
About Tupac and what it meant to be thug life.
My bad. I'm interrupting the activity. Sorry about that. So real quick, let's just review this real quick. The jury makeup, 10 black jurors, y'all, 7 black women. 7 black women. I know. Yeah, I see I was muted. Just one of those things. 7 black women, y'all. So black women, it's on y'all. It's on y'all, black women. We're going to know exactly what Black Atlanta wants with this verdict, because I'm going to tell you what, this one white man and this one white woman, I doubt they're going to just be the one person to hold back the whole program. If the program is going in the direction of not guilty, it's going to be guilty. Who cares what color? Who cares what color? Well, it's listed here. So I care to talk about what's listed. I care to talk about it because it's plainly spelled out here for a reason. So I think that 10 black jurors, if they want something, is going to happen. If they all 10 of them say we want this, it's going to happen. Now, if they can't decide amongst themselves, we might have a hung jury. 7 black women jurors, too. If they want something, I think it's going to happen, y'all. I think if the 7 women or if the 8 women jurors want something, it's going to happen. The men are a minority. The white jurors are a minority. So the majority is black and the majority is female or woman. I mean, the biggest majority really is just the women. 8 of the 12 are women. So I think that's very interesting. 8 of the 12 jurors are women. That is very interesting. So I think, I mean, listen, I'm not saying, I'm talking about color because it's here. I mean, it's literally listed here. You know what I'm saying? So we're talking about it. We don't know how race is going to play into this whole thing. We don't know if race is going, meaning among the jury. We don't know how or if, but it's mentioned here. So let's talk about it. Could the white man be? So I was going to say juror, when I heard juror 56 talk, I automatically thought he was a white man. Now I'm questioning that because there's a 7 out of 8 chance that he was a black man. So I don't know. I don't know. Okay, so Brent, you're saying that the jury is not, you're saying that the black women are not black. Is that what you're saying, Brent? So the 7 black women are not black. Is that what you're insinuating here? I mean, because if you don't, I can read and it says black women 7, black men 3. So it appears to me that there are 10 black jurors out of 12. So we don't know how or if race is going to affect, but it is interesting that 10 out of 12 are black. It is interesting that 8 out of 12 are women. So you really have a very heavy skew towards women and towards black. The other two are white or something else. So when y'all heard, okay, so let me ask everybody, when you heard juror 56, when you heard him talk, did y'all get, what was just your impression? My impression, I thought it was a white man talking, but I could be wrong, you know? I can only imagine it should be talked about because y'all listen. I've been told y'all, y'all very rarely hear me mention race. Y'all very rarely hear me mention race. I'm not the guy who's going to talk about race every 5 minutes. I'm just not that guy. Okay. But this data point came out and we're talking about it. Okay. So we're talking about it. If you don't think it should be talked about, you don't have to have an opinion on it. But this data point was posted by Joseph Papp. I think it's interesting, an interesting topic for conversation. So we're talking about it. Yeah, Juror 56 did definitely talk, and I got white man from what I heard. Okay, now, can you really tell? No, you can't. But that was just my thought the whole time. I'm really surprised to hear there's only one white man, because it's like, dang, well, that would have to be Juror 56 if there's only one. You know what I mean? So let's see. I don't know, because he could have been black. Yeah, he could have been. You really can't tell somebody's race from their voice. You cannot play. You cannot tell. I will replay it if somebody will give me a date. I just don't remember when it was. But I will go back and replay it if somebody remembers. I'm being racist. Who's being racist? Racist how? If you're going to accuse me or anybody of being racist, put a because or a by or some kind of explanation. Don't just make an accusation without some kind of evidence or explanation, please. I just don't remember what day it was. We will go back and play it. But we'll go back and play it, but I need to know what day it was. Y'all, if we can't, so anybody who's too sensitive to discuss race, you just bounce, man. Just be out. You know what I'm saying? If you're too sensitive, you can't discuss the fact that race exists. Just bounce, be out. Cammie, thank you. Do you think Hylton's speech about crime in our black communities will have a major impact on them, considering most of them are black? Oh, what a good question. What a very good question. Cammie, you just came with an excellent question. And I think it could. I think Doug's mention of race and Hylton's mention of race could have an impact. And we do not know how as of right now. But remember, Doug mentioned it on the one side and Hylton mentioned it on the other. And these are Atlanta residents. They have no doubt heard of shootings. They've no doubt heard of killings. They've no doubt, many of them have looked over their shoulders when they have gone out at night or when they've seen a group of people, or they have family members who've been victimized. They might have had family members who were caught up in the game and in the struggle and who were victimizing people. They might have had family members who suffered false arrest or who were imprisoned in Rice Street without charges for 2 years. So it's hard to say how, without knowing the details and what might come to mind in the mind of the jury. But I would say, I think that, yes, the jury's going to bring their total lived experience to the juror room, and they are from this community being Atlanta, this city. So yeah, I definitely think it will play a role, but remember, Hylton wasn't the only one who mentioned it. She was actually replying to Doug. And so we just don't really have a indication as of now which direction it'll push him. But I do think that there will be a direction. Probably, yes. Pointing out race can impact decision is factual. Some people are too sensitive to discuss race. Some people are too sensitive to discuss race, and that's okay. They don't have to. Having 7 black women, yeah, I think it makes a difference. I think it definitely makes a difference. Now, the only thing is we just don't know how, like it's going to be interesting. November 5th is when 57 wanted out. Okay. So let me see if I can find that. Peanut Gallery says if the black women are older, I don't know for sure, Peanut Gallery, because I can easily imagine that if 1 or 2 of those women had a son or nephew or an ex-boyfriend or whatever who had gotten caught up in a Fulton County system and false charges and this and that, I can very easily imagine them telling their story and swaying the other people. So while I see where you're coming from, we just don't know what their lived experience is going to be. That's the thing. It's highly likely those 2 white jurors will see it for what it is, that the state made a lot of allegations but not proven anything. Yeah, hopefully. I would say hopefully on that. What day was, let me see something. Whoever made this, y'all, if you're on here, I want to give you a salute. The YSL trial links, I use it a lot. I just don't know your name. I want to salute you because if it's November 5th, then I can go in. Hold up. Somebody said November. Did you say 5th? All right. According to this, there wasn't any court on November 5th. Was that a weekend? Don't let November 5th have been a weekend, Ty. That was a Tuesday. So, oh, that was last year. My bad. I'm tripping. I'm on the wrong November. Hold up. Okay, this is 2003. Okay, so it goes to 2000. Okay, my bad. Here we go. Day 156. So it starts in 2003 and ends in 2003. That's what threw me off. So day 156 is the day we're looking for. Day 156. All right, Ty. So my bad. Okay, so we have, this is day 156. We would have been coming back from a break, right? Let's see. Wasn't it like after lunch? All right. Okay, yeah. This must be it. Let me get rid of this. Ty, I think you might be right. This might be it when they spoke to him. See, y'all, some people understand this as being, should race play a role, where we're not talking about what should be the case. We're talking about what we think will be the case.
Fastest witness yet.
Yes,
You are
ma'am.
excused. Call your next witness.
When was that? Todd, somebody give me like a, wasn't that when we had just come back from lunch or something? Somebody help me find this. So Ty, yeah. Okay. Law and Crime has a clip. Okay. Yeah, probably. YSL juror. Let me look for the clip on Law and Crime. Here we go. I found it. Here we go.
Morning, Judge Whitaker. I am requesting to be removed from the current case due to the length of this trial and how the state has handled this case. I can no longer be unbiased towards any decisions moving forward.
Now, this is the same juror, I think.
So we're just trying to hear from the
Will be
jury.
another 3 to 6 months. It's evidence, and
Just
I
trying
can
to get to
foresee
where the
another
jury
3 to
talks.
6 months with the remaining defendants. And frankly, you have to start a case unbiased, but as you listen to the evidence, as long as you don't deliberate with anybody, you can mull the evidence in your own mind.
You know what?
And frankly, if y'all are presenting the case in a way that is driving a juror crazy, that's on
This
you.
might not have the jurors.
Things as well.
Yeah, here we go. Here we go. Okay. We'll back it up.
Said that you would be biased.
I'm just trying to
You
find where the
find out.
juror starts talking.
I think it is represent, and you seem to.
Bear with me.
So I am in receipt of
Okay, here we go.
correspondence from you this morning. And I'm actually in receipt of both versions of it because you sent one and then you adjusted it. And my assistant had already sent that one to me. So I have both. And you seem to be expressing concerns about the length of the trial. And I've discussed that with all of the attorneys, and we all feel comfortable representing that there is really, it's almost certain that this trial will be over far before 3 to 6 months have elapsed. I think it is probable that it will be over before the end of this year. So I'd like to find out whether that assuages any of your concerns.
Given that you said probable, then I'll keep it as is, but I will, if it prolongs, then I will send out correspondence if it goes into 2025.
All right. Let me ask you as well. You said that you, first you said you could no longer be unbiased, and then you said that you would be biased towards any decisions moving forward. Is that because of your worries about how long the case might take?
Yes.
Okay.
I projected it when we first began this entire case, we were projected to be in 6 months and then a year.
Yeah.
And then given the circumstances in between, I just personally, I just feel like it's just too long.
Yeah.
I love what I do for a living. I miss what I do.
Yeah.
And it's been hindering a lot of things, family and friends.
Yeah.
So since use probable in the sentence, and so therefore I can we're assuring that this will probably
Impossible to tell, y'all.
for years, and therefore I can stay on.
It's impossible to tell.
Okay. Let me ask you a couple of other things as well. I know that you were instructed to with some version of entering the case and
Come on,
considering
don't
the
say
evidence
that.
with an open mind and not reaching any final conclusions until the trial
No,
is
this is
over
not
with.
live.
Can you continue to assess the evidence with an open mind?
Given the information that we just discussed, and yes.
All right.
Yeah, it's not. It's
Okay. Can you decide this
I initially
case
thought I
based
was
only on
listening
the
to a
evidence?
white guy, but it is impossible to tell. It's impossible to tell. Lord have mercy. See you later. Have a good evening. Anybody who can't handle talking about race, y'all are free to go elsewhere. Yes, court has adjourned for the day. Yeah, it's impossible to tell. So, juror 56, I'm gonna say it's probably a black man now. Honestly, I'm only saying it based on the fact that I know that there's 7 black guys and 1 white guy, and with it being impossible to tell, yeah, it's probably a black guy. Probably a black guy. So, I think that's interesting, y'all. I don't necessarily know that it changes my opinion of what I think is going to happen. You know what I'm saying? I don't know what I think is going to happen. trying to interpret my proclivities, my thought process through the eyes of this jury makeup, you know, it does make it a little bit more uncertain, but I can't say uncertain in any particular way. No, your girl Avery. When you say 3 black guys, I don't. Yeah, 3 black. Oh, okay. Oh, you're right. You're right. My mistake. I said 7. 3 black males and 1 white male. Still, you still have a 75% chance that he's gonna be one of the 3. So I'm gonna say that could very well have been a black guy. Yeah, I'm fine with y'all making jokes. You know what I'm saying? Long as they are within the boundaries of good taste. There you go. So I don't know. I don't necessarily know that seeing this really changes my opinion. Because again, if you have 8 women, I would say at least 6 of them are probably going to be moms. You know what I'm saying? At least 6 out of 8 going to be moms. Probably more like 7 or maybe even all 8. So, I don't know. I don't know. Y'all, we just don't know. We don't know people's lived experience. So it's real tough to try to just use this demographic breakdown and try to really draw any kind of conclusion. It's really tough. I don't know. After sitting there that long, I probably want to go back to work too. Yeah, I think that was just a joke. Hopefully that was a joke. Yeah, Tay's joke was that no black man said they wanted to go back to work. I know. And it was a joke. And that's fine. So y'all, I don't know how this will have an impact, but what impact will it have? Who knows? You know what I'm saying? Who knows? We don't know. You can't use them being black as a reason to think they'll be found not guilty. So my thing is, it will have some impact, but we just cannot predict what that impact will be. Every characteristic of a person has an impact. Your gender, your socioeconomic background, your race, your the language you speak, everything has some kind of impact. The thing is, we just can't predict what that's going to be. We just can't predict. Yeah, we'll find out soon enough. We don't know what the impact will be, but everything has an impact, because if it didn't, then you couldn't come to any kind of conclusions, right? I was not guilty the whole trial, but when Hylton put it all together and got to project her opinion in closing, I started second guessing my decision. So let me ask you this, Ashley. Are you second guessing your conviction about, not conviction, that's a bad word. Are you second guessing your opinion about not guilty? Or are you second guessing your thought that other people will find them not guilty? So I'm going to say it again. Are you saying, I thought they were not guilty, but Hylton convinced me that they might be? Is that what you're saying? Or are you saying, I thought they would be found not guilty, but Hylton's closing made me think other people might find them guilty? Or are you saying both of those things? That's what I'm trying to figure out from you, Ashley. If she's second guessing, that's reasonable doubt. Well, Ashley is second guessing her. She's second guessing her conviction that they're not guilty. So that's not good. I mean, it's not good if you don't want them to get convicted. I vote not guilty based on reasonable doubt, regardless of what I believe to be true. Also believe Hylton tied it together well. Yeah, so Hylton got a lot of hate, but I reserved judgment that in the courtroom, what she did might have worked. Where it didn't come across to us at home, maybe in the same way that it came across to people in the courtroom. No, I don't want any of those, baby. Thank you, though. Appreciate it. I was looking for Ashley to follow up. Here we go. It didn't let me finish. Okay, solely my opinion, mine. If I were a juror, but I still have doubt, so I'd have to vote not guilty. Okay, so but you're saying you are less, your doubt was, so Hylton moved you closer to guilty, basically. You were further away from guilty, and Hylton's closing moved you closer to guilty, even though you're saying she might not have gotten you close enough. That's what I'm getting. Listen, y'all, if you think they're guilty, you can say that. I don't care. I mean, I don't have a problem with people who think they're guilty. I don't have a problem with people who are convinced by the evidence. You know what I'm saying? You can say that on this stream. You can say it as long as you're just being honest and you're representing your opinion. That's your opinion. That's the state put on a case, and if you're convinced by that case, I do think there are certain things that. No, I mean, listen, if you're convinced, you're convinced. You know what I mean? What we want to do is just try to have somewhat respectable conversation on this stream. But if you're convinced that, if you were convinced beyond a reasonable doubt, if you're convinced beyond a reasonable doubt, then you're convinced beyond a reasonable doubt. Ashley said you still have a doubt. This is what I can say. This is what I can say. Hylton moved the needle somewhat for the Shamel Drinks video footage, but I think she added in some information that was not in evidence, which I do have very strong questions about. Like, she said that the car exhibited having been washed. Was that in evidence? Did anybody testify to that? Did anybody testify on the stand that the car had been washed and that you could see the watermarks on the car? Did anybody testify to that? Because I certainly don't remember hearing any of that testimony, but Hylton asserted that in the closing. So are you able to do that? Can you just make up new evidence at the end? So where she might have moved me a little bit, and frankly, her passion was, I understood it, even though I felt like she kind of lost it a little bit, but I saw where she was going. But the watermarks thing, it was like one last example of just doing something dirty. It was like one last example right at the end of your closing, where you have all this passion, where you have all of this emotion, and you might be trying to reel the fish in. And at the very last moment, you say, they had the car washed. You can see the watermarks. And it's like, did anybody testify to that? So that did not go over very well with me. That didn't go over very well with me, with that whole, you can see the watermarks on the. So it's like, I feel like you still trying to trick me. She made up the story about switching the car behind a building. That theory was never brought up during the trial. So, at least though she's saying that could have happened though, Ty. Whereas the watermark thing is, she's saying there are watermarks. So I'm just making a distinction between what they could have done. So at least that signals to me you don't know, but you're planting a hypothesis in my mind to, hey, you can see that right there. And it's like, I don't remember seeing that. Where can I see that? So I'm making a bit of a distinction. Okay, my official prediction. Oh man, you called me out. I guess I do have to make an official prediction. I'm only making a prediction on the RICO, the 2 murders, and the gun charges. I'm not going into any of the other stuff. All right, y'all. Clizzles just called me out. Clizzles just called me out, but he dropped the 2 spot on me, so I got to do it. Clizzles just called me out, but he dropped the 2 spot on me, so I got to do it. And we see that there are 7 black women jurors, 3 black men jurors, a white man juror, a white woman juror. Man. So now I have all the information I need. I saw the whole trial practically. I heard juror 56 say that he didn't like the state's dirty tactics. Y'all, I'm going to say this. My official prediction. I'm going to go back to what I've been saying. I think not guilty on the RICO, not guilty for both on RICO, not guilty for both on the murders, guilty on the gun for Shannon, and probably guilty on for both of them on the criminal street gang. That is my prediction. Not guilty on RICO, not guilty on the murders. Shannon's probably going to get the gun charge. Yak, I think, was gonna beat his gun charge because, if I'm not mistaken, his gun charges are just about being in the house where the guns were. I'm not touching the drugs, but I think Yak could possibly beat those. I don't want to give an official prediction on that just because I don't know. I mean, this is just about being in the house. Yeah, I'm gonna say not guilty on any drug charge, any gun charge that has at its base that you were in a house where that stuff was, not guilty. So Yak could very well get, in my opinion, not guilty on everything except the gang. I think they're going to get the gang charges, y'all. I think the gang charges are going to stick on both of them. I really do. I think the gun charge is going to stick. And so not guilty on RICO, not guilty on murder. Both of them will probably have the gang charge stick. Yak probably won't have anything else stick. And Shannon will probably have whichever gun charges they have on him is probably going to stick. So those are my predictions. Those are my predictions, people. Sentencing could certainly be time served for both of them. It could be time served plus some probation for both. So you asked Clizzle for a prediction, and I just gave you my prediction. I think Yak looking at serving another 5. Okay, so what would Yak serve 5 for? For the gang charge? Shannon could be looking at 10. I don't know. I don't see Shannon doing another 10 years unless he's guilty of the RICO or the murder. Isn't the gang 5 to 15? Yeah, but I don't know that you have to serve that in prison though. I don't know that you have to serve those sentences in prison. I see Shannon getting more time if found guilty, but not 10. Yeah, I think it'll be tough for her to give him 10. I think it'll be tough for her to give him 10. Y'all tripping. They coming home. The leader is home. So Clizzle dropped me a 2 spot, Silverback. He dropped me a 2 spot. He asked for my prediction. That's my prediction. That is my prediction. That gun charge, man, that gun charge on Shannon is probably going to be the hardest thing to beat of everything. I mean, even in his closing arguments, Max Sharp said, we don't deny that Shannon had the 2 guns that he was talking about after Waters Road got shot up. Like, Sharp even acknowledged that. So the idea that Shannon is not going to get found guilty on the gun charges when his lawyer admits that he had guns in his possession, like, if the jury comes back and says not guilty on that, that's definitely sending a message. It's like, yo, you know what I'm saying? Because his lawyer literally said he had those guns. We don't deny it. So I mean, you know what? You know what I'm saying? What else can you possibly say? He said that in front of the jury, y'all. He said that to the jury. So it seemed like those gun charges are the most difficult thing. The Shannon gun charges are going to be the most difficult thing for not guilty to come back on, in my opinion. Poor kids who were making it bigger than they will ever be, so they went after these kids. Sorry for being racist, but as a white woman, I would vote not guilty just on that. I don't think it's racist to say how you would vote. I don't think that's racist. Yeah, Sharp might have had no choice but to admit it, but my thing is, how can you find him not guilty of something that his lawyer is telling you he did? You would have to find him not guilty based on jury nullification. You know what I'm saying? Like, based on, like, we know what the law is, but we also recognize he needed to have a gun, so we're not going to penalize him. Like, you're basically going to just buck the law. I agree with you on that verdict. The gang charge will stick because the jury will feel like they have to convict them of something. I do think that there's the risk that they will have that feeling. I do think there's a risk that it's like we can't just let them walk on everything. You know, they brought up a previous gun charge. Wasn't he talking about that? What he admitted to, if I'm not mistaken, if I remember correctly, is remember how Shannon was caught on the wiretap after the Waters Road shooting, after he survived the shooting at Waters Road, and Shannon said something like, you know, I put one gun in the Audi or something like that. I forget where the guns were stashed. If I'm not mistaken, y'all, I could be mistaken, but I believe Sharp admitted that Shannon had those guns at Waters Road. Plus they found Shannon's girlfriend's gun along the slow speed chase route when Shannon was apprehended by the police. So there's just too much evidence that Shannon was moving with guns for you to have a reasonable doubt that he possessed the gun. Like, so now could you say, well, I know he had a gun, but I'm still going to say not guilty because people were after him and he needed a gun to protect himself. If he gets found not guilty, it's probably going to have to be something like that, right? Like, we just gonna give it to him. So those are my predictions. Clizzle, thank you for the super. By the way, y'all, I definitely believe he had a gun at Thug's house. You talking about Yak? The thing is, you can't necessarily connect Yak with any particular anything at Thug's house. If you told me Yak didn't live there, but every time Yak was there was a certain room where Yak stayed and nobody else stayed there because Yak was Thug's best friend, and anytime he came over, whoever's in that room, Thug would kick him out. So Yak wasn't at the house, but when we searched this room where we know Yak always stays and where he has exclusive access whenever he's in the house, we found these things. Like, if you're gonna put me a circumstantial case together like that, I'm more willing to hear you. He has a specific spot that Thug reserves for him that nobody else has access to, and this is where we found all this stuff. You give me something like that, then I can hear you. But you just say he was in a house where all this stuff was, I can't hear you. I can't hear you. So, guns were in basement hidden. I think guns were all over the place. I think the guns were all over the place, y'all. Wondering what's up with the watch. Did that cop really steal it? We don't know what happened to the watch. Nobody knows. I know he wasn't seen inside the house. People don't like circumstantial evidence or constructive possession. But it's valid. So y'all, I'm gonna keep playing this. I am gonna fast forward it a little bit to 25 minutes past the truly humble under God stuff, because I really don't know what else on here I might get a copyright claim for, but at least I know I can avoid that. So Mr. Vegas, circumstantial evidence on one hand is like, man, but then on another hand, it's like we use it every day. I've been using an example this whole time of a dog, and I'm not comparing humans to dogs, by the way, but your dog, your house. You and your dog are home. You have your big Wendy's burger that you just bought, and you're like, oh man, I ain't get a soda. So you put the burger on the table, you run out the house, you go buy a soda from the vending machine. 2 minutes, let's say in the lobby, 2 minutes later, you back in and the burger's gone. Okay. That's circumstantial evidence that the dog ate the burger. You didn't see him. If you don't perform tests on his teeth or his stomach or whatever, like, it's circumstantial evidence that the dog, well, what are the circumstances? There was a burger on the table. Nobody else was in the house but the dog. When I got back into the house, I saw the wrapper in the dog's bed. I know the dog likes to eat in his bed whenever he can. So it must have been the dog. But that's circumstantial evidence. So, you know what I mean? So, like, you know what I'm saying? So, like, all right, Mr. Vegas, let's see. Mr. Vegas says, yeah, but you're using it in everyday life. This circumstantial evidence is being used for potential life sentences. Okay, so let's go to the gun. Let's go to the gun, okay? Okay, so police find a gun that's registered to Shannon's girlfriend. Where do they find the gun? They find the gun in the street on a route that Shannon had just passed by when he was running from the police. So they find the gun in a place that Shannon had just recently been. And they have a wiretap in which his girlfriend says, I gave Shannon my gun. So, Mr. Vegas, you did not find Shannon with the gun. Okay. But so we have a circumstantial case here. We have his girlfriend's gun. We have her saying, I gave him my gun on a wiretap. And we also find the gun where Shannon just was minutes earlier. So, Mr. Vegas, are you saying that you don't believe that's enough to convict? Are you saying you have a reasonable doubt as to how Shannon's girlfriend's gun got to the place that Shannon just was when he was fleeing from the police? And there's a recording of her saying, I don't know what his problem is. I just gave him my gun. If he didn't get caught with the gun, I can't convict that. Okay. So So then in your city, Mr. Vegas, you could literally, you could become a drug kingpin in your city, or you could become any kind of criminal you want, because as long as the police don't catch you with something, as long as, even if they are right behind you and you can toss something out of the window and they don't see you, and they say, hey, there's the thing right there and he's over there, but they didn't see you toss it. So you would never get caught with anything as long as you're slick enough to just toss something to the side before the police can see you. That wouldn't make sense. That wouldn't make, like, the law would never work. The law would never work because you're in a high-speed chase. All you would need to do is wrap all the drugs up in some black tape and then travel at night. And as long as the police get behind you, you just drop it out the bottom of the car. As long as they didn't see you drop it, you're good. You're good, because now it's just circumstantial evidence. Well, we know you had these drugs, or we suspect you did. We found them in the street, and we know you just passed down that road. But we have to say, well, did you see me drop it? No. Okay. Well, you can't convict. You must be caught doing something before you can get sentenced. All right, I hear you, Mr. Vegas. I just disagree. I do share your concern about some circumstantial convictions. I do share your concern. Okay, so I'm not saying I don't think you have a point. I do think you have a point, but we have to allow circumstantial evidence. You know, because you know, I mean, I think I gave a good enough example. I think I gave some good examples here. Examples here. Most of our crimes are convicted on circumstantial evidence, I would bet. And I get it. You're liable to be wrong when you don't have that direct evidence. I mean, I'm with you on that. And I've often felt very frustrated about circumstantial evidence myself. But I also recognize that, you know, oftentimes you just got to roll with it. If we don't have circumstantial evidence, the state would have problems proving their case. Everybody uses circumstantial evidence all the time. We all do it. Now I get it. Mr. Vegas is saying, okay, well, he's saying, well, when you got these big time consequences, like you about to go away for life, it should have to be more definite. But it's very easy to think of situations where you have circumstantial evidence and that's the best you're going to get. Depends on the circumstance. If you're not a felon, how many guns are you allowed to purchase in the South? I think you can have as many guns as you want in Georgia. If I'm on wiretap speaking about killing somebody, my car's on CCT driving down the road where the person is killed, and my phone is on that road at the time, chances are I did it. So the problem is, if you're talking about killing somebody, that would be more like direct evidence. But I see what you're saying. All right, y'all, let me continue with this Brian Steele. If y'all want to hang out, I'm just going to continue playing this for a while so y'all can keep chatting. I'm going to do some other stuff because I have to try to live something of a life. I thank everybody. I'll probably pop back on at some point. So don't worry, I'm not gone forever. So let me go ahead and keep playing Brian.
When he had time and the opportunity to go into the studio, he wouldn't leave. He is a prolific creator of music. The neighborhood realized his talent. He was the best rapper in the neighborhood. So Jeffrey was invited to the underage clubs to perform. And he would be the introductory entertainer. He would be able to perform 5 or 10 minutes, $50, get paid $100 sometimes. He's about 17 years old, 2008, 2009. When Jeffrey would leave the establishment, he got robbed. And the money was gone. And that money may not be a lot of money to some of you in 2008 or 9, but to Jeffrey, it was food. It was meals for him and his family. The next time Jeffrey went for an event, he did not get armed robbed. There's a man in the community who's a man of influence in the community. He was allegedly the leader of Raise on Cleveland, the supposed gang, rock crew. He was supposedly the leader of the Bloods in that area in Cleveland Avenue. His name is Quentin Porter, goes by Boo or Big Boo. And when Jeffrey comes to make the performance, he's no longer there for 5 or 10 minutes. He is the lead performer. He's going to go last. As the time went on, the neighborhood got behind Jeffrey. The rock crew, the Bloods, the whole neighborhood, they would put up signs on the post, come out tomorrow night. Watch our own young thug perform at this establishment. The place is sold out now. This is no longer 25, 35 people. There are hundreds of people in the club. There are hundreds of people in the parking lot trying to get into the club. There are hundreds of people backing up in the streets, all to see Young Thug. The people who own these establishments are making money. They are attracting customers. Word gets out. Jeffrey's no longer just performing in the area that he grew up in the poverty-stricken area. He's now in Atlanta, South Georgia, Alabama, Florida, South Carolina, North Carolina, Tennessee. He is performing all of the time. By 2011, Jeffrey released his first album. It's entitled, I Came From Nothing. And yes, he speaks about killing 12 and people being shot and drugs and drive-by shootings. This is the environment that he grew up in. These are the people he knew. These are the stories he knew. These are the words that he rhymed. This isn't a ballad or a book. These are phrases in a song. And whatever the listener takes from it, you will learn that's what the song means. This is art. This is freedom of speech in America. As the years go on, 2013, 2014, Jeffrey's now 22, 23. It's unbelievable. He has 3 hit songs that are going around the world. Stoner, Danny Glover, and Lifestyle. He is making music videos professionally. He is working with some of the biggest artists in hip hop. It worked. It's unbelievable. He is not running this criminal street gang in Cleveland Avenue area of Cleveland to gain property, money, or power. Jeffrey Williams did it on will and hard work and determination without anybody's help, except the people from that area that he will not turn his back on. By 2014, to today, you will learn. Jeffrey Williams has been nominated and won and recognized MTV, United Kingdom, American Soul Train Music Awards. He is a Grammy Award winner. XXL Awards, BET Awards, Billboard Music Awards. Every single year since 2014, that's what he has accomplished. He is not sitting there telling people to kill people. He doesn't need their money. Jeffrey's worth tens of millions of dollars. Jeffrey has been a sponsor for Puma, Calvin Klein. He has been featured on the cover of Rolling Stone magazine, GQ magazine, XXL magazine, Paper magazine, Complex magazine, Variety Interview magazine. He is at the top of his craft. Jeffrey is so talented in music, he doesn't only do gangster rap. He does rap, gangster rap. He has hits in country music, popular music or pop music, Latin music, Afro, beats. He's been featured on NPR, Tiny Desk. He's played numerous times on Saturday Night Live, Jimmy Fallon Show. Jeffrey has performed in almost every continent on the earth. He's performed in front of more than 300,000 people that come for him. His social media feed has more than 10 million followers. He's not the creator. He's trying to pull people out of poverty. Jeffrey has performed with the likes of Rihanna, Ed Sheeran, Sir Elton John, Drake, everybody in music. And Jeffrey didn't only stay in music. He did fashion. He's an icon in fashion. He has been to Paris, to Spain, all over Europe at the fashion shows. He has his own clothing lines. People are walking around the earth today with Jeffrey's picture tattooed on their calves, on their shoulders. They have his lyrics on their bodies. YSL, when Jeffrey was coming up and making it, Lil Wayne had and repped, talked about Cash Money Records. That's his label. Jeffrey's friends in Cleveland Avenue, they call themselves YSL. Because on the pants, the tight-fitting pants, the women's pants that they're wearing, it says YSL, Yves Saint Laurent. That's where that comes from. Ladies and gentlemen, Jeffrey most serious crimes in the state of Georgia. I'd like to go through with you each and every crime he's charged with in the indictment. The indictment's thick. You're going to have it. At the end of the case, the Honorable Judge Granville will give it to you. You should read it. It's the charging document. It is critical in the case. There are many counts. Most of them Jeffrey's not charged with. But everybody, there were 28 people who the prosecution, through the grand jury, indicted together. They're all in count one. That's why this is a joint, because everyone's in count one. That was the decision of the prosecutors. You will learn that Jeffrey doesn't even know most of the people in this indictment. He doesn't know them. They all know him because everybody in that area knows Jeffrey Williams. He is known as the Michael Jordan of that area. And he didn't get out and stay away. He tries to come back and give people hope because he knows what it is to be depressed, hungry, have nothing going for you. The first count is a RICO conspiracy. And the supposed objective that the prosecution charged is that Jeffrey, along with others, had a meeting of the mind. They had an agreement. They have an agenda together. And that they wanted to preserve and protect and enhance the reputation, the power, the territory of YSL. That's the allegation. Jeffrey hasn't lived in the Cleveland Avenue area in a decade, more. He has homes from Los Angeles to Atlanta. But they charge him with, he wants the reputation, power, territory of the enterprise by obtaining money, weapons, or other property. Jeffrey needs no money from somebody on robbing someone of a car. We're doing a $30 gun deal, or even $100 million. Right? He's got his own source of legitimate income. It's a RICO conspiracy. There are then what's called overt acts. The judge will charge you on the law. But there are 191 overt acts. And those are separate instances that the prosecution said they're going to prove. Most of them don't include Jeffrey. But the ones that do, I'd like to go through with you. And I've broken it up into 3 categories. Because an overt act can be a crime. It doesn't have to be a crime, so I then wrote chats, social media, any type of statement, because the prosecution has been investigating Jeffrey for a decade. They have all of his personal chats. You think you're talking to somebody on Facebook in a personal chat? They have all of his thoughts. They put these in the indictment. The third category are lyrics. So I'd like to go through them with you. First is going to be supposed crimes. And these are the overt acts that you will see that involve Jeffrey. As you can see, Jeffrey has never been convicted of a crime. He stands before you. He's not a convicted felon. He can vote. He can carry a gun. He can be on a jury. But now, these acts are embedded in the indictment. So let's start with the first one. So this is September 9th of 2013. Jeffrey just turned the age of 22. and he's driving in a car, and he gets stopped, of course, for failure to maintain a lane. And the police officer comes up to the car, and Jeffrey doesn't have a license, doesn't have a valid driver's license. So now he's under arrest. Police officer says he sees pills, Xanax pills, 7 of them, on the console. Police officer searches the car, and underneath the front passenger seat, there's no passenger, there's a gun. That weapon comes back stolen from Andrew and Ann Phillips months before. There's no evidence that Jeffrey's involved in that burglary of the Phillips home. There's no evidence Jeffrey ever touched that gun. You're not going to hear any type of DNA, fingerprints. In fact, Jeffrey says, that's not my gun. Police officer wants to know, whose gun is it? Jeffrey's not talking to police. So Jeffrey gets arrested. That case got dismissed. But 10 years ago now, it's an overt act for you to consider. You will learn that this stop was video recorded and audio recorded. But the City of Atlanta Police Department, the District Attorney's Office of Fulton County, I demanded that. They can't find it. So you're going to rely on a report of an officer who doesn't remember this incident. That's it. That's an act in furtherance of a conspiracy. That's the entirety of that first overt act. The next one. This is overt act 5 through 7. You may notice that Jeffrey's not even alleged to be in this overt act, but now you're going to hear Jeffrey's supposed involvement. This is 2 days later. It's September 11th, an infamous day in America. It's 2013. Jeffrey was arrested, if you remember, for the last overt act, September 9th, 2013. He made bond, he just got out. Walter Murphy, he grew up with Jeffrey. He's one of the people that would exchange dirty clothing with Jeffrey. You will learn that they would have no money between them. One of them would come across $1. They would split the food that they could buy with that $1 together. Walter Murphy is with a person named Adrian Bean and Fred Plethora. And there's an armed robbery of Mr. Dotson. Gunfire went out. Police are always in this area. So when the gunfire was heard, police respond immediately. Adrian Bean is driving the car. This is a car that he borrowed from a friend. It has nothing to do with Jeffrey. So he commits a crime in someone else's car. Adrian Bean almost kills a police officer, almost runs him over, driving so recklessly, high rate of speed, goes across a neighbor's lawn, over an embankment. The car is now airborne. It goes over, you'll see pictures, goes over a parked police car in a parking lot and slams into the side of a laundromat. The car crashes. Mr. Plethora is shot. Police are firing at the car. Mr. Murphy is shot. Mr. Bean runs away. He's captured. Mr. Bean, you will learn, is told, hey, we believe there was a fourth person in that car. If you make that young thug, we'll go lenient on him. Adrian Bean is in the Fulton County Jail talking with his wife. He said, I should have ran the way Thug ran. He got away. That's recorded anytime an inmate, a person is incarcerated, in a jail. Most of the time, if they're speaking with a pastor, a lawyer, their calls are being recorded. You will learn that Mr. Bean also stated on a recorded call, they gave us a story to tell. Mr. Bean is interviewed 4 days later, September 17th, 2013, by Detective Quinn, City of Atlanta Police Department. Detective Quinn it's a big case because police officers are discharging their weapon. People are getting shot. Detective Quinn interviews Adrian Bean. And Adrian Bean tells him, they talk about this recording. Adrian Bean tells him, I lied to my wife. Everything on the recordings are not true. Jeffrey was never arrested for this. He was never charged for this. He was never prosecuted for this. He's not even in our indictment on Overt Act 5, 6, or 7. But now, we're going to hear from Mr. Bean. That's it for the next one. Somehow that furthered this conspiracy. Jeffrey was not even charged. Next Overt Act is January 7th of 2015. Now, this is a larger part of our case problem. God forbid, Donovan Thomas is going to be killed 3 days later. It's going to be January 10th of 2015. And in order to understand this rental car, and there's nothing clearly wrong with renting a car, but in order to understand this rental car and then the 3 days later, the killing of Donovan Thomas, you have to understand some background. So we're shortly before New Year's of 2015. And there's a man named Kenneth Copeland. He goes by Woody. And Kenneth Copeland is not friends with Jeffrey Williams. He uses Jeffrey Williams, just like a lot of people. Because Kenneth Copeland wants to be famous and have money. So he reaches on to Jeffrey Williams about a year before that. Well, Kenneth Copeland is a criminal. He is a notorious criminal. In fact, you will learn that he was ranked one of the 10 most violent people in Georgia by the federal prosecutor here in Atlanta. That is Kenneth Copeland. Kenneth Copeland breaks into cars. He steals the property they're in. Donovan Thomas is the head of a gang called IF, Inglewood Family. Donovan Thomas and Jeffrey are friends. Jeffrey's friends with everybody. It promotes him. And Jeffrey tries to help other people at the same time. Kenneth Copeland breaks into Donovan Thomas's car. And he takes his expensive chain, Donovan Thomas's wallet, his driver's license, and Donovan Thomas's cellular telephone. Donovan Thomas calls his cellular telephone. Kenneth Copeland answers the call on Donovan Thomas's phone. Kenneth Copeland changes his voice, tried to disguise his voice, but Donovan Thomas knows it's Kenneth Copeland. Donovan Thomas has people on the street. And he tells Kenneth Copeland, "You have my stuff. I'm going to get it back." And Kenneth Copeland says, "Yeah, I'm glad you called me. Because one of my partners had your stuff. I realized it was yours, so I got it for you for safekeeping. No problem." When Donovan Thomas meets with Kenneth Copeland, he doesn't come alone. He comes with two other people, and they display guns. Kenneth Copeland's not alone. He's with his brother. They're really not related, but they call themselves brothers. His name is Demekian Garlington. Demekian Garlington and Kenneth Copeland are like this. They are inseparable. Demekian Garlington and Kenneth Copeland are together. When Donovan Thomas comes, he makes it known that Kenneth Copeland is on the menu. Meaning Kenneth Copeland is going to be first. He just stole Donovan Thomas's property. It is now January, and Kenneth Copeland is with a lot of people. Jeffrey's there. Jeffrey was performing on stage at Club Crucial. Monday night was Club Crucial night. That's where they all went. And Kenneth Copeland goes in the back, in the kitchen area, and he's met there by a man named Kelvin Watts. He goes by Shell Kel, and who's a half-brother of Donovan Thomas, and other people who are affiliated with Donovan Thomas. And Kenneth Copeland gets beat. He has bumps on his head, his eye is injured, he's being kicked. No one does that to Kenneth Copeland. Kenneth Copeland's the person who puts the bumps on the head, injures the person, kicks him. Kenneth Copeland's mad. And you will learn that Kenneth Copeland then went on a mission. He went to every place that he knew that Donovan Thomas or one of his brothers or friends were, or family members, and he would shoot at them with his weapon. On the 7th day of January 2015, Kenneth Copeland told Jeffrey, "I'm going to be with my child just born. The mother of my child, her name is Miss Quarterman. And I don't want to be driving around in the typical car I drive around in, Dodge Charger. Can I use one of your rental cars?" Jeffrey does this for everybody. People need to take someone to a doctor. People want to go out of the state. They don't have transportation. He rents cars all the time. Jeffrey says, "Yeah, there's a rental car here. It's a Corvette." Kenneth Copeland says, "That's a two-seater. My child has a baby seat. That's too small." Jeffrey rents a car at the Atlanta airport on the evening of January 7, 2015, along with Kenneth Copeland. After they drop off the Corvette, the same location. This rental car is in Jeffrey's name. When they leave the rental car location, Kenneth Copeland wants to pick up his brother, Demekian Garlington. And after Jeffrey is dropped off, Jeffrey does not see that Infinity vehicle until after the killing of Donovan Thomas. That Infinity vehicle, that rental car, is in the possession, the control of Kenneth Copeland that whole time. The 8th of January, Kenneth Copeland is shooting at Donovan Thomas. He's using this Infinity vehicle, he's using another vehicle. He is on a spree. It's now January 10th of 2015. There's a New England Patriot, Baltimore Raven playoff football game. It's Saturday evening. Donovan Thomas is watching the game from inside a barbershop with a lot of other people, his friends. At approximately 7:22 that evening, Saturday, January 10th, 2015, Donovan Thomas is outside of that barbershop. His Chevrolet Tahoe is parked in that parking lot. Car drives by. You'll see a video, a surveillance video from the stores. You'll see sparks, it's gunfire. Donovan Thomas is struck fatally. The EMTs try to save him. He's taken to Grady Hospital, surgery after surgery, and he leaves us. 2 other people were shot as well, but their injuries were not fatal. Later that day, that evening, Jeffrey, you will learn, is in negotiations with his record label. They want to give Jeffrey over $800,000 up front. And the contract's worth millions to produce these records. That's what Jeffrey was working on. He was working on a music video. No one's going to say that Jeffrey was at that scene of the shooting. But later, Kenneth Copeland, when he's arrested, he tells the police lie after lie after lie after lie. Kenneth Copeland says Jeffrey Williams was involved in that shooting. Although Kenneth Copeland said, I don't know anything about it, I'm just telling you what I heard. Kenneth Copeland's one of those liars in the neighborhood that everyone knows, that becomes a witness, swears to tell God's honest truth. You will learn that after the shooting of Donovan Thomas, his associates did not take that well. Immediately, word on the street is that Kenneth Copeland, Woody, is responsible. Kenneth Copeland, it's now after 10 p.m., it's hours after shooting. He's then at Jeffrey's home, along with a lot of people. They're all scared they're going to be killed. They're all telling, I had nothing to do with it. Jeffrey, you will learn, is friends with Donovan Thomas. Jeffrey puts Donovan Thomas in his music videos. Donovan Thomas invited Jeffrey just recently to come into his neighborhood to shoot a music video with him in it. Jeffrey's not happy. He is saying, Kenneth Copeland says, the police are calling Kenneth Copeland. The police are right on him. And you will learn, and it's on recording, that Kenneth Copeland goes into the police station later that morning, so it's a very early morning hours, January 11th of 2015, and he's with Detective Thorpe. Detective Thorpe is recording this. And Kenneth Copeland says, yeah, I got your call. I was at Jeffrey Williams' house, Thug's house. Everyone knows Jeff. And I told him that the police won't talk to me. But Jeffrey said, you had nothing to do with this. You should go talk to the police. That's what Jeffrey said. Detective Thorpe asked Kenneth Copeland, this is hours after the killing. Do you have anything to do with a rental car, an Infinity rental car? Were you in an accident in an Infinity rental car? And Kenneth Copeland says, no. He's just a liar. Kenneth Copeland tells Detective Thorpe, earlier today, during the time of the killing, I was at the Green Store. The Green Store is like a grocery store. It's green in color. It's called the Green Store. It's not far from where Donovan Thomas got killed. You will learn that there's video surveillance inside and outside of the Green Store. Supposedly, Detective Thorpe, who is a qualified law enforcement officer, he's been doing this forever. I'm being told that, no, we never got the video of the Green Store to support the supposed alibi of Kenneth Copeland. No one corroborates Kenneth Copeland and where he was. You will learn that Kenneth Copeland eventually says, it's now June of 2015, gets rearrested. He doesn't want to be in jail. He speaks with the police. He's now with Detective Dennis, Detective Gaither, also City of Atlanta police officers. They're detectives with the gang unit homicide. Kenneth Copeland says, oh yeah, the night of the killing, Donovan Thomas, I wasn't involved. But I saw Jeffrey Williams. He's at the McDonald's on Cleveland Avenue. I saw him with all these other people. And then I followed him to his home. It's about 8 o'clock at night. There are videos at the McDonald's. They don't have any video. They never bother to get any video. They even try. But we have phone records. And phone records can show that they're not GPS. This is not like you're within 5 feet of this area if you call E911 or something. But it gives you range, maybe 1.5 miles, maybe more. And it tells you which tower you're hitting off of. Kenneth Copeland tells the police, I followed Jeffrey Williams' car to his house about 8 o'clock. That's not true. When you track Kenneth Copeland's phone records, he doesn't go near Jeffrey Williams. He doesn't see Jeffrey that night. He doesn't follow Jeffrey home. He doesn't go to Jeffrey's home until after 10. This is all a lie. Kenneth Copeland was told by the police, we want Thug. That's how he gets the deal. Because Kenneth Copeland was also told, you're an armed career criminal. You're going to spend 25 years in federal custody for having a gun. You're going to be dying in the state of Georgia custody because we're going to charge you with gang crime after gang crime after gang crime, but you can help yourself out. On Kenneth Copeland's word, Jeffrey Williams stands here concerning that overt act. So Jeffrey Williams rents a car in his own name to use in a homicide of his friend. Kenneth Copeland, Antonio Sledge, they're all at Jeffrey's home, and they're all scared. They're saying, Donovan Thomas and friends are going to kill us. They think we're involved. Jeffrey gives money to Antonio Sledge so he and his family can get a hotel room and not suffer a potential drive-by shooting. As Kenneth Copeland said, they're all going to be killed. Kenneth Copeland made them all supposed targets by the IO gang. Kenneth Copeland, Shannon Jackson, Demonte Kendrick, others go down to Miami shortly after the shooting. Jeffrey was performing. Jeffrey wanted them to be safe, not get hurt until people calmed down. Jeffrey then sent them back to Atlanta. Jeffrey then went on tour. Because you will learn by April of 2015, Jeffrey did his first nationwide tour. He did with a performer known as Travis Scott. In the summer of 2015, Jeffrey then toured Europe, performing there and going to fashion shows. Jeffrey Williams is not involved. On the next overt act, you will see these are the people. This is overt act number 17 and 18 and 19 and 20. And this is charging murder and then attempted murder for shooting the second person who was shot that night and then the third that night, and then participation in criminal street gang activity. You may notice that the overt act doesn't even include Jeffrey. No one charges Jeffrey with murder, but here we are. The next overt act is April 26th, 2015. Jeffrey is touring. He is performing. He's in Louisiana. Lil Wayne, his idol, Jeffrey idolizes him, came out against Jeffrey, called him gay. Jeffrey did a promotional social media release where there's people with guns on either side of him, and Jeffrey saying, come to this concert, we'll see what happens, come on to the concert. Jeffrey was told to do that video and release by his management team. Because when Lil Wayne says don't listen to his music, that impacts him. Lil Wayne is bigger than Jeffrey Williams at that time. So this creates interest in fans. You will learn that this is part of being involved in hip hop or rap. There's all these battles going across social media. It generates interest, much like the NFL have rivalries with the Saints and the Falcons, and how much they hate each other. It is generating advertising. It's branding. Jeffrey is in Louisiana. Here in Atlanta, Lil Wayne has a tour bus, and he performs concert, and his tour bus was fired upon and struck. There's zero evidence Jeffrey's involved. Zero. Jeffrey's not even named. Now you're going to hear about it. Because Jeffrey's the king slime. He just controls everybody, even without any evidence to support it. Because that's the theory of the prosecution and the police who have targeted Jeffrey Williams. The next overt act is July 7th of 2015. Jeffrey is at Perimeter Mall, that's located in DeKalb County. And he's in the mall and he's buying 50 to 100 sneakers, brand new sneakers. And he's going to do a video shoot. And he's going back to Cleveland Avenue where the children don't have proper footwear. He's going to give out these sneakers and allow the children to be in a video shoot. So that's why he's at the Perimeter Mall. He's there with friends of his. And he's on a Segway scooter. It's like an electric skateboard. And the mall security comes over and tells Jeffrey and his friends, and you'll see video of this, they have to leave the mall. You can't have a Segway inside the mall. But Jeffrey leaves the mall. But the security officers follow him. They follow Jeffrey and his friends to Jeffrey's Jaguar. And the security won't let Jeffrey leave. Won't let his friends leave. They're standing around the Jaguar. They can't shut the door to the Jaguar. They can't pull out. And they tell Jeffrey, you're waiting here. You're going to have to be here. They tell Jeffrey's friend. We're going to get a criminal trespass warrant for you. Allegedly, someone inside the car said, I'm going to go home, get a gun, and come back and shoot you in the face. That's the allegation. The security guards then supposedly step back, the car drives away. Nobody is shot. There's no incident. Jeffrey gets arrested on that. DeKalb County prosecutors dismissed that case. It was not even indicted. Now you have it here before you. The next overt act dealing with crime is September 24th of 2017. Jeffrey's with Sergio Kitchens. Sergio Kitchens is an unbelievably well-known musical performer. His performing name is Gunna. And he and Jeffrey both are under YSL. That's Jeffrey's record label. They signed Sergio Kitchens for Gunna. There's a third person in that car. His name is Cedric Jones. The car is going to Peachtree DeKalb Airport. It gets pulled over for a window tint violation. The officer gets Jeffrey out of the car in handcuffs, Sergio Kitchens out of the car in handcuffs, Cedric Jones out of the car. Police search the car. They find in the car supposed methamphetamine, supposed hydrocodone, marijuana, and a stolen firearm. Jeffrey was on his way to perform at the Jimmy Fallon show that night. Cedric Jones said, I packed that stuff. Somehow that is now influencing and perpetuating and moving this supposed YSL conspiracy. That's the overt act. The next one. May 18, 2018. Jeffrey is driving a Porsche. Sergio Kitchens is in the front passenger seat. Supposedly Jeffrey is speeding. Supposedly there's another car that's in tandem speeding. Both cars get pulled over by police. There's videos. Jeffrey and Mr. Kitchens are asked to get out of the car. They're asked if there are guns in the car. They say yes. There are guns in the car. Police get them out of the car. Any drugs in the car? No. Police have Jeffrey and Mr. Kitchens on the side of the road. Go through Jeffrey's car. They run the guns. The guns are lawful. The police put the guns in the trunk of the car. Tell Jeffrey and Mr. Kitchens, you're free to go. Give Jeffrey a speeding ticket. Jeffrey's driving away. He stops the police. Inquires about what's going to happen with the other gentleman in the other car. Police say, no. You're going to jail. They have in the car weapons, 30-round magazine. It's not in Jeffrey's car. There's going to be zero evidence that Jeffrey put those guns in the car, knew those guns were in the car, had anything to do with them. That's your overt act. The next crime is an overt act. This is the date of Jeffrey's arrest. So it's broken up into several overt acts. So I grouped them. This is overt act 183, 184, 185, 186, 187, and 188. And what you'll see here is they're just different items. So Jeffrey's home is surrounded on March 9th of 2020 by law enforcement. Law enforcement has tremendous military power. Law enforcement takes control of the scene, the area. Jeffrey and more than a dozen people are in the house. You will learn that Jeffrey doesn't live at the house often. But other people live there all the time. They take care of the house. You don't leave a house unattended. The house has a lot of Jeffrey's awards that you'll see. And in the house, law enforcement finds a small amount of cocaine. I'm talking about a small amount of cocaine. They find codeine, lots of codeine. Codeine's cough syrup. People drink it if you get high. They're very good. Marijuana in the house. And firearms. Other people had access to this home. Other people lived at this home. You will have no evidence that Jeffrey ever touched a firearm. Those are the overt acts involving Jeffrey. And somehow that furthered this conspiracy to create territory and property and money and respect and reputation. The next series of overt acts deal with videos that are released on the internet, photographs on the internet, chats. These are not released on the internet. The chats are personal. So this is when you really know what Jeffrey's talking with people, and then conversation. So the first one is November 3rd, 2014. That is Jeffrey in the red sweatshirt. That is Mr. Copeland. That's Kenneth Copeland, Woody, in the white sweatshirt. And they're wearing different colors. And the RG is Rich Gang. That is a musical gang, a musical artist. Rich Homie Quan, a man named Brian Williams, Birdman, Jeffrey Williams. They had lifestyle that went across the world. Success. And Jeffrey is holding up his fingers. Suppose that's a YSL. That's what he's doing. He's wearing red clothing. That's the overt act. Jeffrey didn't release that. That's not his Instagram releasing it. But that's the overt act. The next one is January 3rd of 2015. That is Mr. Demekin Garlington in the red with the glasses on. That is Jeffrey, closest to us. There's money on that table. There's a double cup, styrofoam cup. It says that Jeffrey posed for a photograph. Jeffrey's not even looking at the camera. Jeffrey didn't release that on social media. He didn't post it. That is Mr. Garlington. And that's Mr. Garlington's "We Ain't Going Back and Forth." Mr. Garlington and Mr. Copeland are brothers. They consider themselves one. What happens January 3rd, 2015? It's an important thing. Shortly before New Year's, you will remember that Kenneth Copeland stole Jonathan Thomas's chain, expensive chain, his driver's license, his wallet, and his cell phone. That's Mr. Garlington saying, "We ain't going back and forth." That's the overt act. Dealing with Jeffrey Williams. Jeffrey didn't even post it. Next one is January 26, 2015. Again, this is Mr. Garlington. Now, what I'm showing you, by the way, are the overt acts from the indictment. You'll have the indictment. These are language of the indictment. And this goes to a video you will see. And it's Jeffrey. By this time, his teeth, his rotten teeth are covered with gold. He's trying to fix himself, make himself a better image. It is 16 days after Jonathan Thomas is killed. And it says, Jeffrey saying, so an A lies to the kids, lies to their mamas, lied to their brothers and sisters, then get right in the courtroom and tell the God's honest truth. Don't get it. Y'all ends need to be effing killed, bro, from me and YSL. It's exactly what Jeffrey's been thinking all the time. The criminal justice system is out of control. But what do you learn here? First of all, Mr. Garlington released that on his Instagram, not Jeffrey. Second of all, when was the video made by Jeffrey? Was it made, as the state told you, 16 days after Jonathan Thomas's killing, and therefore somehow it's relevant to this murder? You will learn that that video was in existence before Jonathan Thomas was ever killed. That is a repost. That is a repost by Mr. Garlington. The prosecutors, the police, are misrepresenting the evidence. What does happen on January 26, 2015, though? Is Jonathan Thomas's close associate. He's also a very well-known musical performer. His name is Mr. Bennett. He goes by YFN Lucci. His mother's house. He's shot at. His mother, Mr. Bennett's mother, YFN Lucci's mother, is shot, as well as her boyfriend. That's what happens on January 26, 2015. This is released by Mr. Garlington. Because everybody wants to associate with Jeffrey. He's the only one who got out of that area. Everyone talks about him. You're going to see in the chats, they don't even know him. Hey, if I do this, How much will Jeffrey pay me? Hey, if I do this, will Jeffrey take me on tour? Hey, if I do this, will Jeffrey do this? Can I get Jeffrey's number? Can I come to his house? Will he buy me jewelry? They use Jeffrey. This has nothing to do with Donovan Thomas. But that's what you're being told. The next one is February 9th, 2015. Jeffrey is in a car. You'll see the video. He's singing. He's singing. And he's making signs with his hands that the prosecuting police say are gang signs. I can make gang signs. This is America. I can speak favorably to the Bloods, to the Crips, to Donald Trump, to anybody. That's the overt act, and Jeffrey didn't even release it. This is on Mr. Garlington, who Mr. Garlington wrote, "You did 30. YSL coming soon." Instead of the C for the Crips, you remove the C if you're in favor of the Bloods, and you use another letter, sometimes a B, this one you use an S. You will learn that in the YSL gang, it's now called a hybrid gang, because there's not only Bloods, there's Crips, there's anybody who wants to come, no rules. But now the experts in the Atlanta Police Department, those are the only experts, they're all the same, the Atlanta Police Department. Now it's a hybrid gang. That is the overt act. It's not written by Jeffrey, it's not released by Jeffrey, but they want you to fear music that talks about killing, drugs. It is art. If you don't like it, you don't have to listen to it. But this is America. It is art. And you will learn that rap is the most listened to music in the world. It's the number one. It is a multi-billion-dollar industry. You don't fear this, we encourage it. It generates money. It puts people to work. It's not meant for brainwashing. It's whatever the consumer chooses. It's art. It's like reading a book, looking at a painting, watching a movie, reading poetry. It's what you believe it to be. That's what we do, as opposed to Russia. They stop all communications. They censor. The next overt act is March 20, 2015. Jeffrey is with Shannon Stillwell, Diamante Kendrick, Mr. Garlington, Mr. Arnold. And they are using their hands to make signs. That's the overt act that furthers, that drives this conspiracy. That's it. Jeffrey didn't even release that photograph. Who releases it? Mr. Garland. Next. It's almost New Year's 2017. Antonio Sumlin also comes from the impossible life that Jeffrey was born into. He's with Jeffrey. There's a social media captioned "Original Slime SHI." And Jeffrey saying, "Murder Gang BIT." And holding up his fingers is YSL. until we're dead and pale. That's the overt act. That's driving this conspiracy. The next allegation is August 8th of 2019. That is Mr. Bennett. He's a very, very, very prominent musical performer, rap, gangster rap. It's August 8th, 2019. And this is Jeffrey's post. Jeffrey did post this. And he wrote, YFN, meaning Mr. Bennett, if I ain't like what you do for your mother and kids, and capitalized, I would have been kill you. That's supposed to be this rival, this leader of the YSL, the King Slime, against IF gang. And here we go. What they don't tell you, but what you will learn, is the day before, Jeffrey released an album called So Much Fun. YFN Lucy criticized that album on social media, that it's awful. And what you also will learn is that in 2016, years before, YFN Lucy, he's not as high as Jeffrey. He does not have as much fan base or interest. He doesn't make the money that Jeffrey does. So YFN Lucy does what all these rappers do. They attach to somebody bigger to promote themselves. Jeffrey did that too. He did it with Lil Wayne. He did it with others. In 2016, Mr. Bennett or YFN Lucy, he released on social media that he has been having sex with Jeffrey's fiance. So King Slime, all these years, this man saying that he sleeps with Jeffrey's fiance goes unharmed. Nothing done. This is the post that Jeffrey says, and it's a real threat. If I didn't like what you do for your mother and your kids, I would have been killed you. It doesn't sound like too much of a threat. That's the overt act. The next one is March 12th of 2020. Mr. Huey and Mr. Williams. Now, this is not social media. These are actually conversations that the prosecution subpoenaed from Google or from Instagram or from Twitter or from Facebook. You get all of Jeffrey's statements. This is very invasive. And what happened right before this, and if you look at the date, this is right before COVID hit in 2020 in America. Sergio Kitchens has a dear friend, co-worker. He is a producer, an engineer, musical engineer. So Sergio Kitchen performs, this other person turns the music, the beats, makes it right, changes lyrics, does whatever they do. This producer or engineer's name is Chandler Durham. He goes by Turbo. And Turbo's car is sold. And in that car are beats, lyrics that cannot be reproduced. They're the only copy. They're on in a hard drive in his car. The car is stolen. And it is alleged that Mr. Huey's friends or acquaintances or people that Mr. Huey knew took that car. Not that Mr. Huey did it, but that he knew who did do it, who has that property. And Jeffrey writes to him, if you don't take it back, you're gonna die. Give back your property. You will learn that no one died. You will learn that the property was never given back. That is the real leader of this feared criminal street gang. He's ignored. That's it. That's March 12, 2020. The next one is February 4, 2021. Now this again is the personal chat. Trintavia Stevens, he grew up with Jeffrey. They exchanged clothing, dirty clothing. They went hungry together. And Woonie Lee is also a up-and-coming musical artist that Jeffrey wanted to sign, but Woonie Lee went to another record label. Jeffrey supports him to encourage his career. And this is February 4th of 2021. And what the indictment did by the prosecution through the grand jury is they put this together, and this is bad. I understand when you read it.
Objection, Your argument.
Abstain, objection. Thank you. This reads, YSL rule the world, kid. 24M on an N head. Y'all just start bringing me the money. Man, y'all and stop playing with me. So when you read that, it sounds like there's a contract on someone's head. Kill him, start bringing me the money. Stop playing. That's threatening. What you will learn is what the prosecutor did was they took these checks from various days. This is over a 3-day period. This is February 4th, 2021, all the way up to February 7th of 2021. And they cut out all of the context. And what you will learn is that on February 4th of 2021, Jeffrey wrote, YSL rule the world, kid. 24M on an N's head. What happened on February 4th, 2021, that was released on social media and went around the world, is one of Jeffrey's artists that he signed, who developed, he encouraged, and who made it. This person had a supposed, maybe it's real, supposed $24 million pink diamond and had it surgically implanted into his forehead. There is a photograph next to YSL Rule the World Kid, 24M on an N's head. There's a photograph. If you click on it, it is the rapper with the surgically implanted pink diamond in his forehead. The police bury this. The prosecution buries this. I will show it to you. Now, the evidence will show, they may say, oh, it's on. There's no mistakes here. This is a big deal. This is a bill of indictment in Fulton County, Georgia in 2023.
Your argument.
That is misrepresenting. You will learn. You will see it. It has nothing to do with put a contract on someone's life. That's the evidence that's coming at you. You'll start, bring me the money. Y'all, and stop playing with me. When you read, this is a long chat. These people are struggling. Trintavia Stevens is struggling. He's sharing a home with other people. They're trying to pay rent. They're working jobs. These are hard jobs to work. They're trying to save money, trying to eat, trying to take care of their kids. And Trintavia Stevens is in the chat saying, I paid the rent last month. Jeffrey doesn't live with these people. He's just included in the chat. He's hardly on these chats. And Trintavia Stevens is complaining. And he's saying, give me the money for the rent. We got to pay the rent. I paid it last month. Everyone's supposed to put the money on the stove, in the kitchen. No, I'm doing what you said you do. We live together. And Jeffrey said, y'all start just bringing me your money. I'll pay the rent. Don't stop playing. That's the overt act. That's furthering this conspiracy. That's what they did to that man. The next overt act is May 13th of 2021. This is the chat. It's again, these are the personal conversations not supposed to be seen. These are not released on social media. It's like a wiretap. This is supposed to be between these people. And it's Mr. Martinez-Arnold, who, by the way, is a Crip. He's in YSL. Crips are blue, but that's why it's a hybrid gang. Everything moves to make it fit Jeffrey. Now it's a YSL gang that's hybrid. Martinez-Arnold, Miles Farley, Quantavious Greer, that's Jeffrey's brother. Wani Lee, you just learned about him. He's an up-and-coming rapper. Signed to another label. Jeffrey's promoting his career. It's not even signed to Jeffrey's label. Jeffrey's promoting him. Trentavious Stevens, you learned about him, wrote with Jeffrey. Antonio Sumlin and Jeffrey. And it's May 13, 2021. And Jeffrey wrote, y'all ain't beat him up or shot him yet. Y'all ends getting soft. Well, that sounds bad. But what you will learn is the conversation was about Trentavious Stevens complaining to another person who's in that chat. That other person tried to sleep with Trentavious Stevens' girlfriend. And the other person told Trentavious Stevens' girlfriend, Trentavious Stevens is cheating on you with another girl. And Trentavious Stevens and this other man are leveling each other over this chat. And they're going back and forth, and this goes on a long time. And Jeffrey, they're acting like kids. And Jeffrey wrote, y'all ain't beat him up or shot him yet. Y'all getting soft. He's talking to people that he tries to help and that he's known all his life. That is the overt act. He is totally taken to mislead you. I will present the evidence. And there's no apology accepted when they say, oh, yeah, you're out of context, we made a mistake. There's no mistake here. They built a theory. They have an agenda. This is wrong.
Objection, argument.
Next one. September 1, 2021. Mr. Mender is in the Fulton County Jail. When you're in the Fulton County Jail, not only are your jail calls, like a telephone call, recorded, but you can do things with loved ones where you can actually see them, like a FaceTime. Or I guess that's Zoom. But they're recorded. So it's about a 16-minute call, and then it breaks off. It just, you can't talk longer than that on the jail call. You got to call back and pay more money. And Mr. Mender is speaking with Mr. Huey. And the conversation starts with Mr. Huey driving in a car. You'll see this. And Mr. Mender is on his iPad or Mac or whatever device he has. And Mr. Huey meets Jeffrey Williams at a jewelry store. Jeffrey has an image. He's very, very visible. He wants to be visible. He promotes his brand. He wears gigantic jewelry all the time. His face tattoos, his tattoos on his body of the bloods, of 5 stars, of his kids' names. He has 6 children. His brothers and sisters' names. Of the struggles he's been through. Jonesboro South. And Mr. Huey goes into the jewelry store. And Jeffrey walks up. So now you see Jeffrey in the viewfinder, in the video. And he sees Mr. Mender. And Mr. Mender knows that Mr. Huey's in a jury circuit. Mr. Huey, before that's shown. And Mr. Mender says to Jeffrey, hey, I need something. And Jeffrey points to Mr. Huey. He says, speak with him, and walks away. Jeffrey's on that video audio for 31 seconds. That promotes the RICO conspiracy, that Jeffrey dares to speak with a person who's in custody and treat them well. He didn't buy anything for him. Jeffrey walked away. That's the next opening. The next one is September 4th of 2021, so you're a couple days later. And Jeffrey is with Mr. Huey. And Mr. Huey puts on his Instagram, it's not Jeffrey's post. Mr. Huey was in custody shortly before this. And he wrote, from lockdown to a jet, Slack is. Said Jeffrey poses for the photograph. Jeffrey's not even looking at the photographer. Jeffrey doesn't post this. That somehow promotes this conspiracy. This violent, territorial, money gathering, reputation building, fear producing conspiracy. That's the overt act. The next overt act is November 14, 2021. It's again Mr. Huey, Mr. Williams. And Mr. Huey writes, and now this again, this is a private conversation. This is not social media. And Mr. Huey wrote, you know I'm ready to handle the business and go sit down if I got to about any one of y'all on my mama. What the prosecution leaves out is the next line by Mr. Huey, where Mr. Huey writes, but I don't even know if this is true enough. And Jeffrey writes, have you spoken with Gunnar or Sergio Kitchens? And Mr. Huey responds, yes. And what they're talking about, if you remember, right before COVID of 2020, Jeffrey is telling Mr. Huey, get those people to return those beats. Those beats are not ever coming back. They're lost. That is proprietary information. That is valuable art. They're gone.
Mr. Steele, I hate to interrupt you, but you might be time. How much longer do you have?
An hour?
We're going to take a couple of breaks. 10 minutes, okay? All right.
All right, people, y'all, I'm going to wrap it up there. It's been a long day. I thank y'all for being on the stream. We'll be back tomorrow morning at the same 8:15, 8:30-ish, something like that. Thank y'all. Have a good evening, and we'll see what happens tomorrow. Bye-bye.